Despite the specific direction, the matter has not appeared in the list today.
File is not here. Let me click on 20th. 2020.
Milord,
It will come on 20.
may I have your
What has happened? That the staffs has changed. They have see all the files. So they are searching out all the files. It will come on Tuesday on 20th under the urgent motion.
Milord, may I have your lordship's leave to mention one notice, Milord. Yesterday I was appearing before lordship without authority, Milord, and lordship could not pass the order. Milord, I have procured everything, Milord. Otherwise, Milord, unless it is listed.
What you have procured? What you have procured?
Procured the letter of authority of all other petitioners, and they are ready to appear before your lordship on the date fixed, Milord. Kindly let it appear.
I don't want them to appear, but let you
Yes,
come with because they will appear, then all the advocates has to go out.
No. No. If your lordship observed at one point of time that otherwise all the authorities I have taken, Milord. Kindly let it appear. Election is being delayed, Milord. A new special officer has to be appointed. On Monday, Milord, it will.
21st.
May I permit it to mention, my lord?
First urgent motion query.
May I permit it to mention, my lord?
Please.
In the context of appointment on compassionate ground, where calculating the income of the family, medical allowance is to be taken into account or not. Division bench has held that it is not to be taken into account. The court had adjourned the matter to take instructions on the issue. But I am praying this matter may appear on Thursday next.
Already my dad. Come the first week of February.
May it appear in the first week of February itself, my lord.
4th February. 4th February.
May I have your lordship, item number 425 today's list. I had mentioned this matter in November. It is a personal matter relating to a family member who's 86 years of age. There was an urgency and your lordship had directed the matter to appear on 3rd of December. It is at 425.
What is the relief you have prayed for?
The relief, my lord, she is a person who is in a vegetative state. She is completely immobilized, vegetative state. It is a mental health care act. I'm seeking certain directions upon in respect of her assets, my lord. That's all. It's a personal matter, my lord. I have nothing else to say, my lord. Your lordship had directed this matter to appear on 3rd.
5th February.
If your lordship will kindly make it as an urgent motion.
5th February urgent motion.
I'm very.
May I have your lordship's
mentioning item number 5, which I am praying for upgradation. On the ground, my lord, the passport has not been renewed. But this matter was moved before the Honorable Vacation Bench. The Vacation Bench directed me to approach the London ACGM to obtain the NOC. But we had prayed before the London ACGM to permit me to appear virtually because I am in Kuwait. My passport will be expiring on 12th. Now, my lord, this Honorable Court during the vacation had directed the matter to appear immediately after reopening of the court.
Oh.
In Justice Iron My Church. The matter to appear before this court.
By this court, in this court?
Yes, my lord. Immediately. But the matter was listed on the 13th. Now, the difficulty is, my lord, I have got only 7 days time, my lord. In the meantime, if I could be arrested by Kuwait, my lord.
Why?
My lord, my passport has expired, my lord. Only 7 days grace period has been given to me.
Passport,
what is
the date of the visa?
My lord, that is on 20th, my lord.
20th of
January, my lord.
So
the difficulty is, my lord, if my passport has expired on the 12th.
Even though you are having the criminal case.
Yes, my lord.
Correct.
Valid ground has been.
You have filed an application before the magistrate.
Yes, to allow me on virtual mode.
So what virtual mode?
To appear virtually to obtain, because I'm in Kuwait.
What is the necessity of appearing of the person for getting the no objection certificate from
the that is the observation of the London ACGM that he did not appear before me physically. That is why my application is rejected.
When it was rejected?
My lord, on the 9th.
9th.
Yes, my lord. We have also prepared the supplement. Yes, my lord. The supplementary affidavit has been affirmed, my lord. If your lordship kindly fix up any date.
Why here? The revisional application. It will go to the revision application if you are challenging the order of the magistrate.
Unless until this is disposed of, that will be conducting at reserve Calcutta, my lord. Any day, my lord.
I don't know how. Okay, let it be fixed. 20th कितना matter है देखो. 20 को देखो, 20 जनवरी कितना मैटर है। Urgent motion. Already there are several matters.
But kindly, my lord.
Okay, 20 तारीख को रखो, देखेंगे।
Grateful, my lord. Grateful.
May I have your lordship's kind leave to mention a matter? Your lordship.
Tomorrow. The diary with the matter to be appeared under the meeting ballot, but it is not appearing. That about on 5th of January.
When the entry mode is going to be expire?
Tomorrow.
Tomorrow. इसको क्यों नहीं आया कल का उसमें?
I handed over the sleep while the diary with the
No file. If it is not file, you mention. I told you, if there is no file, mention whatever the cause mention is there. You mention it. No file not here. Tomorrow to be mentioned for extension of entry mode.
at 2 p.m.
Tomorrow you come. I will take the matter.
May I have your lordship's kind leave to mention a matter? Lordship, item number
Certain,
354.
uncertain. It is up to the bar. The court cannot anticipate what is the uncertain. If you are going with the bar, you go with the bar. If you are going with your clients, then you come with the court. It is. If you want to go by the bar, go by the bar's resolution. It is your choice. The court is. If you want any court from any order from the court, you come to the court. Then the court cannot fix the date as per your convenience. Yes, bar will take the resolution. That's why the matter has to be taken today.
It will appear tomorrow.
Yes, I already dictated.
May I have your lordship's kind leave to mention item number 324.
Application,
हाँ,
I have already served on the other side.
हाँ.
To be appear
Restoration
in the
22nd को
another
रखो and
application,
under the heading application for restoration. 21st of restoration.
restoration.
Any restoration applications are there? You give restoration application.
Lordship, may I have your
Just a
lordship's
minute.
kind leave to. Sorry, very sorry.
You give all. If any restoration applications are there, to give to my court officer. All these restoration application may fix on 22nd. This all may be fixed on 22nd. Under the heading application for restoration. Yes.
Yes, sir. May I?
Which matter? 3 p.m. Okay.
Last question I have mentioned. The last accepted, file has not been.
File has not yet reached. What can be done? What you want? If the file is not there, what can be done by my court officers?
Action has not been given.
Can you take that?
May I
Just
have
a
your
minute.
lordship's kind leave?
You do that. You fix the matter on 6th of February under the urgent measure. It is a criminal division application.
May I have your lordship's kind leave to mention item number 324? Your lordship, the
I will
urgency
take
is-
the online application later. First the physical persons
Okay,
who are
okay,
present. Let me
okay,
take.
okay, my lord.
has passed an order maintenance part that is not complaint. But I am notified the judgment of this honorable court that ballot so that the order complied with that get some amount.
9th February.
May I have your lordship's kind,
9th February.
may I have your lordship's kind leave for inclusion of on hearing matter?
Hearing.
Yes.
Inclusion on hearing any date. may-
Lord, may I be permitted to mention one for
Under the heading hearing.
Lord, may I be
May I
permitted?
permitted to mention one matter 529 for upgradation. Urgency is this one. Agreement was executed between the petitioner and the railway authority, and I am on the basis of the agreement. I am running my restaurant and waiting room at Jagadish Chandra railway station at Asansol. agreement was expired on 11th January 2026, and there is a clause for extension of the agreement. On the basis of the same, I made a representation before the authority, but they did not take any step. I filed a petition, but without they knowing fully well, they came to my site, and on 13th January they evicted me from the site, and my all the materials are in, if on there is all material, but I do not, they did not take any step. Kindly fix the matter any day.
So what you pray, but once you have been evicted, what the court will do now? You
Lordship,
go for the damage.
all my materials are there.
So
all
what
my
you
ma-
prayed for in the writ application?
Lordship, kindly actually at the time extension of my agreement.
Extension of agreement, they are not extended.
They-
You have been evicted from the premises.
All materials are there, Lordship.
So what you prayed for?
Lordship, they are, I take back my materials.
Have you made a representation for giving back your
And on the
materials?
basis of
So what is the urgency?
urgency, Lordship, kindly take this matter any day thereafter.
16th February.
Lordship, may I be permitted to mention a matter? Lordship, my petitioner's bank account, current bank account has been wrongfully closed on a voluntary ground, Your Lordship. A good amount of money has also been put to this thing. Has been put in place. Your Lordship.
Take 17th February.
My lord, may I be permitted? My lord, may I be permitted?
I noticed that the all this gets a election.
Very good. 27 is a nomination. 22nd.
May I
22nd
be permitted?
January, urgent motion. Yes.
May I be permitted?
Of this matter because this pertains to election.
Yes.
This pertains to
It is listed here. Which number?
403.
Give.
403.
Record and note. 403.
Yes, madam. Nothing about.
Learned counsel for the though the matter is listed at serial number 43 students list. Full stop. Learned counsel for the petitioner mention the matter and submit that the matter is connected with the electricity connection. Accordingly, WPA number 25235 of 2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
My lord, may I be permitted to mention, my lord, for inclusion, motion, my lord.
may I?
My
May I be permitted, my lord, motion, my lord, inclusion, motion, my lord.
Give inclusion.
My lord,
Yes.
may I have your kind leave?
Inclusion of the motion. Give
Motion.
the call. Give.
Yes. May I be permitted, beautiful one.
Give inclusion. Give that all inclusion matter. Give the copy.
Hearing
matter, my lord.
May I?
My lord, may I permitted
may I
to
permit-
mention some matters for upgradation, my lord?
Yes. Why?
My lord, as per your lordship's order, the concerned authority filed a report. We are satisfied. We want to dispose of the matters. As per your lordship's order, the concerned authority filed a report, and we are satisfied by the report. We want to dispose of these matters, my lord.
उसको एक काम करो.
There are 9 matters, my lord.
9 matters.
My lord, it already runs.
All 9 matters reports are there.
My
Do
lord,
you want to
my
assist
lord,
them?
my lord,
Only
it,
single line order will be enough.
my lord, it
Then let's go to-
already runs today's list.
28 January को रखो.
My lord.
Urgent motion.
My lord, may I have your kind leave for
Hello.
filing this writ petition? The urgency is that this writ petition is pertaining to shifting the polling station from my Rayati land.
Huh?
Shifting the polling station from my Rayati land. I have filed a title suit. I have owned. Then they have filed several appeals. All these appeals are dismissed. Now only a Section 47 application is there. No stay is there. The Election Commission has fixed the scheduled election polling station in last previous all election in my Rayati land. I just want to shift, not to fix that polling station on that land. And in previous year, in 2018, they fixed the polling station in some other polling station.
It was not the polling station.
No, in last election it was there, but
Then-
in 2018,
What
previously
last
it was
election it was there.
it was there, but my title suit, my appeal was
Maybe title suit,
that
the-
time appeal. that
polling
time-
day, polling person shall
that-
not take your
that
land.
No,
Only
my
one
lord,
day
what
it will
happened
be
that
used.
is
Yes.
SIR, my lord, SIR is there, SIR will be SIR will
Maybe,
be
sir,
in
polling,
future.
polling day is only one, and the polling giving the describe notified as the polling station will not declare the title, sir. One day you have to bear for the administration. What is the urgency?
The trial court records, your lordship has pleased to call for the trial court records.
Criminal matter.
Criminal matter.
It was fixed on 6th, sir. It is not listed in the criminal list.
At 2 p.m. my lord, if your lordship may kindly see, sir.
Give you the order.
My lord,
I mention a matter. 2 p.m. 6 January. देखो फरवरी में कौन सा डेट है देखो 2 PM का देखो फरवरी में देखो 2 PM कब खाली है
I ছোট কথা বলছি সেটা তো উন্নয়ন নারায়ণ জিনিস তাই বোরিং মাঠে অ্যাপ্লিকেশন
6 February.
6 February.
6 February under the heading especially fixed matter.
Your lord-
6 February inform the other side.
Your lordship, may I be permitted to mention one matter? Your lordship,
Is the senior citizen lordship. Since 21 it is pending lordship.
So what is the urgency now after 4 years? If it is pending since 2021.
By the authority concerned regarding the submission of the successor certificate.
Ah.
It's submitted that certificate. In spite of that, they are not releasing the money which was awarded long ago. Lordship.
Who has awarded the money?
Union of India, under the Union of India, it is the CBDT lordship.
What is the section that whether the deceased was a government servant?
No,
Ah.
this is not coordination.
Ah.
What notification was done by the authority concerned regarding the inflation of the tax and recovery of the hundi money.
Ah.
If anybody will give the information regarding that, he will be awarded. The uncle of the petitioner informed that money was recovered, ornaments were recovered. In spite of that, they are not giving. Now the date of the uncle of the petitioner, authority concerned told that the submit the successor certificate already submitted. In spite of that, they are not releasing, they are not giving any chance.
11 February करो.
Your lordship, may I mention a matter? Your lordship, this matter falls under the Societies Registration Act. Herein the petitioners are the employees under the university registered under the Society Registration Act. There hasn't been paid their remuneration ever since last 36 months, even though there has been sufficient flow of income from the students, student tuition fee, your lordship, due to rampant corruption happening throughout the university.
Go to the anti-corruption unit and file a complaint.
Your
What the
lordship, there
report will
has
do?
been several representation provided to several competent authorities. The representation has not taken cognizance and no relief has been granted till date. It has.
your lordship,
17th February.
your lordship, may I be permitted?
Huh? Ah. Correct. What is the urgency? Yes.
Your lordship, may I be permitted to mention
Madam,
one matter?
Okay, no problem.
Lordship,
It will come on the regular matter. Yes.
Madam, my lord, for
My lord,
Then it will come.
my lord, may I permit to mention one matter, my lord? Urgent. My lord,
All mention?
my lord, may I permit to mention one matter, my lord, urgent matter, my lord?
Yes.
This is a short matter, my lord. I was, my lord, served as a genuine contractor, government contractor for state government, against the state government work, my lord. My husband is, my lord, cancer patient, my lord. Kindly take it up, my lord, any date, my lord, for
So what is the
recovery of my-
urgency? What is the urgency? What is the matter about?
Urgency that I need, my lord, money because, my lord, my bank loan and other things, my lord, is going on, my lord. I have already done work, my lord, completion certificate before the state government, my lord.
It's not
I'll
urgency.
take it.
Yes. Yes, Mr. Banerjee.
Kindly take
May I
it
have your
up any
lordship
day.
kind leave to mention this matter, your lordship, item number 324.
Yes.
The urgency is that the petitioner is running a hotel, but his account has been kept on hold. We are not able to operate our hotel. We are not able to pay the salaries of our staffs and statutory auditors. If your lordship takes it up any day, because it's a running business which has come to an hold totally on the basis of a complaint made which does not
the
feature
bank
my
has
name.
kept on hold or as per the order of
Yes,
the
sir.
authority?
No, the bank has kept on hold pursuant to a communication of Colonel PS, but the FIR on the basis of which it has been kept on hold, my name does not feature at all. That annexure, that FIR is part of my writ petition.
Where is your,
Your lordship will take it up any day. Your lordship, item number 324, your lordship. Junior is there.
February.
It's
Fifth
fifth
February.
February.
May I have kindly
mention, my lord,
mention
item
one
number
matter,
135 and 136. My lords, item
Yes,
number
Mr. Bag.
May I have Milord's kind leave to mention item 434? Milord, it's a tender matter. We have participated in the tender, Milord. We have been delisted because, Milord, there's a circular which is under challenge before your lordship by us in this petition, Milord, which says that any pending litigation you cannot against this company, you cannot participate in any tender process, which is absolutely bad because it infringes our fundamental right to file litigation. Milord, there's a litigation, we have to give a declaration. If there's a litigation, you can't participate in the tender process. That's what we have challenged. We have participated in this, but we are delisted. The tender is not complete yet. So, Milord, I'm only praying there's an urgency because once, Milord, the tender process is completed, then we'll be, Milord, thrown out.
When the tender will be finalized, any date is fixed, final date?
Milord, we have been delisted a couple of days back, Milord, 2 days back. It's item 434, Milord. Any day that suits your lordship, Milord.
Come on, 28.
28, I'm very deeply
Milord,
obliged, Milord. We'll come back.
Milords,
Very
Milord,
deeply.
kindly allow me for kindly allow me for mentioning, my lord. I am waiting.
Milord, we have handed over the slip, Milord. We've handed
My
over the
lords,
slip.
item
Very
number
deeply.
135 and 136, my lords.
Yes.
My lords, item 135 and 136 is challenge to the wires of the Revocation of Incentives Act, my lord. Your lordship placed the matters on 27th and 29th of January at 3 p.m. My lords, I'm requesting these matters be also tagged with those matters.
Item number?
135 and 136.
Recorded order. As per the 135 and 136.
135 and 136, my lords, yes.
135 and 136, huh? Learned counsel for the petition, though the matter is listed as item number 135 and 136, also counsel for the petition submit that the connected, the similar matters are fixed on
27th January and 29th January at 3 p.m.
27 January and 29 January at 3 p.m. Accordingly, place for fixing the matter on 27 January 2026. As per the submission made by the counsel for the petitioner, let the matter appear on 27th January at 3 p.m.
My lord, despite your lordship's order, my lord, one matter has not been listed, my lord.
Yes.
My lord, WP number 28723. Today, my lord, two matters has been listed, item number 40 and 41, my lord. That is a specific order. Let the matter be appear on January 15, 2026. Another same heading.
January.
Junior is, my lord, the three matters, my lord, remember is the case of blocking of new challenge.
Yes.
I can.
Which matter you are not telling?
Well, the matter WPA number 28723.
I don't know. I will not go by the WP number. What's the serial number?
Serial number 40 and 41. Two matter has been listed. One matter has been left out. Despite your lordship's order, the matter has been left out. My junior handing over the slip, matter.
So what do you want?
My one, this matter may be also listed along with the two matters in any date, Malad. It's the urgency there, blocking of each challenge case, Malad.
41, 42. 41, 42.
40 and 41.
So then let you see what is happening in 40 and 41. Then that will be automatically disposed of.
Yes. Malad, I mentioned Malad one matter regarding Malad regarding Malad. I have mentioned my 7 and 6.
Not this.
Malad, I beg to
Who is senior?
Malad,
you are not cutsy.
Malad, item number 552 of this. I am a contractor, contractor, alias, mental third. My renewal has been turned down because of my contract has been cancelled. Subsequently, Malad, we prepared arbitration property, our resolution granted in our favor. Now, my lord, in spite of that, my lord, my renewal has been turned down in the 31st December 2020. Now, my lord, what I am not eligible for any contract. My livelihood is fixed.
What is cancelled? Your registration is cancelled.
Renewal is not cancelled.
Renewal has not been given. Okay.
It was arbitration, my lord, in my favor. I
Ah.
have been preferred. Departmental arbiter appointed, my lord, give it.
So give the award amount to the authority. They will give the extension. That's why the Calcutta that I am telling. Award amount to give to the responding authorities. They will extend your contract. देखो 12th February को रखो.
My lord, my simple
I have also challenged the Revocation of Incentive Scheme Act because I have also invested thousands of crores after getting the incentives. Now everything sought to be taken away retrospectively. Lordship has fixed the other batch of matters which have been filed on 27th and 29th January. Another matter was mentioned. If Lordship is pleased to list my matter along with.
इसको ले लो 27th को 3 PM में, जब भी उससे पहले ऑर्डर किया था ना, उससे पहले को भी 27th at 3 PM.
My lord, my simple prayer is for correction of order.
Huh?
My simple prayer is correction. I have noticed.
Correction of the order.
Yes.
उसको Tuesday रखिए for correction under the heading to be mentioned for correction.
My lord.
Tuesday.
My lord, your items pertain to premature release.
Ah.
The appellant is in 30 years in incarceration and the earlier bench had fixed this matter. So this is the urgency. Kindly fix this matter. Two matters, your lordship. Item.
How many years you are in custody?
30, more than 30 years.
What is the conviction?
Conviction is under 302.
Life. So whether you matter has been considered by the remission commission committee?
Yes, by SSRB. The previous bench has fixed the matter and directed the state to file a report pertaining to that. Thereafter, the determination changed.
उसको रखो 16 February को रखो.
My lord, with your indulgence, my lord, this is a bank freeze matter and the Gov of Investigation. They have frozen the bank account, which is a salary account, my lord. In July 2025, from then, even the charge sheet has been submitted, but still the account has not
So
been.
go and make an application before the magistrate.
We maintain an application before the magistrate, and that has been rejected.
So go to the revisional application, file a revision application challenging the order of the magistrate.
But the specific memo that was submitted by the police was for only 4 lakh rupees. The entire bank account has been freezed by SBI. So that is wrongful. And for a long period of such long period of time, it is a settled position.
Correct. That is correct. But it is now this criminal court is in session. So criminal court can pass an order for release.
Filed in this before your bench, my lord, kindly grant the relief, my lord.
How this court, once the criminal case is pending and you have filed an application before the criminal court, what order has been passed by the criminal court?
Because the investigation is ongoing, we are not inclined to defreeze the account. That is one line.
So you challenge that order in the revision application. Yes.
Lordship, petitioner is the claimant of LIC policy. After some policy has been matured, they invest in plowback scheme. But the after incorporation of a policy, that policy has not been forwarded to me. Several occasions I have repeatedly made a representation. It is my basic right to get the policy and all details. They are not. There is some kind of corruption, that is going on. I have
18 February.
Your Lordship,
18 February, urgent motion.
To mention a very extreme urgent matter, my lord. Petitioner is a registered license holder with the railways and in that capacity has participated in a tender and emerged as the highest bidder. Accordingly, a letter of acceptance was also issued in my favor. Now, my lord, without intimating me and without cancelling the earlier tender, they have floated a fresh tender. Now, that was made a subject matter of challenge before this honorable court. My lord, I have preferred this application under essential services before Group 7. There was an interim order was also passed staying that particular tender because it is in contravention to Section 5 of the Indian Contracts Act. Once it is accepted and without earlier communication, it cannot be rejected. So, my lord, interim order was till today. For want of determination, my lord, the matter was released today, right now. I am mentioning this matter, my lord. If your lordship does not intervene, they will file again, give effect to that tender, and my writ petition will become infructuous.
Where is the order of the extension of the interim order?
And this is your lordship to take this matter tomorrow, my lord. I will intimate. I have served copies upon all. Today was the matter which was listed, and interim order is till today.
Kindly take it tomorrow, my lord.
Where is the interim order?
Lordship, the last paragraph, second page.
In the meantime, responsibility restrained from taking any steps to float any tender.
Till 15th. Today is 15th. And
Yes.
today the matter was released.
Correct.
Lordship has directed to place this matter before your lordship on urgent basis. Let it appear, my lord, tomorrow. I will serve notice upon all.
इसको tomorrow कर देना, urgent में छूटना नहीं है. Tomorrow urgent motion, no, tomorrow has to be mentioned with.
Your Lordship, may I be permitted to mention one matter, Your Lordship? The interim order expires today. I mentioned this matter the day before yesterday. Your Lordship was pleased to direct the matter to appear in yesterday's list, but the file is not here. Your Lordship, let the matter appear Monday.
Where is the interim order?
Your Lordship, I do not have a physical copy.
Interim order is till today.
Till today, Your Lordship.
Now, if it will appear on Monday, what will happen to the interim order? Why?
Your Lordship,
why
the file is not here.
Why?
They searched for it.
Give the
This is the
case
mention-
number.
this-
You are not having the copy of the order. Where is the stay order?
The interim order, I have.
Take the copy of the order. Yes.
This is of a date for hearing, my lord. This is a matter where petitioners' protection of antiques was seized, my lord, beyond the sanction of law and beyond jurisdiction. My lord, on the last occasion, I had mentioned before your lordship, my lord, was pleased to grade the matter to be listed on 16th of December as urgent motion, my lord. So whatever reason it could have come up. I'm praying, my lord, kindly fixes a date, my lord, for hearing. Otherwise, my lord, my collection of antiques, my lord, will be stopped, my lord.
12 फरवरी को रखो अर्जेंट मोशन में. ये लो तो. The division bench order.
Your Lordship, this matter was appearing before Your Lordship, and Your Lordship was pleased to decline the interim order. Then an appeal was preferred before the division bench. The division bench was pleased to extend the interim order till 15th of January, and with a liberty to file.
Which court extended the interim order? This court.
Interim order was
Where is the interim
declined.
order?
Interim order was declined.
Continue till 15 January.
Yes, Your Lordship.
Until the order or until further order, whichever is early. In the meantime, applicant will liberty to file appropriate application before the learned single judge for further. You filed an application for.
Yes, Your Lordship, on 6th
When
of
you
January. 6th of January.
6th of January.
Lordship.
Give this application number. Let it be application. May appear tomorrow. Give the application number.
Your Lordship, tomorrow, Your Lordship, kindly to make it Monday. Tomorrow, my son's admission is there. I have to be there.
Give the let it be fixed on Monday under the heading to be mentioned for extension.
My lord,
Grateful, Your Lordship.
my lord, I mentioned.
Grateful.
Yes, yes.
Appearing under the wrong heading. I have already mentioned it is coming under the heading new motion, whereas it should be coming under the heading hearing. I'm humbly praying to.
उसको hearing में list में रख दो. Fix under the heading hearing.
My lord.
I be permitted to mention, Your Lordship?
Yes, Mr. Madura.
Item 498 of today's list, my lord. I was humbly praying because of the urgency in the matter which I'll indicate. Let it come up under as an urgent motion any day in February. I know your lordship's list is heavy. Any day, my lord, in February. 498. Mr. My lord is a senior citizen in medical.
498, 498, 12th February.
My lord, I mentioned the
February urgent motion.
My lord, I mentioned the matter, my lord, that is fixed on 20th. At that date, I will be at the hospital, my lord.
Send any junior, I will adjourn the matter.
May I be permitted to mention the matter is listed for upgradation. The matter is listed in today's cause list as item number 400. I'm mentioning upon notice to the other side.
What is the urgency?
Your Lordship, the urgency is the petitioner is the biological father and he is seeking for the custody of his minor child.
Where is the minor child?
The minor child is with the mother, but Your Lordship, the mother is on bail and the entire family left the locality with the child without any intimation to the petitioner, Your Lordship.
So why you not file the application under the Guardianship Act before the district judge?
Lordship, the accused, she is a, the petitioner was already in a premeditated criminal racket. The marriage, she's continuously marrying, Your Lordship.
And the child is with the mother?
Yes, Your Lordship.
What is the age of the child?
4 years and 2 months, Your Lordship. Kindly, Your Lordship.
Child or boy? Male child?
That male child, your lordship.
Male child,
Lordship. Kindly, lordship.
17th February.
Great, your lordship.
May I get permission?
Yes, yes.
May I be permitted to mention for urgent motion, your lordship, in the trial court, your lordship, the petitioner had challenged the Aadhaar details of one of the private respondents, and the UIDAI was called for producing the documents of the person, but they have submitted on oath that such permission has to be given by the High Court, your lordship. Hence, they had filed this writ petition, and the urgency is that the trial court had given us 12 weeks for obtaining such permission, your lordship, and if it's not,
So what you are praying for here?
lordship, the permission to be granted to the UIDAI so that they can produce the.
The trial court has already granted.
The lordship has granted time for obtaining permission from the High Court, your lordship.
16th February.
Milord, may I get permission to seek for a leave to file and for extremely urgent hearing, Milord?
Huh?
Milord, may I get permission to seek for a leave to file and Milord for extremely urgent hearing, Milord?
Urgency.
Urgency is that I am a salaried person, but without assigning any reason, the respondent bank authority, being State Bank of India, freezed my entire bank account.
Good.
Entire bank account. I make several representations.
Will be deposited. You will get the amount in a bulk.
Milord, I made several representations by stating that please assign us the reason.
It was freezed.
It was freezed, Milord, 3 months.
3 months. So what you have done within 3 months?
We made several representations.
You file it, then registered it.
Milord, it has been really hardship for my
That's
the family, Milord.
First, you go to the go file, get the number and mention.
The two financial institutions are involved in this.
Yes.
Two financial institutions are involved in this petition. Lordship, the one financial institution is not paying the money. That's why we have approached the RBI to take appropriate action. As per to the RBI circular, master circular, Lordship, the RBI is not taking action. The coordinate bench of this court has already asked for a report from the RBI. The report has been filed. The exception to the report has also already been exchanged.
Whether you are declared fraud.
Lordship, not the money is not been. They are not paying the money. Not the other other matters. Not a fraud case.
So why they are not? Who is not paying the money?
Another financial institution for which the RBI needs to take action as per the master.
Okay.
We cannot directly approach because both.
So what do you want?
I need already matter is ready for hearing, Lordship. Any day, Lordship.
Affidavits completed.
The report has been filed. The exception to report has already been
filed. February में कोई डेट देखो hearing का खाली कौन सा है? 2 बजे का खाली कौन सा है फरवरी में? Fourth February at 2 p.m. as a specific fix. 24th February. Inform the other side.
Extreme urgent matter. This matter is pending before this honorable court, my lord, since March month. I'm a senior citizen, my lord.
But there are matter pending since 2006 also.
Well, I have done the entire tender of. I'm 70 years of age, my lord. My only source of income is my only source.
What?
Of income. The tender of my.
You're total sure that the tender will get to you.
My lord, the inter work was done, my lord. But in spite of my meeting several representatives before the authority, my
But release of payment.
Release of payment, my
Go to the money.
only.
It is admitted claim.
Definitely.
They have given the completion certificate. They have released any amount.
Part amount.
Part amount they have released.
Any rate, my lord, contrary to law.
19th February.
My lord,
Lordship, may we permit to mention this matter?
Application for inclusion in the list.
Lordship, may we permit to mention
My
this
lord, may
matter?
I be allowed to mention?
21 तारीख को रखो under the heading application for restoration.
May,
हाँ.
my lord, may I be allowed to mention?
All are urgent. Yes, tell me.
Well, item number 505 of today's date.
505.
This is regarding to Bangladeshi immigrants who managed to procure fake documents. On basis of that, they managed to record also their names in the recently published draft SIR. One of the immigrants, private respondent, has also managed to record 2 voter ID cards in the recently published draft SIR. Now they are also facing a criminal charge against my client, lordship. That is a petitioner, lordship, whose next date is fixed on 20th January, lordship.
Where?
Because the Lanet court, in Barakpur court, lordship. So, lordship, if a humble prayer to lordship may be fixed any date before.
So what do you want here? What is the prayer before this court in the writ petition?
To direct for investigation, lordship.
It's already investigation. The trial is going on.
Investigation, no investigation conducted, lordship. Several representatives.
So what is the stage of the criminal case?
That is the stolen. That is fixed for lordship 330 of CRPC, lordship. That is one issue, lordship. But that issue needs to be addressed before the Lanet regarding this.
So you want another cases to be registered?
No, not another case, lordship. Regarding identification in the office, biological mother, lordship. These two persons.
So what you are praying for before this court?
Directing for investigation as to who is the biological mother. Because this is
So you can file an application before the landed court below. File an application for sending the matter to the DNA test.
This is regarding the investigation part, lordship. This is not related to that. That is
Sir, you are telling that before the trial court the case is at the stage of 313.
313 for lordship stolen property. He has stolen there. That is different case, lordship. But this is to be addressed, lordship. For evidence purpose, lordship. I shall file it.
Yes.
Lord would remember this particular matter. I'm mentioning this for the third time for inclusion. Lord, January 1st week I had mentioned this matter, then the file was lost. Lord, your lordship had directed to appear it any day before this week. Lord, this matter went out of the list because it was not served. It was served, but the respondent did not appear. Thereafter, Lord, it went out of the list. Your lordship was sitting in 38, then it came to this court. Your lordship would remember, then I have served notice. This was to be fixed, your lordship.
17 तारीख February.
I'm deeply obliged, your lordship.
Malad,
Deeply
may I
obliged.
To mention this matter. The matter is appearing as item number 262 in this list. Lordship is a matter regarding premature release. The petitioner is 71 years of age and already in custody for almost 40 years, your lordship. So basically, your lordship,
So whether your case has not been considered by the remission committee, then what has happened?
They are still sitting with it, your lordship.
What?
They are still sitting. They are not releasing him, your lordship.
No, any committee has taken the decision.
Yes, the state
for giving remission to you.
No.
Then,
lordship, we have filed a writ petition for that, your lordship. And
so what do you want now?
Lordship, his medical condition is getting worse day by day. He underwent a cardiac surgery.
The matter is to be heard on merit. State is to be heard.
Yes, your lordship, but it's not getting upgraded. We have mentioned it before.
Whether the affidavit is completed.
Yes, your lordship.
Affidavit is completed.
Yes, your lordship.
You sure? I fix for hearing if you find that there is no affidavit, then you'll be in trouble.
This matter has come Justice Sinha's court, your lordship.
Whatever it is, I am only putting one question whether the affidavit is completed. Once the affidavit is completed, then
it's a new motion, your lordship. The new motion, your lordship.
New motion.
Yes.
Lordship and item number
19th February को रखो urgent motion.
With your lordship's kindly, may I mention item number 521 for upgradation, your lordship.
For what?
521 of the today's.
For what?
Your lordship for upgradation.
For what?
Your lordship, the petitioner's house has the petitioner's husband was a guarantor to the bank, but the petitioner's was not a guarantor to the bank. The petitioner's house has been sealed by the bank, where no contract exists, my lordship.
So might be the property might be mortgage in the bank.
Your lordship,
So
it is a sole owned property, your lordship.
maybe you might be a guarantor or a surety of your
Not
husband.
entered into any kind of.
Yes, what is the?
Lordship was kind enough to this particular matter. Terminal benefit related matter, my lord. Since 2021 it is pending. Exchange of evidence, everything is done. It is appearing in the list 558. Possible lordship, kindly, my lord.
Lordship.
My lord.
For the inclusion of a hearing, any specific date.
17th February. Urgent motion.
Lordship.
Urgent motion.
Inclusion of a hearing, it predicts a complete matter of 2025 or predicts a complete illegally terminated by an authority.
Who is for the other side?
We have served notice. Upper notice are
हाँ इसको ना 2 बजे का कौन सा डेट खाली है देखो.
लॉर्डशिप में
2 बजे का डेट खाली. बाईस 23 24 25th February at 2 p.m. as a specially fixed matter. Inform the other side.
Lordship, may I permitted to mention item number 278 running the today's list for upgradation, Lordship. The ground of urgency is the Lordship. The petitioner is in custody for more than 21 years and he is undergoing severe health issues, Lordship.
Huh?
He is undergoing several health issues, Lordship, and he is in custody for more than 21 years.
What is the conviction?
Sir, 302, Lordship.
So, how you can get the commission here? Your case has not been considered. Oh, 24th February.
I'm grateful, Lordship.
My lord, may I be allowed to mention a matter? My lord, the matter is running as item number 95. It's an electricity matter, my lord. My lord, kindly.
95.
Yes, my lord.
What is the name?
It releases the matter. It's a.
What is the name?
Devarbrata Sarkar and another versus State of West Bengal and others.
Though the matter is listed as item number 95, but the learned counsel for the petition has mentioned the matter and submits that the matter is connected with the grant of electric connection. Accordingly, the matter is WPA number 18478 of 2024 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
Your Lordship,
that petition approach the Honorable Court and Honorable Court dismiss the writ. But against that, Honorable Division preferred and Honorable Division was fixed to divide the petition into original. Now, what happens during this interim number, there is an arbitration proceeding that is already initiated by the railways. Now, my lord, because of the pendency of this single honorable single bench's writ petition, my lord, is standing in the way. The arbitration, my lord, is going to once again happen on.
What is challenge in the writ petition?
Termination of the contract of the railway overview.
So what is that subject matter in the arbitration?
The same.
So why you are parallel proceeding? How the parallel proceeding will go? So either you not press the petition, you go and proceed with the arbitration.
That's what I was saying before. This matter should be mentioned, but under the agreement to be mentioned. I'm pressing your lordship.
Let's go. Give. इसको to be men वो वाला है ना? To be mentioned में रखना for withdrawal.
your Lordship.
For withdrawal. हाँ? हाँ. 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 When your father died? Huh? 2020. When the mother died? 23. Now we are on 25 you filed. 24 you filed. So उसको ले लो 25 तारीख को रखो 25
One matter. Hospitals are running in my property without any license or under technical establishment.
Yes.
Hospitals are running in my property matter without any license under clinical establishment. There's already the improvement issued by the CFC, the medical officer. I doubt that hospital has not taken any step because they have no stopping of the business matter. They're running my property. Any untoward incident happens, I will liable.
So what is the urgency in that?
So they're running it in spite of the improvement notice. They have to stop the business without any license. They're running this business matter.
So what is the urgency?
This is my property. And the any untoward incident happened to the property.
25 तारीख को रखो उसको.
May I be permitted to mention a matter, my lord? It's running item number in the list, item number 464 and 465, the two matters. The petitioner is the leaseholder and it is the property.
What is your prayer?
The upgradation.
Why? For what?
The property is under KMD, my lord.
What is the urgency for upgradation?
The original leaseholder is, the condition is not very well. So he's in serious condition. So we need her in this matter.
So what you prayed for? What is your prayer in the writ application?
My lord, regularization of the lease deed, my lord. Original assignee, my lord, assigned it in my favor. Lease of 999 years. But so he or she can transfer it in favor of anybody else. My lord, last 13 years, my lord, she submitted in every document. My lord, in support of assignment. But since last 13 years, the matter is, my lord, hanging over, my lord.
26 February को रख दो उसको.
Lordship, may I be permitted to mention three matters, your lordship?
26 February.
For withdrawal.
Withdrawal, lordship.
चले लो withdrawal.
Item 280. Grateful,
It
Lordship.
is listed today?
Yes, Lordship.
Record or not? Give the number.
Lordship, the item numbers are mentioned.
What is the item number? Give the item number. Give. Item number 282. Counsel for the, though the matter is listed as item number 282, but the learned counsel for the petitioner prays for, she has instructions to withdraw the instant case. In view of the submission made by the counsel for the petitioner, WPA number 17555 of 2025 is dismissed as withdrawn. Interim order, if any, stand vacated. Same item number 291, same order, and 312.
One, Your Lordship.
291 and 312.
Well, Lordship.
May I have my lord's kind leave to mention a matter? May I have my lord's kind leave to mention a matter? My lord, despite a peremptory direction from the Honorable Coordinate Bench, the respondent bank has not released the funds. The said funds are lying with the bank since the last 20 odd years. The petitioner who had filed the writ petition has passed away during the pendency of the writ petition. The successors, they have been substituted. My lord, the matter was returnable on the 1st of December, but the matter did not come up in the list. If my lord would kindly...
25th February, Gaurav.
25th.
May I be permitted to
Deeply
make one
obliged, my
bit of
lord.
upgradation, my lord?
For what?
My lord, I'm staying in a property, my lord, which I received as a gift from my grandparents, my lord. Now my grandparents, being the private respondents, have filed an application under section 4567 of the Welfare and Maintenance of Senior Citizens Act to oust me from the house, my lord. I'm staying in the house, my lord. I have filed an appeal, my lord, that is still pending. In the,
So what you want?
Magistrate court, my lord. My lord,
It is pending before the magistrate. What the writ court will do?
my lord, my prayer is to my lord to overlook the my lord initial order of the initial order where I am being directed to go away from the house, my lord.
So you challenge the order before the revisional court. How the writ petition? Yes.
But the petitioner's grant for EWS certificate has been the petitioner's grant for EWS certificate has been rejected by the authorities due to his inclusion of his subcaste in the state OBC list.
Correct.
Now, my lord, he had participated in the second SCPC recruitment process, the document verification of which is to conducted in the last week of January. This matter was taken up
Which category you applied for?
under EWS category.
But you are having, now it has been changed to the OBC. Category B.
Yes, my lord, category B. Now,
Category B.
Now, my lord, the urgency is that the document verification process will be conducted in the last week of January. My lord, kindly takes it up before that, my lord. Otherwise, my lord, my candidature will go.
29 January.
29. My lord, before that, my lord, in the last week of January, the document verification.
I can't fix on other date. 28, 29, only this.
29, my lord, deeply obliged.
Lordship, may I leave to one matter? Lordship, the petitioner is Lordship, senior citizen matter. Lordship, the pension matter, which has been deducted hugely at the time of Lordship retirement.
So why before this court? Which department?
Lordship, education, but
Go to the education.
Lordship, 2025, I have filed. They are not Lordship producing in document. Lordship, kindly consider this.
Madam, this court is not having the determination. You go to the education department. Irrespective, all the things cannot be taken.
Lordship, 2023 year, Lordship, I have seen Lordship, your Lordship is jurisdiction.
So what? Go to the first court. If that court will not accept, then you come before this court.
Lordship, this court is Lordship.
This court is a good. Go to the group 2. Yes.
My lord, may I be permitted?
The mention will not finish. 1 hour has passed.
Mr. Banerjee.
Yes, one by one. Yes.
My lord, Mr. Banerjee will mention the matter, item number 324. It fixed for 5th February. My lord, kindly fix any time, my lord, on 5th.
I don't know which matter.
My lord, it's a the freezing of the bank account, HDFC Bank, item number 324, today's late, my lord.
So it is fixed on 5th February. That is urgent motion. So it will be taken up.
But any time,
Time can't be. Time then it will go to the March.
my lord, motion, similar motion, your lordship had in earlier occasion and file.
What is
my lord,
what?
direction given to file report by the DM. My lord, DM has already filed a report in favor of me. Panchayat Samiti constructed the building of the Panchayat, Gram Panchayat office. My lord, by filling up a pond that is 20 bighas, more than 20 bighas of pond. Your lordship directed to file a report in favor of me. My lord, in spite of direction, my lord, of the SDO, my lord, the construction, my lord, 3+2 construction already done. Any date as your lordship convenience, kindly, my lord, take up as upgraded motion. Any date with notice I am mentioning.
17th February.
17th February.
My lord, may I be permitted to? Yes. Call the list.
My lord, I mention application.
For what?
আমি একটা ইন্টারিম অর্ডার আমি ইন পার্সন অ্যাপিয়ার করছি
Which petition? Read petition.
আইটেম নাম্বার 311
So what is the urgency?
আর্জেন্সি এটা একটা হ্যান্ডরাইটিং এক্সপার্টের জন্য কোড ডাইরেকশনের প্রয়োজন আছে হ্যান্ডরাইটিং এক্সপার্ট
petitioner?
হ্যাঁ আমি ইন পিটিশনার
আপনার রিট পিটিশনার?
আমার রিট পিটিশন মানে এটা আমার বাবার লাইসেন্স এক্সাইজ লাইসেন্স
What you prayed for?
আমি প্রেড ফর মানে আমি চেয়েছি যেটা অ্যাপ্লিকেশন ফর হ্যান্ডরাইটিং এক্সপার্ট মানে অ্যাপয়েন্টমেন্ট ফর এটা অ্যাপ্লিকেশন করেছি
23 February को करो. My lord, may I be permitted to mention? Yes.
বলে এটা ডেট ফিক্স করে দেন
I'm in custody for more than 21 years. My brother who was in custody, he has expired. My sister in law, she was released by the order of the governor. But I am in custody for last 20.
You have not been given the remission. Why?
But I have not.
You do one thing. You file it. Get the number. Mention. I will.
My lord, next week একটা ডেট ফিক্স করে দেন next week
23rd February. 23rd February.
My lord, may I be permitted to hearing matters, my lord.
Hearing matters.
My lord, I seek your lordship's leave to mention one matter for upgradation, my lord.
Come Monday.
My lord, may I be permitted to mention?
Just call the list. Call the list.
For release from this.
Which matter?
Your lordship, I had mentioned on 9th of January. Your
Which matter?
It is not running in the list, your lordship. I had mentioned for grounds of upgradation, your lordship had directed that because this is related to MSMED Act, violation of MSMED Act as well as SARFAESI Act. On 4th of December, I had mentioned your lordship had directed the matter to appear because your lordship said that since it is also related to SARFAESI Act, your lordship do not have the determination.
So it has to be seen what is your prayer? You challenge the SARFAESI Act or your?
I am challenging the MSMED Act. I'm actually challenging the MSMED Act.
So that has to be seen.
Yes, I had mentioned on 4th of December upon
12 तारीख को रखो.
My lord, may I be permitted to mention?
Of today's list, kindly take it around 3 p.m. because considering the urgency, your lordship, the actual direction matter appear under the heading.
You go to the original site registrar and tell the original site matter not to be taken. Request this court to not to taken the original site matter. Your appellate site matter will be taken. You knows that at 3 p.m. the original site matter has been taken. Then.
Before 3 p.m. lordship.
My lord, may I be permitted to mention one matter for upgradation, my lord? Item number 72 of the daily list, my lord. The bank authority has withheld the petitioner's FD amount even long after maturity, my lord. The FD amount have matured
24th February.
For upgradation, my lord, item number 307 and 308 of your lordship's list, today's list. My lord, the urgency is that taking advantage of a wrong recording in the deed of conveyance, my lord, the local club is taking possession of my property. Though the description.
What you prayed for?
My lord, I'm praying for a direction upon the registrar to
25th February.
My lord, I'm deeply obliged.
25th February. Yes, call the list.
Appearing for the petitioner.
Call the list. Call the list.
Lordship.
This court did not find any justification to the assertion made by the respondent that the ongoing investigation will adversely impact it and will cause severe detriment to the public servant. In view of the above, lookout circular is set aside. Next.
I am appearing for the petitioner, my lord.
It is mandatory on the part of the bank that in reply, if borrower claims benefit of the framework with reasons and affidavit, the bank is bound to look into the claim of the borrower. Considering the above, this court finds that the proceeding initiated by the bank against the petition is at the initial stage, and there is no dispute that the petition number 1 is MSME. The petitioners are directed to file claim within a week from the date along with an affidavit and the documents to the respondent number 2. If the petitioner submits its claim within a week from date, the bank shall consider the same in accordance with the notification dated 29th May 2015 and 17th March 2016. Till the final decision is taken by the bank, the proceeding initiated by the bank shall be kept in abeyance.
I'm grateful, my lord.
Considering the above, WPA number disposed of by directing the respondent number 2 to that is the Registrar of Companies, Kolkata, to consider the representation submitted by the petitioner within a period of 6 weeks after giving an opportunity of hearing to all three parties, that is the petitioner, Swatch Environment, and the Haldia Water Services, by passing a reason and speaking order after giving an opportunity to all the parties. Next.
My lord, I am appearing on behalf of the petitioner. My lord, this is the matter wherein we were discussing whether the senior citizens, they have the, we know they have the right to prefer appeal, but whether the persons who are not the senior citizens in the same act, what they will do? Shall they prefer appeal, or they have the right to prefer a writ application? But this was our point of discussion.
Dispose of, huh?
My lord, I have annexed a particular citation, my lord, there of this honorable court. If your lordship sees paragraph 25, my lord, it has been discussed. Page 25, paragraph 16.
Yes.
But there were the discussions thoroughly, and ultimately it was stated. Before that, my lord, kindly allow me to read from paragraph 9, relevant parts, my lord. Paragraph 9 of the citation, page 17.
Yes.
On a bare reading of section 16, it appears to us that the right of appeal has been conferred only on the senior citizen or parent, as the case may be, who is aggrieved by an order of the maintenance tribunal. The wording of the said section is absolutely clear. There does not seem to be any scope for confusion. The legislature, in its wisdom, has restricted the right of appeal under section 16 to the senior citizen or parent. There could be good reason for the same. The act is a piece of legislation meant to enhance the welfare of parents and senior citizens. The said act imposes an obligation on the children or relatives as defined in section 2A and G of the act to maintain the parent or senior citizen as the case may be. Hence, possibly the legislature thought it fit to limit the right of appeal under section 16 to the parents and senior citizens. Now, my lord, I shall take your lordships to the paragraph 16, page 25.
Yes.
Relying on the decision of the Punjab and Haryana High Court in the case of Paramjit Kumar Saroya, Supra, learned advocate for the respondent number 6 argued that unless section 16 of the said act is construed as providing a right of appeal also to the children and relatives, there is a possibility of there being parallel proceedings resulting in conflict of judicial decisions. There may be an order of the maintenance tribunal with which both the parents and senior citizens and the children relatives are aggrieved. The parents, senior citizens would challenge the order before the appellate authority constituted under the act. The children relatives would have to challenge the order by way of a proceeding under Article 226 or 227 of the Constitution before the High Court. This would give rise to an anomalous situation and possibility of conflict of decisions. Such a mischief can be avoided if section 16 of the Act is interpreted as giving a right of appeal to the children or relatives also. We respect to the learned counsel, we are not impressed with this argument. Theoretically, such a situation may arise. However, there would be no possibility of conflict if decisions if the High Court withdraws to itself to statutory appeal filed by the parents, senior citizens. This power the High Court has whether under Article 226 or under Article 227 of the Constitution. In view of the aforesaid, we set aside the judgment so and so. So, my lord,
Yes. So who has filed the writ application?
my lord, huh?
You are the writ petitioner?
Yes, I am the writ petitioner. I am the daughter-in-law of the senior citizen.
Where is the order of the SDO?
Page number 100 of the writ petition.
100 of the writ petition.
Yes. Page number 100 of the writ petition.
Priyanka Methi is the daughter-in-law.
Yes, I am the daughter-in-law. I am reading, my lord, loudly. The matter is taken up today for hearing. The petitioner and OPs are present, heard from both the parties. In compliance of the order passed by the Honorable Justice Tirthankar Ghosh, Kolkata High Court, there was a writ application which was filed by the father-in-law, in connection with so and so. The matter was heard at length. Petitioner allegation in brief is that he gifted his business of fertilizer with a pakka building measuring 1800 square feet total in 2 floors over a 3 decimal land to his son Badshah Maiti and daughter-in-law Priyanka Maiti equally. After that, daughter-in-law Priyanka Maiti grabbed the share from his husband Badshah Maiti by a deed of gift. Actually, what happened? Deed of gift was done. Thereafter, husband also gifted the property to his wife. In way of some conspiracy, after getting the right of full ownership of the said plot, Priyanka Maiti misbehaved with the petitioner, spouse of the petitioner, and also Badshah Maiti, her husband, and driven out from house. Now the petitioner is residential, houseless, jobless, and praying for get returned his property, which he has given to the OPs by gift deed. The OP Badshah Maiti admitted the fact and stated that his wife misbehaved with him. Priyanka Maiti, the spouse of Badshah Maiti,
Who is the petitioner?
Priyanka Maiti is the petitioner before your lordship.
Before the SDO?
Yes, before the coordinate bench, the
no,
father-in-law.
before the SDO.
Father-in-law.
Father-in-law.
Father-in-law was the petitioner. Priyanka Maiti, the spouse of Badshah Maiti, informed to the court that the petitioner was facing a huge financial crisis and the property in question was about to auction. In that situation, she and her father stable the circumstances by financial help. This is the submission of the wife, daughter-in-law. The Mugberia Cooperative Bank was not approving any loan until and unless whole property shop was not fully transferred in the name of Priyanka Maiti. She is mother of 2 daughters who are unfortunate enough to get any assistance from their father or grandfather. The future or security of 2 girl child is nothing but this land. This court also perused, the order of challenge. This court also perused the deed of gifts mentioned before and found the deeds are unconditional. Hence, this court orders. Here I am pausing for a moment. I am raising question whether this SDO can pass this order even. All members, that is Priyanka Maiti, her husband, father-in-law and mother-in-law will stay at their residential house without any condition. The petitioner Abhay Chandra Maiti may start again business at the shop which was gifted to Priyanka Maiti, and Priyanka Maiti is restrained from creating any obstruction with the premises related to business. As the deeds are unconditional, the petitioner prayer for cancellation of the deeds is not considered by this tribunal. If there another issue arises, the petitioner may apply before proper forum. So, this was the prayer.
So you are for the daughter-in-law.
I am for the daughter-in-law. I have come before your lordship by filing this writ application because I have no other way. I cannot go before the appellate tribunal. I do not have any right. But my lord, what happened in this case? Kindly comes to page number 12 of this, my lord, recalling application.
Page number 12.
Yes, page number 12 of this of my petition. My lord, this was for abundant mistake, my lord. The conducting lawyer.
Page number 12 of which application?
Of my recalling application.
Recalling application is can number 1.
Can number 1.
So it is for recalling of the petition.
Yes, my lord. My lord, by mistake, my lord, the conducting
Where is the order of dismissal?
Yes, page 12.
Acha, that one.
Yes, my lord. He my lord, withdrew this petition. He was under the impression that there will be an appeal before the appellate forum. But the fact is, no, it was filed properly before this honorable court as a writ application. The daughter-in-law, he has the remedy before the writ court. My lord, for that, my lord, I have preferred this application for recalling. Kindly comes to page 12. I am reading, my lord.
Correct.
I am reading from paragraph 1. After skipping 5 lines, he submits that subsequent to the filing of the present writ application, the petitioner came to know that there is an appeal provision under the Maintenance of and Welfare of Parents and Senior Citizens Act 2007. True, there was appeal provision, but that is only for senior citizens.
Correct.
Yes, thereafter, accordingly, he prays for withdrawal of the present writ application with the liberty to file an appeal before the appropriate forum. Paragraph 3, in view of the submission made by the learned counsel for the petitioner, WPS such and such is dismissed as withdrawn with the liberty to the petitioner to file an appeal before the appropriate forum. Here, my lord, I am again pausing for a moment. It was a mistake, my lord. It will be a writ application. Kindly recall the order and allow me to submit before.
Yes.
My lord, first of all, my lord, this is a recalling application. In a disposed of matter, recalling application, how far is maintainable is doubtful. It should be reviewed. And my lord, now if lordship may kindly come to, this is one part of my submission. And second is, if lordship may kindly come to page 26 of the judgment passed by the Honorable Division Bench, paragraph 19.
Yes.
Paragraph 19. Learned counsel for the respondent number 6 argues that even assuming that no alternative remedy is available to the writ petitioner appellant, still an order of a tribunal cannot be challenged by way of an application under Article 226 of the Constitution of India. And that must be done only by way of an application under Article 227 of the Constitution. Here, my lord, the order is of the SDO, the appellate forum is DM. We have noted this point argued before us. However, we express no opinion thereon. We leave all issues open for the learned single judge to decide, including the point of maintainability of the writ petition, except on the grounds of availability of an efficacious alternative remedy in the forum of an appeal under section 16 of
the
the
court
state.
has left open with regard to whether it should be a 226 or it should be a 227.
In my respectful submission, this is the order of the SDO. A tribunal presided by SDO. There is appellate forum under section.
But the division bench is binding upon us.
Yes, binding up. Division bench is certainly binding upon us. But my respectful submission that it should be under Article 227, not a writ petition.
That will taken into consideration at the time of hearing of the writ application. You take that plea.
Very well. Lordship is allowing the review. Malad, subject to correction, Malad, I don't have the reference right now. Malad, so far as the recalling is concerned, after disposal, it is how far maintainable, Malad, I have. Review is maintainable, certainly, Malad, but the recalling is not. In Buddha Sai case, Malad, but I don't have the reference right now.
Here, our submission was as it has. We prayed for.
That's correct. That is correct. That is correct. If the writ petition is disposed of on merit, then the review has to be filed. If any proper. Here they have withdrawn and dismissed. Kindly see the para 3.
Para 3, I have seen.
Para 3. They have withdrawn to filing an appeal. And the learned advocate could not brought the notice of this court with regard to the order passed by the division bench. Now they have brought the notice of this court with regard to the division bench order. So as per the division bench order, the petitioner is the sister and daughter-in-law of the petitioner, so she cannot maintain the appeal before the appellate authority. So now they file the writ application. So with regard to the writ petition, or 227 is maintainable, that is the matter hearing on merit.
Grateful, Malad.
The petitioner has filed the present application being Can 1 of 2025, praying for recalling of the order dated 2nd December 2025. Wherein, as per the submission made by the counsel for the petitioner, WPA number 25520 is dismissed as withdrawn with the liberty to the petitioner to file an appropriate appeal before the appropriate forum. Learned counsel for the petitioner submitted Though on the submission made by the counsel for the petitioner, the court has passed an order for dismissal of the writ application liberty to file an appeal. But subsequently, the petitioner, learned counsel for the petitioner submit that the learned advocate on record could not able to bring to the notice of this court to the order passed by the Honorable Division Bench of this court in the case of Srimati Mamta Sarki and another versus the state of West Bengal and others, passed in MAT number 61 of 2019, dated 19th of March 2020, wherein the Honorable Division Bench has held that the parents/senior citizens would challenge the order before the appellate authority constituted under the Act. The children/relatives would have to challenge the order by way of proceeding under Section 226 or 227 of the Constitution of India before the High Court. The Honorable Division Bench has kept open whether the writ petition under whether the application under Article 226 of Constitution of India is maintainable, or whether under Article 2 whether the application filed by whether challenging the order passed by the SDO can be maintained under Article 226 of the Constitution of India or Article 227 of the Constitution of India. Learned counsel for the learned counsel for the petitioner submit that there in terms of the order passed by the Honorable Division Bench, there is no appellate provision, and as such, the petitioner has to continue with the proceeding of the present writ application. Accordingly, prays for recalling of the order and to restoration of the WPA number 25520 of 2025 in its original file. Learned counsel for the respondent raised objection and submits that this court by an order dated 2/12/2025 has dismissed the writ application as withdrawn as per the submission made by the counsel for the petitioner, and as such the order passed by this court dated 2/12/2025 cannot be recalled, and the application filed by the petitioner is not maintained. He further submit that the petitioner has not filed any application for review of the order dated Had the learned counsel for the petitioner respondent further submit that the order passed by the sub-divisional officer is an appealable order under Section 16 of the Act, and as such the petitioner has to approach the appellate authority. Had the learned counsel for the respective parties, this could find that the petitioner initially the petitioner was of the view that the order is appealable, and accordingly he has taken leave from this court to file an appeal before the appellate court. Accordingly, this court has dismissed the writ application with the giving the liberty to file an appeal. Subsequently, the petitioner came to know with regard to the order passed by the Honorable Division Bench in the matter of Mamta Sikri Supra, wherein the Honorable Division Bench has categorically held that only the senior citizen or parents can maintain the appeal under Section 16, and the children and relatives can only maintain the writ petition either under 226 or 226 of the 27 of the Constitution. Considering the above, this court find that on the misconception the petitioner has read before this on the misconception on the petitioner has prayed before this court for withdrawal of the writ petition. Accordingly, the petition was dismissed. Now, in terms of the order passed by the Honorable Division Bench, the appeal is not maintainable if he is not a senior citizen or parent. Admittedly, the petitioner before this is the daughter-in-law of the complainant before the sub-divisional officer. Considering the above, this court find that the can number 1 of 2025 filed by the petitioner is maintainable for recalling of the order dated census. Accordingly, order dated 2/12/2025 is recalled. WPA 25520 of 2025 is restored in its original file. List the can number census disposed of. List the matter when
February, second week.
Affidavit filed?
No.
You will file affidavit?
Lordship,
Or
may kindly
you will
give.
or argue on merit?
My lord, it's a law point, my lord. It's a law point.
Let the matter appear on 19th February under the heading urgent motion.
Lordship, grateful.
Grateful, my lord. Grateful.
Next.
19th February. Grateful.
Yes, call the list. 5 is 2 p.m. Na?
No, this is actually
5.
no,
8.
8. Well, this has come by mistake because your lordship had been pleased to place it on 27th January. And the first order which was your lordship.
Repeat it, sir.
No, he is to pay me compensation. Because
I will.
You do both. You go.
I will.
But these petitions are in fact not claim against the state. And ASG would ultimately not be troubled with. The fight between the state and center, that is before the division bench. Anyway, let it appear on 27th.
Thank you.
কিন্তু আমাকে দেরি করবে
আমার হাতের বাইরে দেখছি অন্য লাইন দিয়ে দেখছি
Record it is Learned Counsel appearing for the parties inform this court that the matter is wrongly listed today and submit that by an order dated 7 January 2026, this court is fixed the matter on 27th of January 2026. In view of the submission made by the counsel for the parties, peruse the order, let the matter appear on 27 January 2026 under the same heading.
The subsequent order has not been uploaded. That is why it was earlier order was directed to appear on 15th.
And that is why that he should pay me compensation.
9th January is it server has been done?
No. Your lordship's earlier order was it was due to appear on 15th.
Okay.
That is why it has come.
Okay.
Subsequent order is not taken note of.
Thank you. Next.
Item 9, Your Lordship, I am being laid by Mr. Bihani. Your Lordship, due to some personal difficulty.
What is the matter?
The matter is about the passport renewal, Your Lordship.
Yes. You are ready with the report, Mr.
Yes, but they actually informed us that they will ask for adjournment.
Now, if you are ready with the report, otherwise
Yes.
When?
Any day next week, Your Lordship. Any day next week.
Well, after 27th.
After 27th?
First week of February.
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 3rd February.
3rd February.
Under the same heading.
Under the same. A copy of the report.
No.
Come on that day, we'll see to that.
Soft copy forward.
Number 10.
For the petitioner, my lord, I have already served notice upon the advocate, senior advocate, and the learned government advocate.
एक काम करो इसको ना भिजवा दो हमारा अर्जली होगा ना चैम्बर में भिजवा दो करेक्शन करके अपलोड कर
দাঁড়িয়ে আছে তিনি
can what is the can okay I will see in the file I will see it and I will include
My lord, I am paying for very short password, my lord, on behalf of Mr. Nilotpal Chatterjee, my lord. At present, he is on legs before the courtroom number 3, my lord.
Last occasion, your lordship was.
Yes.
Have you taken instruction? What has happened to the board?
My lord, instruction has received by him, my lord, but
Authority is
I
required
am
to
not.
be appointed, my lord. Judicial officer has already been appointed.
Yes.
No, so last time because the
Yes, I have seen the
DM
last order,
yeah.
my lord. But yes,
You have a report?
no, my lord. I do
What
not
you-
have.
what
But
you
means- I'm paying for only very short passover, my lord.
Passover.
Kindly passover, my lord. He will come very shortly.
Passover next.
11. Item number 11.
None appears on behalf of the petitioner. You are appearing for the 11.
Petitioner. Yeah, my lord, I have something to say. But there's an order directing the sons to pay maintenance. Today is the 15th of the month. That has not been paid. There's an early order of Justice Sinha directing reimbursement of medical expenses. That has not been paid. I have submitted revised bill in terms of my lord's order, direction for reimbursement of the travel allowance. That has not been
Okay, you
paid.
come this side.
All that, my lord, when the matter is pending, when my lord is in season of the matter. And I shudder to think what would happen once the matter is disposed of. This month's maintenance not paid, medical expenses not reimbursed, travel allowances, the revised bill not paid. 15th of the month today.
Yes, Mr. Mukherjee.
But on my instructions, my lord, I say that, my lord, it has been paid. The transfer details are here, my lord. My learned friend, my lord, may verify
I have
from his
instructions
client.
till
And I've got the
yesterday.
details.
This month's maintenance also, and the medical bill reimbursement.
That we have paid, my lord, we can send the proof of, my lord.
If it is
So, my lord,
paid-
let my learned friend, my lord, argue on merits.
Yes.
Because,
No,
my lord, every month
no.
he will come and complain about
Yes,
that I have not
I'm
paid.
complaining because there's the other son also. He has also to pay. He has
Not the
also
man
to
of
pay
God.
the other son. My learned friend is not speaking for both of them. Until yesterday, my lord, even this month's maintenance was not paid.
Which one?
The
Mr. Mukherjee is telling that then it has
Yes,
been
but
paid. They are having the
Where,
document.
when, on which date?
9th January.
Sorry?
9th January. The 15,000 maintenance.
No, I have the proof for this one. I'll send you I have the proof for the travel expenses, my lord, on my phone right away.
No maintenance.
I'll send the proof as well. I have instructions that it has been paid.
My instruction is, and the medical reimbursement is also there.
Instruction was there not paid.
He's telling that it is medical in.
No, that is, I think, travel.
That is a trial. That was a submission.
Okay.
Yes, I
Okay,
say
come
all
on, merit,
three
I will
items have not been paid.
Come on, merit. Come on, merit.
On merit, Manad, I have submitted a brief written note. I'll Manad, focus on the second page of that, the financial capacity of the sons. And all along, Malad, the elder son is totally silent. He has also to contribute to that. This is important because this is all the more reason, Malad, why the house should be vacated and the rent paid to my client. Instead of coming forward every month before my lord with a begging bowl, but this cannot go on indefinitely. My learned CA friend is absolutely right.
Yes.
But kindly see page 2 of that 3-page note.
Yes.
The elder son, Gajanand, has a rice mill in Keshpur and Midnapur, and his elder son, the grandson of my client, is also earning. The elder son and his family are in occupation of the first floor of the building. His daughter has been recently married off in a lavish wedding. The younger son, Shamsundar, carries on his father's business of animal feed in Kirantala and uses the ground floor of the residence as a go down for the said business. He has also appropriated the agricultural income from the family's ancestral home land in Haryana. The maturity proceeds of the fixed deposit disclosed by him at pages 58-59 of his writ petition have been misappropriated by him. There's no whisper about what has happened to that money. The purported affidavit undertaking of Pushpa, annexed at pages 31-32 of his writ petition, allegedly recording no objection of his mother to run the family business from the subject property, bears her forged signature. Besides the ground floor go down, the younger son is also in occupation of the entire second floor of the building. This is how things are. But the house is in the name of my client. That has not been disputed. There's a wrong deed annex that has been pointed out by one of the brothers. And then the claim of the petitioner, in view of the fact that the petitioner considers it impossible to reside in her dwelling house in Midnapur because of the perceived threat to her safety, the house should be vacated by ousting the sons. In the event the Honorable Court is not now, Malad, after this change scenario of every month there's default, I think, my lord, this whatever money my lord eventually directs will not be paid.
Yes, continue.
Grow up. The petitioner cannot be expected to spend her remaining life in her sibling's house, and that is why she has claimed a nominal rent for an independent accommodation in Jatani in Khurda district, near the residence of her younger sister. It has to be borne in mind that the two sons are in occupation of the entire 3-storied house, the ground floor whereof is in commercial use. Irrespective of the income of the sons, the rental income from the said property would be in the region of 50,000 per month. And as owner of the property, Pushpa is squarely entitled to the said sum. She should also be paid her share of her husband's business, now run by the younger son. In addition, the maturity proceeds of the fixed deposit disclosed at pages 58, 59 should be paid to her. In the event of serious illness of the petitioner requiring hospitalization, all expenses should be borne, I say by Shamsundar, by whatever they decide. However, in the event of the sons failing to comply with the order of the Honorable Court regarding payment, the order of eviction passed against them by the SDO should take effect. My Lord will also note another significant thing. After the SDO's order, my Lord, there was a gap of 6 months before the writ petition was filed. In that 6 months, my Lord, not a penny was paid.
Not a penny was paid means?
As maintenance, in terms of the direction of the SDO.
10,000 you are not getting.
The direction was 25,000, 15,000 by Mr. Mukherjee's client, 10,000 by the other son. For that period,
Can the SDO can pass an order for 25,000 under section 9(2)?
She can, in default of rent, she can. I know there's a ceiling on that, but then the deemed rent, the deemed rent, the property is hers.
So deemed rent can the SDO can decide in the summary proceedings.
But it cannot. Kindly have a look at the prayers of his writ petition.
That's why I kept this matter. These are the two questions. Section 9, there is a ceiling of the maintenance amount, which cannot beyond that. If it is ceiling, so you cannot go beyond the 10,000 rupees. With regard to the property, income of the property you are claiming, so that cannot be decided by the authority.
25,000 has not been challenged by either party.
No, I am telling here.
Yes.
Whether they have challenged or whether the authority, if this court is find that it is beyond the jurisdiction, the court can so moto can pass an order.
Even there is a writ petition by my client.
All this is that they're the only challenges to the eviction direction. But this is all the more reason, my lord, for the house to be vacated. The tenant being placed there and the rent coming to my client.
Because kindly come to the section 4. Section 4, then now come to section 9.
And then Lord 11.
11.
Implementation. Section 4.
Section 4. Section 4 is your application.
Yes.
Which you have filed the application before the authority. Section 4 read with section 5. 5 is the application, 4 is the maintenance.
Here the presumption is that the senior citizen is residing in a own house. The question of rent, deemed rent, occupation charges did not arise.
From the law. Now it is before the court. Now the court has to go by the law.
Kindly seize,
I think the prayer is only for delivery of possession of the house, Lord. That is also not maintainable in a writ court.
Kindly seize, my lord.
Writ petition is
Section 4. Section 4.
Yes. My learned friend is arguing.
Section 4. Any person being a relative of a senior citizen and having sufficient means shall maintain such senior citizen provided he is in possession of such property. Section 4, subclause 4.
Correct. Yes, I am there.
Yes. Or he would inherit the property of such senior citizen.
Correct. Now kindly come to the 9.
Yes. If children or relatives, as the case may be, neglect or refuse to maintain the senior citizen, being unable to maintain himself, the tribunal may, on being satisfied of such neglect or refusal, order such children or relatives to make a monthly allowance at such monthly rate for maintenance of such senior citizen, as the tribunal may deem fit and proper.
And you also filed the appeal. You have filed the writ petition.
I filed a writ petition.
So you are the senior citizen.
I am for implementation of the order.
Implementation. Okay.
The maximum maintenance allowance which shall be ordered by such tribunal shall not exceed 10,000. But here, my lord, 10,000 may be construed by each of the sons. There is a separate direction on respondent number 5 and 6. 5 is 10,000 and 6 is 15,000, a figure which has not been challenged. The focus on their writ petition was on the eviction order. In all this scenario, the proceedings, the happenings in the course of the pendency of the writ petitions embellishes the case for having the house vacated and a tenant being put in place, my lord, so that the rent can be enjoyed by my client. And my lord, the harassment and the neglect that the petitioner faced at the hands of her sons, kindly see page 4, paragraph 4 of the first page of the writ petition. There's the reference to the pleadings in the writ petition, the sufferings and humiliation suffered by the petitioner at the hands of her sons after her husband's death are narrated in paragraph 6:1 to 6:25 at pages 4 to 9 of her writ petition. She was thus compelled to take refuge in her sibling's house in Orissa in March 2019, where life-saving kidney surgeries took place on 18th April and 14th June 2019, followed by surgery for removal of cataract of her eyes. She returned to her residence in Midnapur from Orissa in October 2019, but her stay there was not happy as her sons displayed total apathy, failing to provide food and medicines, and even worse, treating her with scorn and ridicule. The petitioner was thus left with no option but to shift to Cuttack in January 2023. But just one judgment, my lord, that although eviction is not to be normally ordered, in case of persistent humiliation and, my lord, apathy and just kindly bears with me.
Can copy it, sir?
Yes, this is a very recent judgment, my lord, of the Supreme Court. Well, kindly sees paragraph 28 of this. Well, 2025 Supreme Court cases online, page 669, paragraph 28. Age bolla 2025 SCC online, SC 669. It was only in the contingency of Krishna Kumar, that is the son, not behaving properly or continuing to.
Where?
Paragraph 28.
Yes.
I hope I have given my lord the right judgment.
Yes.
Continuing to humiliate or torture the parents, that the eviction proceedings would be necessary against him. Here, even during the pendency of the writ petition, my lord, maintenance not paid. She had to run away from there because of the scorn, the humiliation, the apathy shown by the sons. Here, the eviction order was set aside, but with that rider.
Where? Which?
Paragraph 28, my lord.
Yes, in a condition Krishna not behaving properly, continuing humiliate, torture parent, eviction proceeding would be necessary against him.
That here, my lord, the client was present before my lord. She could not be persuaded to.
That's why the eviction proceeding would be necessary against him. So eviction proceeding where?
Eviction proceedings before the tribunal.
How? Under which provision?
That again, my lord,
Only under 23 permission. Not under
section 23 has been read with section 4 have been interpreted by Supreme Court, that, my lord, that has to be read into it. Just the case of Vanita, that judgment is before my lord, my lord.
Correct, but you have what application you filed?
Kindly sees the judgment, Vanita. Here, my lord, I'll praise Vanita. I just
kindly come to the first 23.
Yes.
It's not a case under 23.
Correct.
Whether
it is not a case under 23.
That's why whether there is any gift.
No, that is subclause 1. Subclause 1 of 23.
Whereas senior citizen has a right to receive maintenance of the estate, some part thereof transfer the right to receive maintenance.
Here, this transfer has been interpreted by Supreme Court and other high courts also. But this judgment is with my lord.
Which order? Which order?
2021 15 SCC 730.
Yes. Vanita.
Yes.
Correct. This is
I cited this not to show me the primacy of not the act.
Paragraph 24.
24. Yes.
Kindly reads paragraph 24 and 25. But I'll start from 23 actually. On the other hand, subsection 2 of section 23 envisages a situation where a senior citizen has a right to receive maintenance out of an estate. Where such a right exists, the right of maintenance can be enforced where the estate or a portion of it is transferred against a transferor who has notice of the right, or if the transfer is gratuitous. The right, however, cannot be enforced against the transferee for consideration without notice of the right. Now, subsection 1 of section 23 envisages a situation where this subsection 1 is not relevant, but on the other hand, subsection 2 of section 23, for a few lines below that,
Yes.
does not confine itself to transfer by a senior citizen, unlike subsection 1. Subsection 2 uses the expression such estate or part thereof is transferred, where a senior citizen has a right to receive maintenance out of the estate and any part of it is transferred. Subsection 2 permits the enforcement of the right to receive maintenance out of the estate against the transferee with notice or against a gratuitous transferee. Subsection, in other words, may cover a situation where the transfer of the estate in which a senior citizen has the right to maintenance is by a third party, in which event the provision provides the right to enforce the claim of maintenance against such transferee. Arguably, the language of subsection 2 is broad enough to cover a situation where the transfer is by the senior citizen, in which event the transferee with notice of the right or a gratuitous transferee can be made subject to enforcement of the right against the transferred estate. Here, the transfer is not absolute transfer, but transfer of possession. But the transfer has not been defined, my lord, and in the subsequent paragraphs, my lord, kindly see paragraph 24 now. Another distinction between subsection 1 and subsection 2 of section 23 must be noticed. Under subsection 1, where a transfer has been made by a senior citizen subject to the condition that the transferee will provide for the basic amenities of his physical needs.
That is the fraud.
Yes. Now, a few lines below that, my lord, the fourth line from the bottom. Subsection 2 in contradiction stipulates that the right to receive maintenance can be enforced against a gratuitous transferee or a transferee with notice of the pre-existing right of a citizen to receive maintenance out of an estate, notwithstanding who is the transferee of the estate. In keeping with the salutary public purpose underlying the enactment of the legislation, the expression transferred also not only be absolute transfer, but also the transfer of the right or interest in the property. This would also be in consonance with the provisions of section 2F, which defines the expression property to include rights or interests in such property. Here I mean possessory rights. The expression transfer not having been defined specifically by the legislation, it must receive an interpretation which would advance the beneficent object and purpose of its provisions. Subsection 2 of section 23 speaks of the enforcement of the right to receive maintenance, which is more comprehensive in nature than merely enforcing an order for maintenance passed under section 9 of the Act. And paragraph 23. The substance of subsection 2 of section 23 as submitted by the second and third respondents is that the tribunal had the jurisdiction to pass an order directing the eviction of the appellant, who is the daughter-in-law. According to the submission, the power to order eviction is implicit in the provision guaranteeing the right to receive maintenance out of an estate, and they are the enforcement of the right. And here, my lord, that is the daughter-in-law who had competing claims under, my lord, Domestic Violence Act and that. But the important thing is that the definition of transfer is not confined only to absolute transfer of the property, but also to possessory rights of the property under section 23(2). Eviction, in other words, would be an incident of the enforcement of the right to maintenance and protection. However, this remedy can be granted only after adverting to the competing claims in the dispute. I'm reading on from paragraph 25.
Yes.
This, I rest my case squarely on this. There's no document transferring the property, but here the possession has been transferred. It is my property, that is not an issue. The quantum of maintenance has not been disputed. My lord will inquire from the respondent number 5 whether he is paying the maintenance.
Okay, that's all.
Yes. But there are judgments following from this, my lord, by various high courts. I can give my.
Completed, then because Mukherjee already argued what further, because
No.
of you only it has been kept.
Yes, and because of my anxiety that once the writ petition is disposed of, nothing will come.
No, your writ petition is for enforcement. Their writ petition is regard to the challenge. If this court find that their challenge is not sustainable, then
Challenge to
enforcement-
the eviction. No
Correct.
challenge, my lord. Will kindly look at the
Correct. With regard to that, the court has to pass an order. Yes, आप पैसा दे रहे हैं कि नहीं दे रहे हैं? कब दिए हैं? Last payment कब दिए हैं? लास्ट पेमेंट कब दिए हैं? अभी हम जनवरी में हैं, कौन सा महीना में पैसा दिया आपने? December. Yes, yes, paid.
December. We are now in the middle of the next month.
Yes. जनवरी में क्यों नहीं दिया आपने? अभी बढ़ा हुआ क्या? 10 तारीख तो कंप्लीट हो रहा है।
तारीख हो गया। थोड़ा प्रॉब्लम है।
प्रॉब्लम हो जाएगा यहाँ से जब ऑर्डर होगा तो। अभी तक तो अथॉरिटी का ऑर्डर, हाई कोर्ट का ऑर्डर होगा तो प्रॉब्लम सब बाहर हो जाएगा आपका। अब मदर को पैसा नहीं देना चाहते तो फिर और मतलब क्या है आपका?
दिया है तो अगला महीना में तो दिया, इस महीना
आप कोई मेहरबानी नहीं कर रहे हैं अपने मदर को पैसा दे करके, फिर
दिया दिसंबर का भी दिया हुआ है, जनवरी का।
आपका क्या बोलना है इसमें? आप ये आपने तो अपील नहीं डाला है ना?
Your lordship will
हाँ, क्या बोलना है बोलिए।
हमारे पास कोई काम नहीं है।
हाँ,
बेकार।
ठीक है,
थोड़ा सा भाड़ा उड़ा से इनकम आता है, फैमिली का।
ठीक है।
फिर भी हम ये उधारी लेके देते थे आपका जो बोला है वो हम निकालते हैं।
ठीक है।
और ये जो का जो चीज था, जो भी कुछ है, हमने खाली 2 रूम यूज करा। बाकी का नंबर 5 क्या है वो तो ये वाला चीज है। अगर हमको
आपने तो चैलेंज नहीं किया है ना? एसडीओ साहब ने जो ऑर्डर किया आपको 10 आप देने के लिए राजी है तो ठीक है, ओके।
Lord, if your lordship kindly comes to the prayer of my learned friends, Lord, writ petition at page 14. Mandamus is short, Lord, directing the respondent number 5 and 6. My client and the other brother. You are at page 14. Lord, that is Pushpa Sharma's Lord writ petition number 10504. There are 2 writ petitions.
Yes.
The writ of or in the nature of mandamus directing the respondent number 5 and 6 to hand over vacant possession
Yes.
of the immovable property belonging to her at such and such, comprising of 2 katas land with 3-story structure in terms of the order of the SDO. So, Lord, this is the first prayer. The second prayer, Lord, that is what I mean to say is a mandamus is sought against, Lord, a private person seeking, Lord, delivery of possession of a property. First prayer. The second prayer is, Lord, compliance of, Lord, the 2 of the orders.
That's the maintenance order.
So that is the maintenance order. Now, Lord, the maintenance order, as your lordship will find, Lord, is having 2 components of it. The 2 brothers are, Lord, supposed to pay, Lord, 10,000 and 15,000 each.
Correct.
Now, Lord, it was also stated that they will not deliver vacant possession of the building.
Till that period.
No, Lord, yes. Page 79.
Page 79.
Page 79.
Yes. No problem to vacate the property to the applicant, but ask the
Lord,
reasonable time for safety.
Lord, about the middle portion, opponent number 1 and 2
What
state.
is your contention with regard to this admission? You will vacate the property.
But this was not our contention at all, because this could not have been there. Because Lord, when I take your lordship to their application was for maintenance. There are 2 sons and a married daughter. They were all impleaded. Orders have been passed against Lord 2 sons. The order is Lord 10,000 for Mr. Sharma, Gajanan Sharma, and Lord for my client Shamsundar Sharma, it is 15,000 rupees.
Correct.
So far as the quantum of maintenance, my lord, I say when I refer to section 9, Lord, there is a capping of 10,000 rupees. We did not, Lord, contest on that before your lordship. We agreed. Well, our only point was, Lord, before your lordship, whether on an application under section 5, Lord, without a prayer, Lord, this Lord,
Where is the application?
yes, Lord, your lordship will kindly come to their application, Lord. Page 69. No. Page 60. Yes. And she files this Lord while she was staying at Cuttack, the sister's place.
Where is the prayer? What the prayers she has made there?
Now, Lord, your Lord, you will see, Lord, there are 3 Lord children. Names have been there.
That is there. Where is the prayer?
Then, Lord, amount of maintenance 7. That is at page 71.
Yes.
30,000 per month reimbursement of hospital expenses. These are the 2 Lord amount of maintenance claimed. Then, Lord, the details of the property owned by the applicant, Lord, the land such and such, Lord, which we say that this is not absolutely owned by her. This being a Mitakshara property, the property was owned by the father. Therefore, Lord, it is co-owned by all the legal heirs. So, Lord, there is also, Lord, a mention of, Lord, a movable property, the funds at a Mahendragarh Central Cooperative Bank, Haryana. So, Lord, the prayer were only for 30,000 rupees and, Lord, hospitalization expenses. Nowhere, Lord, there was a prayer. It could not have been, Lord, in a section 5 application. The purpose of the act, Lord, is to, Lord, ensure that the senior citizen is maintained.
Yes.
So, Lord, in this context, Lord, your lordship has already seen, Lord, the orders, the 2 orders. Now, Lord, our only contention is that, Lord, on an application under 5.
So that order is 79.
That order is 79, Lord, and there is another order, Lord, page 88.
Page 88, yes.
These are the 2 orders.
Yes. Yes.
Now, Lord, your lordship has seen, Lord, the scope of an order for maintenance, section 9. But if your lordship will kindly take, Lord, the statute now.
Yes.
If children or relative, as the case may be, or neglect or refuse to maintain a senior citizen being unable to maintain himself, the tribunal may, on being satisfied of such neglect or refusal, order such children or relative to make a monthly allowance at such monthly rate for the maintenance of such senior citizen as the tribunal may deem fit, and pay the same to such senior citizen as the tribunal may from time to time direct. The maximum maintenance allowance which may be ordered by such tribunal shall be as may be prescribed by the state government, which shall not exceed 10,000 rupees per month.
So there is a upper limit. The needs of such citizen so that senior citizen may lead a normal life. At any event, it cannot be as provided in subsection 2 of section 9, more than 10,000 rupees per month. Of course, while allowing even lesser amount, the income of the appropriate party should be taken into consideration. So, my lord, here, when I take your lordship to the order, your lordship has already seen, my lord, it is 25,000, my lord, as against 30,000 rupees claim, which is absolutely contrary to, my lord, subsection 2 of section 9. This is, my lord, one part of the order. On instruction, my lord, I do not say anything on the quantum. Now, my lord, when it comes to, my lord, the prayer B of my learned friend's writ petition, my lord, the enforcement of an order of maintenance, my lord, we fall back upon section 11. So there is an efficacious alternate remedy. A copy of the order of maintenance and including the order regarding expenses of proceeding, as the case may be, shall be given without payment of any fee to the senior citizen or to parent, as the case may be, in whose favor it is made, and such order may be enforced by any tribunal in any place where the person against whom it is made, such tribunal, on being satisfied as to the identity of the parties and non-payment of the allowance, as the case may be, expenses due. A maintenance order made under this act shall have the same force and effect as an order passed under Chapter 9 of the Code of Criminal Procedure 1973, and shall be executed in the manner prescribed for the execution of such order by that code. So, my lord, twofold, my lord, execution.
Yes.
By the tribunal itself, and, my lord, by resorting to, my lord, CRPC. Yes. Now, my lord, the right of appeal is only vested, my lord, to the senior citizen. My client doesn't have the right of appeal under section 16. So, my lord, my only remedy was filing, my lord, the writ petition before your lordship. Now, my lord, so far as, my lord, the second prayer of my learned friend's writ petition is concerned, my lord, they are to be relegated, my lord, under section 11 to the authorities concerned. But they do not have any right to approach this honorable court. Now, my lord, the other point that my learned friend had taken, my lord, that when an order for maintenance is passed under section 9, my learned friend tries to contend that it also encompasses eviction, so that, my lord, the senior citizen can, my lord,
take the benefit.
Take the money by, my lord, renting it out. Now, my lord, to such effect, my learned friend was trying to take, my lord, the help of section 23, which is, my lord, categorical on the point about, my lord, when there is a transfer made.
Correct.
And the transfer is, my lord, essentially a transfer contemplated under the Transfer of Property Act. Not, my lord, what my learned friend, my lord, says about the possession. The possession was never, my lord, taken. On the last occasion, your lordship has recorded in the order, when your lordship asked her that whether she is willing to reside, she categorically said, no, I am not willing to reside at Cuttack, not with my sons. So, my lord, it is not even a case that she has been turned out from the home. A transfer of property to be void in certain circumstances where any senior citizen who, after the commencement of the act, has transferred by way of gift or otherwise his property is subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor. As such transferee refuses or fails to provide such amenities and the physical need, the said transfer of property shall be deemed to have been made by fraud, or coercion, or undue influence, and shall at the option of the transferor be declared void by the tribunal. So, my lord, there are two elements to this. There must be a transfer. The transfer must record that it is in lieu of maintenance. And if there is a breach of, my lord, the condition of transfer, then only, my lord, 23 is resorted to.
Correct.
Then, my lord,
whether you find any document to show that the property belongs to father and
nothing. My lord, there was no prayer even under 23. My lord, because there could not have been a prayer because there is no transfer by, my lord, the senior citizen. Okay. Because, my lord, to invoke 23, there must be a document of transfer with a stipulation of maintenance. There is a judgment which says that if there is no stipulation of maintenance, but then it doesn't fall under 23. It is an unqualified gift or a transfer. It has to be a qualified gift to fall under 23. Then blood subsection 2 says, where any senior citizen has a right to receive maintenance out of an estate, and such estate or part thereof is transferred. The right to receive maintenance may be enforced against the transferee if the transferee has notice of the right, or if the transferee is gratuitous, but not against the transferee for consideration and without notice of right. But this is a very important blood. Although the Supreme Court tried to make a distinction qua the PWDV Act, but here independently what it says is that suppose a property is there.
Yes.
And the property is not transferred.
Correct.
With a right to receive maintenance is attached out of that estate. Then it can be enforced against the transferee. If the transferee has a notice of such right.
And that's
But if it is for consideration, no. But not against transferee for consideration and without notice of right.
The right to receive maintenance may be enforced against the transferee if the transferee has notice of
the right.
Or if the transfer is gratuitous, but not against the transferee for consideration without notice to right. Now kindly come to the paragraph 20, this judgment of Vanita.
Lordship.
Page paragraph 25. Paragraph 25, 1, 2, 3, 5, 6, 7, 8,
The
9.
substance of subsection 2 of section 23 as submitted by the second and third respondent is that the tribunal had the jurisdiction to pass an order directing the eviction of the appellant who is the daughter-in-law.
Correct.
According to the submission, the power to order eviction is implicit in the provision guaranteeing a right to receive maintenance out of an estate. But this is the submission according to the submission.
Yes.
And the enforcement of that right. In supporting the submission, they have referred to the view which has been taken by several high courts indicating that the tribunal may order the eviction of a child or a relative from the property of a senior citizen where there has been a breach of the obligation to maintain the senior citizen. The tribunal under the Senior Citizens Act 2007 may have the authority to order an eviction if it is necessary and expedient to ensure the maintenance and protection of the senior citizen or parent. Eviction, in other words, would be an incident of the enforcement of the right to maintenance and protection.
Yes. So they can
is-
take the recourse at the time of enforcement.
Yes. But suppose I do not pay.
Correct.
Then
Enforcement
the
right.
Supreme Court says that, well, you can take this recourse.
As like an attachment.
Not independently, not as my learned friend is trying to say. However, I'm not reading the other portions. That is immaterial for our purpose.
Yes.
So, coming back to the point that my learned friend has taken, in his application for maintenance simpliciter, the authority has gone, and assumed jurisdiction not vested to it by law by saying that, we have to vacate the property. And thereby, creating a ripple in the family. But that's all for me, sir.
Thank you.
But if your lordship, we have prepared a written notes, your lordship will kindly, have you printed it?
No, there's the section 3, my lord, which confers overriding effect on this particular act. So Mitakshara law has to take a backseat. And on facts,
we can consider that when there is a civil suit on that point.
That you go to the partisan suit, then the Mr. Mukherjee will take the override effect of
Roman 2, page 4, Roman 2. There's a pleading that your petitioner is the absolute owner of a 3-story residential building.
Page 4?
My writ petition.
Achha, your writ petition.
Page 4. There's an assertion that she is the absolute owner. This has not been denied in the affidavit.
Page 4, Roman 2.
Yes.
Husband of the petitioner passed away and Kansas. Petitioner is the absolute owner of the 3-story residential building. P1.
So P1 is, it has been rightly pointed out by this respondent, Malad, that is a wrong deed. This particular property was sold, but they have not disputed that the property in contention, Malad, belongs to my client.
ये जमीन किसकी है? ये जिसमें जो जमीन आप अभी जो आप रहते हैं, दुकान है, वो किसका है? मालूम नहीं आप वहाँ रहते हैं?
That
आप कहाँ पे टैक्स नहीं बनते? कुछ नहीं देता. बढ़िया.
Yes. Ever since her husband's death, nobody has been paying the taxes.
Okay. That's all. Thank you.
The written notes, my lord, I'm told it is ready. my
Give
lord.
to my court office.
But by tomorrow, my lord. By tomorrow.
Hearing concluded. CAV. Oh, कल उन रिटर्न नोट्स देंगे ना, इसमें रख देना.
But there's a order of Justice Sinha, my lord, September 9th, 2025, directing reimbursement of medical expenses in the ratio directed by the SDO. That is 2/3, 15,010. So that order is.
That was an interim order, my lord.
Yes,
but
that
now
has not
lord,
been
we have
complied.
already shown that we have
That has
given
not
the
been
payment.
complied.
पैसा दीजिए आप. वो तो दिसंबर में दिया, अभी आज कितना तारीख है? तो कब देंगे आप? मैं कल रखूं, मैं वो डेट में रखूंगा फाइल मैं केस. Nah, not say yes. Next.
But this is the order directing, my lord, reimbursement of medical
रख दीजिए उसको.
24th September 2025. In this writ petition. So
फाइल में रख दीजिए. Yes, call the
this
pastor.
nobody's case that they have made the payment.
3টা পাসওয়ার্ড ছিল 3 Hello, may I please the report, my lord? My lord, Hindi is very mellifluous, my lord. Should I give one copy to my learned friend, my lord?
Yes, give.
The first query is, my lord, এটা অ্যাডভার্টাইজমেন্ট হয়েছে দেখো.
Lord, the advertisement speaks that last date of the receipt of the application is 6th March 2026. That is far off, my lord. And then thereafter, my lord, the mental
No, in here the members have already been appointed.
except, my lord, only district nominee.
Huh?
Only district nominee. That is absent.
Correct. Now kindly come to the page 2. Page 2 in terms of 74B, mental health and also compliance of the order of the census and so. The state of West Bengal.
May be nominated by the principal secretary.
Yes. So now the principal secretary has to nominate the.
That will be done, my lord.
Done.
Query was of the court, my lord, in case where the district magistrate is not there, who will be the officer? That is answered.
Clarification has come now.
Right.
And, my lord, for that reason, my lord, they have given the advertisement, my lord. That is the page 3.
Correct.
And, my lord, that is, it is mentioned in the said advertisement, last date of receipt of the application 6 March 2026.
Correct.
And that is part of, my lord, because this matter is pending. It is a
No, earlier you stated that there was a committee, only this chairperson was there, but the special.
Yes.
Where is that? Where that has been superseded.
My lord, my lord, on 23rd September 2025, they have filed the report. And in the said report, they have said that till the selection of non-official member is completed for the majority of district, the other official member of MHRB of the district are requested to carry the function in respective districts under the respective chairman of the district.
Correct.
And the Milord, the district magistrate is the chairman of the district.
Correct.
And Milord, here, Milord, as because this is within the jurisdiction of the Calcutta, and the Calcutta is not functioning through the district magistrate, that is the
Not the
Joint
principal secretary, not below the
joint
rank.
secretary. A joint secretary ranked by the principal secretary will be nominated.
Yes, but that for that nomination, they have taken the period for Milord for 3 months, 6 March 2020.
Correct. It is a vast area. The publication is to be made.
Milord, because Milord, this is a petitioner is a person who is incapacitated, and Milord, 75% incapacitated, Milord. That
What can be done without the
it can be expedite, Milord.
Now the advertisement is on.
advertisement
It
is
will
already
further
made.
delay.
When the advertisement was made, 8th of January.
Right.
8 January.
Why so much? March?
March
2
is
months?
3 months, Milord. It's almost 3 months.
3 months? No, 2 months. February to
Possibly
January,
on the
February.
assumption that the number of applicants are very less. That might be the reason, Milord.
They may come with the, because this is a mere nomination, Milord, they may come with a proposal that the particular person who is acting as a joint secretary under the Department of Health and Family Welfare, Government of West Bengal, and Milord, that person can be.
So now you come to the district judge is already there.
Yes.
Correct.
Yes.
Representative of the district collector now they have given
Yes,
here.
everybody is there.
Now 2 members.
Milord, for members, this advertisement is.
Who shall be the person of mental illness? So this D is to be complied with.
Yes.
D is to be complied with.
Complied with.
So D is to be complied with. They have issued the notification, the publication.
Milord, I don't have any objection other than the Milord. This is for long.
What can we
He has also come late, Milord. He has come in 2025. I have not.
No, I have not come 2025. This is the second round of litigation, Milord.
No, the correct. So unless and until the member is not appointed, how the board can be constituted?
Milord, this advertisement procedure can be expedited.
Now they have published the notice. Now how the board can? How the court can?
Further complex things, Milord.
Now January is over. January is going to be over. February, March 8th.
Then, Milord, let this matter be appeared on March 7th.
So that is the 6th March. So I am fixing in the 2nd week of March.
And Milord will direct the secretary to file another report.
Correct. So now the 6th March the last date of receive of the application.
Right.
Yes.
Correct.
Yes.
So then if they will receive an application, then the process for appointment of the members. So I am fixing in the last week of the March, and I am directing the.
Milord, this is Milord. On 7th February, I have come before.
That's why I'm telling now that this court cannot go beyond the 6th of March. So what I pray, I will pass an order. So this court will pass an order. Okay, 6th of March is the last date of the application. This court hope and trust that they will appoint the member after receiving the application by 20th of March 2026, and let the matter appear on 24th of March 2026. By that time, the authority also, the special secretary will also nominate the member in terms of the order.
And Milord, a mental health review board will be functioning from Milord.
That's why once the 2 members will be appointed. So already the district judge is there.
Yes.
District judge is there. Now the principal secretary, joint secretary will come. The doctor is already there. Then his will.
It will be coming function, Milord.
That's why. Come on that. In terms of the order passed by this court dated 24th of December 2025, the Principal Secretary, Health and Family Welfare Department had submitted the report dated 9th of January 2026, enclosing an order dated 9th January 2026, wherein it mentioned that to compromise the Mental Health Review Board in Kolkata area, an officer in the rank of Joint Secretary and above, as may be nominated by the Principal Secretary of the Health and Family Welfare Department, shall be the member of the said. Full stop. In the said report, a paper publication is also enclosed, wherein the West Bengal Mental Health Chairman, West Bengal Mental Health Authorities have published a published a notice calling upon application in the prescribed format for appointment of 2 members in terms of section 74 within bracket small d of the Mental Health Care Act 2017. Full stop. Learned Counsel for the petition submit that the authorities have fixed the last date of receipt of the application on 6th of March 2026, which is far away and which is about more than 2 months, and he prays for shorten the date of receipt of the application so that the matter can be expedited. Full stop. Heard the Learned Counsel for the party. Full stop. Learned Counsel for the state submit that the taking into consideration that application is to be received by the department, accordingly 2 months time has been given for receipt of the application. Consider the submission made by the counsel for the respective parties. This court find that the parties, in terms of the order dated 9th of January 2026, the Principal Secretary of the Health and Family Welfare Department is directed to immediately appoint an officer in the rank of Joint Secretary and above as member in terms of section 74 within bracket B. No, 74 within bracket B of the Mental Health Act 2017.
74 within bracket D.
Yes, 74 B.
B to B.
B. Representative of the district collector.
Yes.
Full stop. This court hope and trust that on receipt of the applications on 6th of March 2026, the Government of West Bengal, Department of Health and Family Welfare shall constitute the committee in terms of section 74 of the Mental Health Care Act on or before 20th March 2026. Let the matter appear on 23rd of March 2024. The Principal Secretary is directed to submit further report on the date fix.
We are grateful. It is my lord's hope and trust that we are doing active things in this matter. Yes, we are grateful.
Because I had dealt with the administration. If we direct, then they will.
Very difficult. There's so much of job also will not assigned to them. Yes. Everything is important.
All the things is to be seen.
We are grateful.
Yes, next. 12 noon.
Item number 13. Just immediately after the election, the file is not here.
Yes.
It appears.
File is not here.
File is not here.
So this is the third occasion.
Where is the file?
Because we are doing the material also before this honorable court only.
It may be because what has happened earlier, 2 officers, some file is gone here and there. Then they are searching the file. When it will, they are searching the file. It will be, let it be remain in the list. If it is remain in the, let the remain in the list. I am not touching the. Yes, call the list.
Item number 14 is relating to the electricity.
Let the fix. Yes.
Item number 14 relating to electricity matter.
14 to
14. I am 14 and 15. Both are electricity matter.
14 and 15 also.
I am only for 14, my lord. 14 and 15.
14 file. Okay, 14 is electricity matter. You are for the petitioner.
Well, I appear on behalf of
Record an order. 14. The counsel for the petitioner submit that the matter is connected with grant of electric connection.
Sleep due to the
accordingly, WPA number 13263 of 2025 is released from the list of this court with the liberty to the petitioner to with the liberty to the parties to mention before the appropriate court having determination. Yes.
15 also, my learned friend is
15 is also electricity.
Yes.
Same order. Read petition number. Yes, call the fixed matter.
Please, my lords, I appear for the petitioner. My lord, may I apprise my lord of the subsequent developments since the last date's hearing.
But Lordship knows that
Yes,
Lordship knows that an interim order was passed, and there was a one-time settlement by which we were supposed to make payment of 81 lakhs by 31st December. Lordship had extended the interim order till the 6th of January. Now, the payment could not be made because of reasons which now we'll be putting on supplementary, because our buyer backed out at the last moment.
Yes.
Well, at 31st, we were supposed to make the payment. On 30th night, State Bank of India, which was our buyer who was going to make that payment, they backed out. So we couldn't make the payment. When the matter came up on the 6th of January, Lordship, we are left with the option of arguing the matter on merits.
Yes.
Now, Lordship, as I'm told, my lord, I was on legs before another honorable court. My lord, Mr. Mukherjee was there. We were all ready to argue, but there was paucity of time. But Lordship did not extend the interim order. Now, my lord, the consequence of that would be that they would immediately make the matter infructuous by taking possession of the asset. Now, they sought to do that. So we had to file an appeal before the Honorable Division Bench. And, my lord, by an order dated 8th January 2026, Lordship, this order was passed.
Yes, creating any third party interest.
Lord,
now, paragraph 17 also, the appeal is not maintainable, yet, my lord, the division bench.
My lord, on grounds of equity.
Because the matter is fixed today for yet.
My lord, now, Lordship, after this, what was Lordship one submission which I must make? And I don't attribute anything to any counsel here, but the submission made before the Honorable Division Bench was that everything relating to 13.4 has been done. But we checked up the newspapers, we did not find any publication. We now find that the publication was made after the order of the Honorable Division Bench, whereas the Honorable Division Bench was told that all compliance relating to 13.4 had already been done, and that is recorded in the order. Now, my lord, that is the first extent of mala fide. Now, we raise certain issues regarding the 13.4 notice because the period for disposing of the representation under 13.3A has not expired, because it was all under an order of injunction, the entire process. Without waiting for the 60-day period, more than 27 days were left, the 13.4 notice has been issued. Now, we raised this when the order was being passed before the Honorable Division Bench. Lordship will see.
Now you leave aside all these things.
Lordship, we'll argue the matter on merits. I'm only, Lordship, submitting that in my submissions, Lordship, I shall also cover the legality of the 13.4 notice, because it's a consequential act, and the Honorable Division Bench has given us the liberty to raise this issue before your Lordship. Now, my lord, may I start with the merits of the matter?
Yes.
Give me the following one. Now, my lord, may I indicate very briefly the factual background? My lord, the petitioner this is a company which used to carry on its business by obtaining letters of undertaking. Now, Lordship, the business was a successful business, been going on for several years. And in 2013, to further expand, they obtained credit facilities from the respondent bank. Now, Lordship knows in 2018, the Nirav Modi scam came to light. The entire scam was centered around letters of undertaking procured by Nirav Modi. The immediate consequence of that was all letters of undertaking ceased to be issued. That immediately crippled my business. Now, Lordship, there was also a financial downturn at that time, so my business suffered. Till that time, there was absolutely no allegation or no instance of default of any kind. A very bona fide businessman, bona fide loans, bona fide repayment going on. Now, because of this situation, there was a downturn, there's a fall in our business activities. Well, accordingly, a situation was reached where we had to seek restructuring of the loan. Now, Lordship, one very important factor here is I did not seek any other benefit save and except requesting for reduction in the rate of interest. On 7th March 2020, the respondent bank very fairly granted me a reduction in the rate of interest to about 10%. But this restructuring was done with the idea that the normal situation would prevail. This was the 7th of March 2020 and the 3rd week of March 2020, Lordship knows COVID came. Because of all the restrictions and because of all the lockdowns, etc., our business again got crippled. So whatever recovery we were making in the business, that got completely wiped out. Now, as a result of that, Lordship, we again requested for some facilities. Now, at this time, Malad, the Reserve Bank of India came out with several circulars. One was a resolution framework for restructuring of loans because of the stressed situation of borrowers, especially in our case, Lordship, this is an MSME. So for MSME enterprise, they were the hardest hit. The big businesses did not suffer in reverse, the MSME suffered.
So you want to take the advantage of the master, this MSME?
Malad, yes, at that time, Lordship.
And 2017.
Lordship, at that time, there were notifications for restructuring of the loan, and also there was a scheme called the ECLGS, Emergency Credit Guarantee.
Which year?
Malad, this is all in 2020. Now, Lordship, I must indicate I'll take 5 more minutes at the most. Otherwise, Lordship, the premise under which the writ petition came to be filed, Malad. So we applied for ECLGS loan. Now, this is the first stage from where the mala fide starts on the part of the bank. It appears that they are not interested in recovering the money. They are interested in harming my business. What they do is, they do not give me the ECLGS loan. In fact, I make an application, that application never disposed of. I've taken those grounds in my writ petition, even though there's no prayer, because really speaking, it became infructuous, that nothing could be gained because that period went. So I suffered. Then they renew my credit facilities on each occasion, increasing the rate of interest. And now claiming that they will impose penal interest, penal charges. Now, the imposition of penal charges here, now we come to the issue of penal charges. That is also governed by RBI circulars, which are annexed to the writ petition. There was a lot of complaints by borrowers as to how banks were prejudicing borrowers deliberately by hanging the bogey of penal charges, which is why RBI came out with a circular saying that it had to be done in a very fair manner. There cannot be additional interest. There cannot be penal interest. You can levy a penal charge, but in a fair manner. That is what has been violated here. Now, Lordship will see how. Despite all these things happening, despite COVID, I continued making payments. I've annexed the proof of payment. I've given my bank statements. There were minor delays here and there. But Lordship, a time came where there was some default. Malad, we are at the stage of May, June 2023. Malad, I was told that my account will be out of order and I had to make all payments and regularize the account, which I did, admittedly. Now, Lordship will come to the next renewal of my credit facilities, that is 29th November 2023. Now, Lordship, being cognizant of my financial situation, COVID, everything, rate of interest is increased from 10.05% to 16.35%. Unfair. Now, despite that, Lordship, we have no choice because we have to go on paying. We have to run a business. This caused immense difficulty for us in servicing the account. Nevertheless, we continued. Now, Lordship, the first document which I'll really stress on. Now, everything, Lordship, I've said is pleaded in the writ petition. Lordship will see the relevant documents. When I'll give a short note, Lordship, all these points I've made, I'll indicate the page numbers. Now, the first document, Lordship...
What is the main ground?
Lordship, now, I'm coming to that, Lordship. Now, Lordship will kindly see page 179 of the writ petition. That is in volume 4 of the writ petition. This is an email from the respondent bank.
NPA.
That your account will slip into NPA.
So this is
now
this is issued on 19th of June.
19th June 2024.
And informing you that on 24th June it will be NPA.
NPA. Now, Lordship will kindly turn the page to 180. It's the same official of the bank.
Correct.
I made some payments thereafter, but I received this on 28th June. I'm asked to pay 40,000 on 28th June, and I'm told that on the next date, which is 29th June, I have to put 5.80 lakh. My lord, now this is the bank's communication telling me this is what I need to do in order to avoid facing NPA declaration.
Regularization of
Lordship. Now, Lordship will see page 181.
Yes.
I make, Lordship will see, this is my statement of account.
Have you deposited?
I have deposited. Lordship will see all the entries that I have.
Where?
My lord will see on page 181, 40,000. Then 1,95,000, 2,000, 55,000, 2,75,000, 41,000.
So these are total deposit.
I deposit.
These are deposit.
Lordship.
These are the deposit.
These are the deposits.
Correct.
Now, Lordship, I admit, I understand. If there is a shortfall in this, the bank would tell me there is a shortfall. You please put in. Very well, not told. They told me an amount, I deposited it. Now, Lordship, what happens? Lordship will see in the previous email, the previous WhatsApp message from the bank, 30th is Sunday. Now, Lordship, in that period, without any intimation to me, because that is the bank's communication the previous day, 14,58,000 and 1,03,287 are arbitrarily deducted.
This has been deducted.
Lordship will see the two entries at the bottom on page 181.
Correct. It is deducted by the bank.
This is deducted by the bank. This causes my credit limit to get overshot. There is absolutely no communication, no breakup given to me of this amounts being deducted and on what account. The previous day, the bank communicates to me that that is the amount you need to pay, I deposit it. And then these two amounts are deducted and they immediately declare me NPA.
Correct, but now come to 779. Now come to 179.
Lordship.
Your sanction loan amount was 6 crore 50 lakhs.
Lordship.
Correct.
Lordship.
That is the same. 50
Lordship.
Yes. So overdue as on 10th of June 2024, 6 crore 66.
Lordship. Lordship.
Correct. Outstanding.
Lordship.
And like that. So these are the outstanding. If the 6 crore and 6 crore 66 lakhs overdue. So what is the amount you have to pay for the regularization?
Malat, this I was told that the account had to be serviced with certain amounts at certain points of time. I had a maximum limit of, I think, 10 crore.
Correct.
I had to keep servicing the account.
Correct.
I am not supposed to pay out the entire amount because that was
That's
never.
why you have to maintain certain accounts.
Lordship,
So that you can
Lordship,
continue with
Lordship.
your
So
credit facility.
Lordship. So I ask the bank, what am I required to pay now to keep it regular? And this same official of the bank informs me that you pay 5.80 plus 40,000.
Okay, then these two amounts.
I deposit it. Then, Lordship, this 14,58,000 and 1,03,000 are deducted.
No
I don't know on what account.
Correct.
And they declare me as NPA.
Correct.
So finally, Lordship, I approach this court. I first give representation. I speak with them. I visit the bank. I am then told, and this is pleaded because the bank refused to give me anything in writing, that this is on account of penal interest or additional interest. Now, upon further pestering the bank, they give us a document. Lordship will see
What will
volume.
happen after deduction? What you file the rate application?
Well, after the declaration, immediately thereafter, I gave the representation not considered. I filed the writ petition because the real ground in my writ petition, Lordship will see from the fact, is not the servicing of.
This is a writ petition.
This is the writ petition, not the principal per se or the regular interest, but really the additional interest, which I will now show from the RBI circulars, is violated. So that was the ground on which I filed the writ petition. I made out a prima facie case.
And
Lordship.
How you are telling that it is violated?
Well, then may I place the RBI? Shall I show the?
That's why which provisions you are
Yes.
telling that it is violated?
Malad, there are circulars. One is with respect to what is the period of time you have to give to a borrower before you can declare someone NPA. Now, there is a 90-day period.
Now, your latest judgment of the Supreme Court you have gone through. Sri something.
Malad,
Earlier judgment, Pronit, it is stated that it is not upon the bank, it is upon you, it is upon the bank.
Lordship.
Subsequently, the latest judgment of the Supreme Court clarifying that no, it is the petitioner who has to approach along with an affidavit. Then it can be.
Malad has to approach. Malad, I'll go through it, but has to approach Malad in the sense.
Bank with regard to getting the MSME for the framework under the framework.
Malad, my email requesting for ECLGS under the COVID circulars is annexed, not considered, never disposed.
When you have applied, that's
Malad, that was in within the period, the ECLGS period in 2020. But Lordship, today for me to
what was your prayer in that revival framework?
No, Lordship, now the
consideration of the revival payout of the January 19 on March 2016.
Malad, as far
which benefit you want?
Malad, I am alleging I do not want any benefit at all. I am simply saying, Lordship, that the declaration of NPA is bad in law because, first instance, the manner in which the penal interest and charges have been imposed on me and the debit was made is without jurisdiction because they are violative of 2 RBI circulars. Now, these 2 RBI circulars are not COVID circulars. These are, Lordship, will kindly see, first, Lordship will see page 54, that's in volume 2. Where is volume? I don't have it.
54.
Lordship. Malad, it starts at page 52. May 8, 2023. Then Lordship will see the contents, page 53, and then Lordship will come to page 54. Clause 2, non-performing assets.
Yes.
2.1, classification of assets as non-performing. 2.1.1, a non-performing asset is a loan or an advance where interest and or installment of principal remain overdue for a period of more than 90 days in respect of a term loan. 2, the account remains out of order. 2, and the second footnote is there. In respect of an overdraft, cash credit and all other loan products being offered as an overdraft facility, including those not meant for business purposes and which entail interest repayment as the only credits. 3, the bill remains overdue for a period of more than 90 days in case of bills purchased, etc. Now, Lordship, this 90-day period will come to the footnotes. Lordship will see footnote 1 first. Any amount due to the bank under any credit facility, if not paid by the due date fixed by the bank, becomes overdue. So first is, I ask the bank, what do I need to pay now? I am told, you please pay 5 lakh 80,000, 84,000, and it's done. Very well. I deposited. So that is satisfied by me. Now please come to footnote 2. An account should be treated as out of order if the outstanding balance in the CCOD account remains continuously in excess of the sanctioned limit drawing power for 90 days, or the outstanding balance in the CCOD account is less than the sanction limit, but there are no credits continuously for 90 days, or the outstanding balance in the CCOD account is less than the sanction limit, but credits are not enough to cover the interest debited during the previous 90 days period. Now, my lord, what happens here is, at that terminal date when I'm asked to make the payment, I make it.
No, the
Lordship.
outstanding balance of CC or OD account, so your cash credit account, not
Lordship.
OD account.
Lordship.
Correct. Account is less than the sanction limit, drawing power, but there are no credit continuously for 90 days, or the outstanding balance of CCOD account is less than the sanction limit, drawing power, but credit are not enough to cover the interest debited.
Lordship.
So if
Lordship.
if assuming the interest which the amount you have deposited and they have
Lordship.
debited that amount,
Lordship.
which in spite of that the interest which have been accumulated that has not been completed, so how you will be benefited by this
My lord, in that what would happen in this case, this interest which has caused my default are the two debits on 30th June of 14 lakhs. Lordship will see that those two amounts I will show from the statement.
That's why now the quantum is to seen, because your main first argument is that this two amount has been deducted.
Lordship.
Correct.
Lordship.
14,58,000 and 1,03,280.
Lordship.
So now the bank has come with the plea. These are the deduction of the penal interest.
Lordship.
Correct.
Penal charges / interest.
Interest. Now penal charges interest. Now it has to be corroborated with this II.
Lordship.
II.
Now first, and I will show the other circular with regard to penal charges. This does not and cannot cover penal charges. This provision cannot cover the penal interest and the additional interest, because I will show from the bank's own statement, which they gave to me subsequently, that this deduction is made as penal interest, additional interest.
So it cannot be a penal interest.
It
is
cannot
a
be
simple interest.
interest. Now that I'm asked to deposit and I've deposited.
Okay.
Now, Lordship, if let's say something more had to be paid, when I ask the bank and the bank tells me 40K today, 5,80,000 tomorrow, they could have told me no, it's 10 lakhs tomorrow. If I could have paid, my lord, well and good. If I could not have paid, the consequences would have followed. But I am indicated a specific quantum from the bank. When I approach the bank to ask the bank how much should I deposit, I am told a particular amount. I deposit the particular amount, and then without any notice on a Sunday night, two amounts are deducted. My lord, that is the first mala fide on the part of the bank without jurisdiction in violation of the RBI circulars. Now, may I show the other RBI circular? Lordship will kindly come to page 91.
Yes.
August 18, 2023.
Correct.
Fair lending practice, penal charges in loan accounts. My lord, this may I please place at least a few 5-6 paragraphs at least, my lord.
Yes.
Reserve Bank has issued various guidelines to the regulated entities to ensure reasonableness and transparency in disclosure of penal interest. Reasonableness, one, Lordship, not giving an information is the first breach in the reasonableness principle. Transparency in disclosure of penal interest. Next, no transparency here, no prior intimation, and no breakup given even at the time, even though I was in touch with the bank. So first two conditions violated. Under the extant guidelines, lending institutions have the operational autonomy to formulate board-approved policy for levy of penal rates of interest. It has been observed that many regulated entities use penal rates of interest over and above the applicable interest rates in case of default / non-compliance by the borrower with the terms on which credit facilities were sanctioned. 2. The intent of levying penal interest / charges is essentially to inculcate a sense of credit discipline, and such charges are not meant to be used as a revenue enhancement tool. And that is exactly what has been done here. Third violation, over and above the contacted rate of interest. However, supervisory reviews have indicated divergent practices among REs with regard to levy of penal interest charges, leading to customer grievances and disputes. This circular was intended to prevent what the bank did in my case here, and that is after this circular. So fourth violation. Number 3, on a review of the practices followed by REs for charging penal interest charges on loans, the following instructions are issued for adoption. 1. Penalty if charged for non-compliance of material terms and conditions of loan contract by borrower shall be treated as penal charges and shall not be levied in the form of penal interest
that is added to the rate of interest charged on the advances. There shall be no capitalization of penal charges, no further interest computed on such charges. However, this will not affect the normal procedures for compounding of interest in the loan account. Give me that volume 4, last page.
Yes.
Now, Lordship. 2. The RE, now this has been precisely what has been violated in this case. Now, how this interest came to be computed has not been provided to me till date. So that itself is a violation, non-transparent. The RE shall not introduce any additional component to the rate of interest and ensure compliance to these guidelines in both letter and spirit. And that is exactly what has been done. Now, may I show at this juncture, my lord, may I just place this before that? My lord, after this, Lordship will see 3. The RE shall formulate a board-approved policy on penal charges, similar charges on loans by whatever name called. I am not aware of this. This should have been communicated to me in any case, not done. 4. The quantum of penal charges shall be reasonable and commensurate with the non-compliance of material terms and conditions of loan contract without being discriminatory within a particular loan product category. The penal charges in case of loan sanctioned to individual shall not be higher. I am a non-individual borrower, so that's all right. The quantum and reason for penal charges shall be clearly disclosed by REs to the customers in the loan agreement, and most important terms and conditions are as applicable in addition to being displayed on RE website under interest rate and service charges. Whenever reminders for non-compliance of material terms and conditions of loan are sent to borrowers, the applicable penal charges shall be communicated. My lord, where is the communication for 14,58,000 and 1,03,000? Where is the communication, Lordship? If I may put my submission in the form of a question. In my loan agreement, terms and conditions are given. I am in communication with the bank. The bank is informing me specific amounts to be deposited. Where is the communication of 14,58,000? Now, Lordship kindly comes to page 205 of volume 4.
Yes.
Lordship will see when I kept asking them for breakup of what is this charge, how did you compute? This document is the only document which was given to me. This is dated. Lordship will see top right left hand corner of the page. Penal interest is the heading. Lordship will see at the top left hand corner of the page. At the top left hand corner, Lordship, it says penal interest. Well, at page 205, Lordship.
205.
Lordship.
Yes. Penal interest.
Penal interest.
Yes.
Account level interest.
Yes.
The date is 1st August 2024,
Correct.
evening of 6:23 p.m. Here, Lordship, no breakup is given as to how the computation is done. What is told to me is on what account the debits have been made. Lordship will see the different headings. There's a heading for normal interest, and under that, account level interest. So that normal interest, how it has been accounted for, the date and the interest amount. Lordship will thereafter see another heading called additional interest.
Yes.
That could not have formed part of the 90-day period issue at all. That is not permitted because, Lordship, I've read the circular at page 91, no additional interest. Now, Lordship will see another heading. Thereafter, the next heading is normal interest. Thereafter, the heading is penal interest. Again, you can't levy it as interest. And Lordship will see under the heading penal interest, at the extreme right-hand corner entry, there is an interest amount.
Yes.
So you cannot levy that interest on me. Now, this is in respect of debits made. Lordship will see the start date and end date between 27th June 2024 and 30th June 2024. Now, Lordship will see.
Where you found it? Acha, 30th June.
Lordship will see the start date and the end date.
Yes.
We are, Lordship, concerned with the last 3 entries. These are the ones I'm aggrieved by. Lordship will see the headings. First is additional interest, next is normal interest, and the last is penal interest. Now, all these three deductions, two of these three deductions are in violation of the RBI circulars. And in any case, they are not reasonable or transparent because those are the conditions given by the Reserve Bank. Because no intimation to me. Intimation was 5,80,000 and 40,000, which I deposited, admittedly. And Lordship will thereafter see the total computation. Total normal interest, Lordship, an amount is given, 8,98,000. Now Lordship will see total penal interest, 1,09,000.
That is a penal interest.
Total additional interest, 2,000. Malad, even 1 rupee could not have been imposed.
Correct.
And the same with penal charges. Now, Lordship, even granting everything and all benefits of doubt to my learned, to the respondent bank, my lord, the first requirement under the page 91 circular was that it has to be transparent and reasonable. My lord, these are essential elements of public law being imposed on this bank through a statutory mechanism. Our Lordship knows all such instructions, guidelines, circulars issued by the Reserve Bank of India have statutory force.
Correct.
So, Lordship, therefore, this is what led me to first approach this Honorable Court. The NPA declaration, now a lot may be said, Lordship. I will deal with the submissions of my learned friend on maintainability as and when my learned friend cites them. I have judgments in my favor of this Honorable Court itself, that here Lordship will see that the violation has happened before. My cause of action is an act prior to the NPA declaration, which lets me approach your Lordship for appropriate relief under 226. The NPA is merely a consequence of a void, illegal, DHOR statute and constitutional.
The question is that the deduction, the charge of penal interest or addition is whether it is in accordance with law. If it is not accordance with
Lordship, my last submission on this, Lordship, will be it can never be in accordance with law because Lordship, even if they could have imposed this, let's say the circulars weren't there, the first circular wasn't there. As per the second circular, they were supposed to inform me. You inform me something else.
Right. This court is
And
telling whether
Lordship,
in accordance with law,
Lordship,
including all.
and the next reason why this can never be legal is because that breakup has not been provided to me till date. How the computation was arrived at, not given to me till date. Despite the approaching the bank, despite the writ petition, despite orders being passed.
Okay.
Malad, may I will take 15 more minutes. I will just place my judgments and I'll be done with it. Malad, whenever my lord pleases.
Counsel for the petitioner has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on. When?
As your Lordship pleases.
Malad, can we tomorrow also, Lordship? I'll finish.
Learned friend says, 15 minutes,
I can finish tomorrow also, Lordship will grant me.
How much time will take?
15-20 minutes.
कल कितना मैटर है अर्जेंट मोशन में? क्योंकि आज तो कुछ हुआ नहीं है. कल कितना मैटर है अर्जेंट मोशन में? हाँ, कल 16 है ना, 2 है और यहाँ का 40 ठीक है. Under the heading,
Let it come tomorrow, Lordship. Malad, the subsequent documents, Lordship, I've put in a supplementary just for this. It's already with my learned friend, but I'm still giving an advance copy right now. And that I'll file it, Lordship, tomorrow because it's not been affirmed yet. I'll file it tomorrow. I'm giving a copy to my learned friend, senior friend. Grateful, man. Grateful.
Yes.
तो आ गया hey, इस तरफ आ इस तरफ जा My lord, my learned friend is appearing for FSSI and I am appearing for the Union of India, for the Ministry of Agriculture and Ministry of Health.
So you are for the Union of India.
I am appearing for respondent numbers 1 and 4.
I am for 2 and 3, my lord.
4 is Ministry of Agriculture. And 2 and 3,
Agriculture was that.
you are appearing for the 1 and 3.
Oh, yes.
And
2
2
and
and
3,
4.
No, but
He's appearing for
2 and 3.
2 and 3. 2 and 3, Food Safety and Executive Officer Food Safety. You are appearing for the Food Safety Authority.
Yes.
So affidavits filed. Okay.
Affidavit, in fact, I have filed an affidavit for Ministry of Agriculture also.
Okay.
2 affidavits I have filed.
Hey, affidavits. Where is the affidavit?
Affidavit gulo koi.
Hai na? Yes.
May I start? The subject matter of challenge in the writ petition is an amendment made by the. Sorry.
The next item is of mine. 2 p.m.
Yes.
No, this is in regard to admission. Anyhow, well, from 3 p.m. probably losses will take up original segment. Now tomorrow we are in very difficult situation. Interim order is also till tomorrow. The interim order, though we have got your losses, that affects the respondent school also because of mine. To that extent, that the admission could not be completed because of the issue I have raised, the discrimination on sex. Now, whatever to do your losses, because tomorrow will be first up the Chief Justice. Then probably your losses will leave the Calcutta.
Tomorrow, second up, would your lordship be?
No, I am here.
Your lordship is here. Very
Lord, I am appearing on behalf of the respondent 11. That is
Yes,
a girls' school.
with respect to this court, there is no problem. I am here till
No,
4:30.
very well, man. Very well, man. Then
Tomorrow you lost.
continue.
I will write.
Then okay.
If otherwise, no,
সুবিধা
I am here.
আমার কালকেও ফিক্সড আছে এটা
My lord had fixed this matter for both
today and tomorrow.
Then again I will be. Let's see your loss.
No, what I if it is not Mr. It will taken continuous, so it will taken tomorrow as at the top. Your matter. And the
losses take up at 10:30 tomorrow. 10:30 will
not after 11:30 only. After the oath.
Later understood. My learned friend is also.
Yes, after the oath I will be here, so it will be taken tomorrow.
Grateful, man.
11:30 your losses. Otherwise it not.
11:30. At the top I am keeping. At the top I am. Item number 7 है ना? 6 ना? Item number 6.
6 no. 7.
Item number 7. Item number 7 कल जो अर्जेंट मोशन में टॉप कर देना. अर्जेंट मोशन में टॉप कर.
My lord, as I was submitting that the subject matter of challenge in this writ petition is an amendment made to, my lord, Food Safety and Standards Prohibition and Restriction on Sales Regulation 2011 by, my lord, the Food Safety Authority, or if I may use the expression FSI, with a notification dated March 8, 2021. But the effect of the amendment is this, my lord, before I take your lordship to the relevant documents, is that there would not be any sale of blended edible vegetable oil. Well, we use the acronym BEVO, blended edible vegetable oil, or BVEO or BEVO, whatever it may be, my lord, which will have, my lord, this mustard oil as one of its ingredient. That's the effect of the amendment. Now, my lord, I will take your lordship to through the, my lord, the decision-making process, how this amendment was brought about, and my lord, how, my lord, the authorities deliberated on the issue, and I will try to demonstrate before your lordship the amendment does not achieve any does not have any rational nexus sought to be achieved by the Union Parliament in the Act itself. And that would be, my lord, the amendment is discriminatory, as the classification which has been brought out is, my lord, irrational and offends Article 14 of the Constitution. Additionally, my lord, the amendment also fails the test.
you?
But I am a manufacturer. I was manufacturing, my lord, this Bevo containing mustard oil prior to the commencement of the amendment rules.
What the amendment says now?
Now the amendment says that you cannot manufacture Bevo with mustard oil in it. For domestic. That is for domestic. Fasai obviously will have the other imported consignments, but I am on domestic also only. But I am making it very clear at the very outset that I manufacture other oils also, edible oils. But this also was one of my product, which was one of the key product which I used to manufacture and which attracted huge sales. So, this is the impact aspect. But more importantly, the issue which requires your lordship's kind consideration, subject to lordship, whatever your lordship would finally decide, is that whether this amendment is based on any intelligible differentia or not. So, what I have done for the lordship's kind consideration, I have prepared a compilation of the relevant documents according to me. But this is nothing new. This is from the pleadings itself. I have brought this compilation, that a copy. But this is for your lordship's kind consideration. I have also got copies for my learned friends also. So, I will take your lordship through this this compilation.
Yes.
But before I take your lordship through this compilation, may I take your lordship to the relevant provisions of the Food Safety Act or the Food Safety Act? Kindly take, my lord, if your lordship has the book.
I don't think so.
I am handing my book. May I just? Act. একটা বার করে দেবো, একটা বার করে দাও।
ফাইলের সাথে বই ছিল, বই আছে কোনো?
ফাইলের
সাথে কোনো বই আছে?
ফাইলের সাথে কোনো বই
আমি দিয়েছি,
দিয়ে দেন।
বই চলে গেছে বাড়িতে। So, may I take your lordship to the Food Safety Act?
Yes. 2006.
Yes, madam. Well, kindly take the definition of food, which your lordship will find at
3J.
2J.
3J.
3J. I'm sorry, 3J. So, my lord, this is my lord. The definition contains includes a wide variety of products, food products, and also the proviso to the definition empowers the central government to declare by notification any article as food for the purpose of the act having regards to its use, nature, substance, or quality. But I am not taking your lordship to the entirety of the definition, which may not be germane at present. Kindly take the next definition, that is food additive. Well, food additive has been defined under 3K, clause 3K.
Yes.
Now, Miller, kindly now take M, 3M. 3M would mean
Food authority.
Food authority.
Yes.
Now, Miller, now kindly take now, directly come to section 4. I'm sorry, my lord, before I take your lordship to section 4, kindly take 3ZC. Which defines manufacture. Manufacture, this I must read out to your lordship. 2ZC, 3ZC, I'm sorry, 3ZC. Your lordship has got that? 3ZC defines manufacture to mean a process or adoption of any treatment or any treatment for conversion of ingredients into an article of food, which includes any sub-process, incidental or ancillary to the manufacture of an article of food. Manufacturer has been defined in section 3ZD. But the petitioner is a manufacturer under section 3ZD. Yeah. But the manufacturer has been defined to mean a person engaged in the business of manufacturing any article of food for sale and includes any person who obtains such article from another person and packs and labels it for sale or only labels it for such purposes. I am not troubling your lordship with the other, my lord, definitions. Food safety. Kindly take, my lord, along with this, food safety. That is 3Q. But food safety would mean assurance that food is acceptable for human consumption according to its intended use.
Correct.
So, my lord, these are the definitions which are relevant. My lord, along with this, kindly take, my lord, section 4, which provides for establishment of the food safety, my lord, FSI. If I may use the acronym.
Correct.
Now, my lord, section 5 provides for, my lord, the composition of FSI.
Yes.
Who should be the members of FSI? Now, I am not troubling your lordship with the other provisions. I come take your lordship directly to section 13. Because, my lord, this would have an impact in this matter.
Section 13.
13, 1-3. Scientific panels.
Yes.
May I read it out for your lordship's kind consideration? The Food Authority shall establish scientific panels which shall consist of independent scientific experts. The scientific panel shall invite the relevant industry and consumer representatives in its deliberations. Without prejudice to the provisions of subsection 1, the Food Authority may establish as many scientific panels as it considers necessary in addition to the panels on, my lord, what are the defined functions? Defined functions, my lord, is food additives, flavoring, processing aids, materials in contact with food. Then, my lord, pesticides not relevant. Then, my lord, functional foods, nutraceuticals, dietetic foods and other similar products, biological hazards, contaminants in food chain, labeling, method of sampling and analysis. We are concerned with basically A.
Food additives.
Food additives, flavorings. Food additives, flavoring, processing aids and materials in contact with food. Now, my lord, section 14 is also relevant, which provides for constitution of
Scientific committee.
Scientific committee. So, my lord, scientific panel is different from scientific committee. Kindly take
Committee is different and panel is different.
Scientific panel is different from scientific committee. Section 15 provides for the procedure for scientific committee and scientific panel.
Yes.
But the subsection 1 is, my lord, basically the tenure of the panel. Your lordship will find that.
Yes, period of 3 years.
Period, appointment and period.
Correct.
Then, my lord, subsection 2 is, my lord, how the panel is to be constituted. Subsection 3, my lord, provides for the quorum. My lord has got that. Subsection 4 provides for the procedure for operation and cooperation of the scientific committee and the scientific panel would be specified by the regulation. So, my lord, the panel and the committee would have to act in tandem. There must be some kind of, my lord, collaboration, some kind of, my lord, meeting of minds, if I may say so. Subsection 5 provides for the procedures. This is regarding the working groups, etc., etc. G also, G may be relevant.
So these are the procedure to be taken into consideration for
Yes, ma'am.
constitution of the
I will not
committee,
trouble your lordship.
committee and panel both.
Yes, ma'am. Now kindly take section 16.
Yes.
I will not trouble your lordship with the entirety of section 16 for the present purpose. Kindly come directly subsection 5 of section 16. Straight away.
Yes.
The food authority may, from time to time, give such directions on the matters relating to food safety and standards to the Commissioner of Food Safety, who shall be bound by such directions while exercising his powers under the Act. So, my lord, the vests the food authority with the power to give directions, and those directions would be binding.
Correct.
Now, my lord, kindly take now section 18. The general principles of food safety.
Yes.
18, 1-8.
Yes.
So, Malad, the policy and guideline for administration of the Act is basically laid down in section 18. General principles to be followed in the administration of Act, the central government, state governments, the food authority and other agencies, as the case may be, while implementing the provisions of this Act shall be guided by the following principles. My lord will kindly take, I will not trouble your lordship with the entirety. Kindly take, my lord, 18(1)(c) first. Where in any specific, my lord has got that?
Yes.
Where in any specific circumstance, on the basis of assessment of available information, the possibility of harmful effects on health is identified but scientific uncertainty persists, provisional risk management measures necessary to ensure appropriate level of health and protection may be adopted pending further scientific information for a more comprehensive risk assessment. Let me kindly take clause D also. The measures adopted on the basis of clause C shall be proportionate and no more restrictive of trade than is required to achieve the appropriate level of health protection, regard being had to technical and economic feasibility and other factors regarded as reasonable and proper in the matter under consideration. Then E, the measures adopted shall be reviewed within a reasonable period of time, depending on the nature of risk to life or health, being identified and the type of scientific information needed to clarify the scientific uncertainty to conduct a more comprehensive risk assessment. In cases, cases where there are reasonable grounds to suspect that a food may present a risk for human health, then depending on the nature, seriousness and the extent of that risk, the Food Authority and Commissioner of Food Safety shall take appropriate steps to inform the general public of the nature of risk to the health, identifying to the fullest extent possible the food or the type of food, the risk it may present, and the measures which are taken or about to be taken to prevent, reduce or eliminate that risk. If on a conjoint reading of clauses C to
F,
but it would appear A, my lord, for a risk assessment process, scientific study is relevant.
Correct.
Or would be necessary. While carrying out the scientific study and while carrying out this risk assessment process or risk management process, it would be also necessary to bear in mind the impact on economy and the principles of proportionality. It should not be, preferably it should never be a absolute ban. There may be some restriction. But that is my humble reading of the different clauses, starting from clause C to clause F. Clause F is basically an exception to the extent, my lord, where there is an imminent danger. But it's a case of clear and present danger, as we perceive of. It's a case of clear and present danger. Now, my lord, I take your lordship directly to section 92, which is the rule-making power. regulation making power, I'm sorry. Regulation making power. Yes. Page, my lord, your lordship, section 9, my lord has got. Kindly, my lord, take this section. The food authority may, with the previous approval of the central government and after previous publication by notification, make regulations with this act and the rules made thereunder to carry out the provisions of this act.
So these are rule making power.
These are rule making powers, but I will beseech your lordship to kindly take, my lord, some of the conditions, my lord, only some of the things. Kindly take, my lord, for example, rule section 92, this rule D, clause D, 92 to D.
Procedures of scientific.
Yes, my lord. And my lord, then my lord, this rule subsection D and the my lord, general provisions. That's all, nothing more. Well, what I am on is that whenever the Food Safety Authority makes any regulations, it has to bear in mind the principles, I mean to say, my lord, the guidelines and the policy which is otherwise laid down in section 18 of the Act. Because, my lord, whenever we refer to subsection 1 of section 92, it would relate back to section 18 as such.
Correct.
So, my lord, any regulation which is framed by the FSI would have to meet, my lord, this test of, my lord, test of policy and guideline as embodied in the statute itself. This first case. Now, my lord, now I refer to the sequence of events and what has happened in this matter. Kindly take, my lord, the compilation. This is all how it all started. Kindly take, my lord, page 1 of the compilation. Well, kindly mark the date, if your lordship, if it so pleases your lordship, my lord. These are the minutes of the meeting of the high-level interministerial meeting held on 27th May 2020. Well, this date is very relevant because, my lord, we were perhaps in the, my lord, in the very difficult times of COVID. 27 May 2020, from February it all started. My lord, kindly take the urgency or how they proceeded in this matter. My lord, kindly take for once the Honorable HFM, that is health and family welfare. HFM welcomed the participants and briefed them about the agenda of the meeting. Kindly take, well, I am not taking a lordship to the other agenda. III, disallowing blended edible vegetable oil with mustard oil.
Honorable HFM, what is Honorable?
HFM, and the minister, honorable minister, madam.
Minister.
Minister for Health and Family.
Family welfare, I think, na? Na, HFM can hold.
Family.
Ki ache bolto? Yes, my, it is HFW, it should have been.
Farmer welfare.
No, minister.
Minister
of Farmer welfare. Because it is
at the bottom.
Honorable Minister of the Agriculture and Farmer Welfare.
No, my lord. If your
It
lordship
is, my lord, health and family welfare. My
lordship comes to page 4, list of participants. Dr.
Yes.
Harshvardhan, Honorable Minister for Health and Family.
Family welfare.
FM, okay.
But there is an agriculture minister also who was present in the meeting. But, my lord, the meeting was convened by the HFM, I mean the family, health and family welfare.
Correct.
Now, my lord, kindly take III at page 3.
Yes.
Blending edible vegetable oil, bevo, with mustard oil.
Yes.
CP FSI informed that as a science-based regulator, its major mandates are quality and safety. She informed that bevo, which is in essence since 1991, has no safety, quality or health issues, and that in fact it provides balanced fatty acid and composition for consumers. She also mentioned that India consumes 2 234 lakh tons and produces only about 35% of the total consumption, thereby making the country import dependent. Blending and adulteration are two clearly different aspects. This is very important and cannot be used interchangeably. While the former is legally allowed, the latter is punishable as per the provisions of the FSS regulations. She also stressed that BEVO regulations have sufficient provisions in terms of label declaration, extent of blending and mandatory agmark. In fact, whatever BEVO we manufactured before it was banned with mustard oil, it had that agmark registration. There is no dispute to that effect. Certification, apart from the fact that it cannot be sold loose and has to be sold in a tamper-proof container. Besides, she also pointed to the fact that there are other oils which are equally soybean or more expensive than mustard oil, groundnut oil or sunflower oil, it should be. Banning blending in case of mustard oil alone would raise concern on the rationale. She indicated that the issue of banning blending should be considered by an interministerial scientific team, IMST. She also mentioned that there are about 657 food business operators manufacturing BEVO. Many of the manufacturers are in MSME sector. She suggested that banning of mustard oil alone in BEVO would have repercussions on other high-priced oils as well as the 30-year-old blending industry. She opined that the issue could be looked under other instrumentalities available. Secretary Agriculture informed that the percentage of BEVO compared to total oil consumption is very less. Therefore, it would be worthwhile to revisit the issue. He informed that there is no incentive for farmers to grow mustard as they do not get the MSP. The total consumption of mustard oil in BEVO is only about 50,000, 60,000 metric ton. India is a net importer of edible oil and it must strive towards self-sufficiency by making oil seeds farming economically attractive. Secretary Consumer Affairs informed that banning blending of mustard oil under Essential Commodities Act is not feasible as the act itself is being amended to exclude agricultural products. Honorable HFM informed that during 90s there were issues of dropsy due to consumption of adulterated mustard oil. He opined that the issue of blending requires a look afresh in terms of the present situation with an open mind. Then, my lord, what was the decision taken? In fact, my lord, apart from my lord, this Secretary Agriculture, Department of Agriculture, Ministry of Agriculture, none of the stakeholders was of the view that the use of mustard oil in BEVO should be immediately banned, subject to correction, obviously, by my learned friends. Decision taken. It was decided that a committee of senior officers may be constituted to examine the issue of BEVO. It should be BEVO, especially blending of mustard oils with other oils. The committee should consult all stakeholders and submit its recommendations within a month. It was also decided that the next meeting be held after 6 weeks to assess the actions taken on all issues deliberated. Then, my lord, the committee was constituted, which your lordship will find page 5 of the compilation. Your lordship will find my lord, representatives of my lord ICMR, senior officials, very high senior high officials of ICMR, then DGFT, then Department of Health and Family Welfare. Well, everybody was represented. Yes. Now, kindly take the report. The report starts along with annexures from page 7.
Yes.
I will not trouble with the entirety of the report. I'll take your lordship to page 8. Kindly take the views of the experts. My lord, kindly take from page 9. Now, this is National Institute of Nutrition, Hyderabad, presented the following views on the issue. Well, I'm sorry, my lord, I should have read paragraph 3, which your lordship will find at page 8. The following major issues were raised by the Ministry of Agriculture, Cooperation and Farmers Welfare. Mustard oil holds a unique position in the context of Indian agriculture. There is a unique identity of mustard oil in India. Blending of mustard oil with cheaper oils is resulting in price reduction of mustard oil and is adversely impacting the income of farmers from mustard oil production. Bevo is leading to mixing of cheaper oils with high value oils and is also encouraging adulteration. Well, all the manufacturers, at least I can speak for myself, were never charged with adulteration because they have the mark certification. They used to sell their products, I mean the Bevo with mustard oil in pouches carrying that mark certification, and there is no complaint whatsoever. Kindly take my lord, National Institute of Nutrition, Hyderabad. National Institute of Nutrition, Hyderabad presented the following views on the issue. My lord, I am not troubling with my lord the technicalities which are there in II and II. Kindly take III. Mustard oil has right proportion of fatty acids and there is no evidence of toxicity from its consumption. Then paragraph 7. My lord has got that?
Yes.
The National Institute of Nutrition, Hyderabad suggested that it is important to obtain the right amount of different fatty acid in the diet and avoid excess intake of any one group of fatty acids. Hence, to ensure optimal fat quality, the use of correct combination blend of 2 or more vegetable oils is recommended so as to ensure that human body gets all the fatty acids in a balanced form. Thus, by blending different oils, the benefits of individual oils can be combined together. Based on the presentations made before the committee and deliberations made in the committee, the issue regarding blending and adulteration was discussed by the committee. Then, 8.1. Edible oils form an essential part of modern diet. These oils play a role as important source of energy and provide the diet with many beneficial micronutrients. The demand for edible oils in India has shown a compounded growth of 4.5% in last 10 years and is estimated at 22.5 million tons for oil year 26-2017. But this is, my lord, Solvent Extractors Association of India website. This is from the website of the Association of the Petitioner.
One of the members.
Petition is one of the member of this association. Then I need not trouble your lordship with all these aspects. Kindly come to 8.6.4. 8.6.3. 8.6. Which is at, my lord, page 13.
Blending oil.
Blending of oils. The blending of oils, especially edible vegetable oils, means mixing of 2 or more edible oils to achieve the preset objective of obtaining a fair composition of fatty acids suitable for better health. Any blending provides an advantage as it would share the benefits of composite ingredients from the different oils used in the blending depending on the blending ratio. The main objective of blending is thus to improve the functional and nutritional qualities of edible vegetable oil, and the constituent oil are intended to be complementary to each other in terms of meeting this objective. Then, my lord, kindly take, my lord, 8.6.3. Blending is one of the simplest and cost-effective techniques that can be adopted in the formation of edible oil and oil-based commodities such as cooking oils. 8.6.4. The committee further deliberated on the issue of adulteration of edible oil in edible oils. Food adulteration is the addition or removal of any substance from food so that the natural composition and the quality is affected. Adulterated food is impure, unsafe, and not wholesome. The Food Standard Safety and Standards Act define adulterant as the definition of adulterant is given. Then Miller kindly comes straight away to the recommendation. That is paragraph 9 at page 15.
Yes.
Blending per se is desirable and should continue in edible vegetable oils. So, Bevo would continue. However, it was felt that mustard oil occupies a unique position in the Indian context. There is a definite crop identity for mustard, and the oil extracted out of mustard has a natural pungency which is closely identified with by the Indian consumers, it being a household kitchen product. Additionally, mustard oil has the qualities of being low in saturated fatty acids and high in monosaturated fatty acids. Due to blending with cheaper oils with less healthy indices, the price of mustard oil gets depressed further. This has adverse impact on the production of mustard oil. Stopping blending of mustard oil for domestically produced oil would encourage farmers to undertake extensive mustard crop production, which would make it more remunerative. However, the mustard oil to be exported can still be blended. Kindly take, my lord, what is there. So mustard oil, if it is imported, it can be blended, but domestically produced mustard oil cannot be used in the bevo. Since mustard oil is inherently healthy oil in terms of its composition, its blending is generally with cheaper and less healthy oils. Stopping its blending would ensure availability of pure and healthy oil to the consumers. So no question of adulteration. There is no question of adulteration, or the rationale of adulteration is not available. It has seen under the garb of blending a lot of activities, or now it comes to adulteration. Adulteration with cheaper oils have been happening. But none of the recognized manufacturers have been visited with any kind of proceedings regarding adulteration of mustard oil or adulteration of bevo containing mustard oil. Kindly take, my lord, lot of activities of adulteration with cheaper oils have been happening. The study conducted by FSI is an indicator towards such trend. If the blending is stopped for mustard oil, it ensures 100% pure form of oil is legally produced. The adulteration with cheaper oils on the pretext of blending would be automatically guarded against. Countries like Italy and Spain, taking advantage of the provisions in the European Union regulations, have prohibited production of blended olive oil for their internal consumption. If the provisions of WTO permit such an action to be taken by member states subject to SPS and TBT compliances, India may also consider addressing its concerns vis-a-vis mustard oil on similar lines and limit local production to only 100% pure form without any blending. The committee was unanimous on the issue that blending of edible oils is not bad and the blending has its own set of advantages. However, considering the limited contribution of mustard oil to the overall quantum of blended oils around 15% and its unique identity in the Indian context, the committee felt the need of putting in place specific regulations by FSI to prohibit blending in mustard oil and to facilitate manufacture of sale of pure mustard oil for domestic consumption. So it is not adulteration, it is only for the purpose of some kind of conception that mustard oil only and only if it is sold in as such. But I am using the expression as such because it is not blended, it must be sold as such. Would ensure
the committee
higher
was unanimous on the issue. The blending of
edible is not bad. And that blending has its own set of advantages. So the committees of not the view that the blending of mustard oil does not have its advantages. But what the why committee is of the view that this kind of blending with mustard oil should be prohibited. However, considering the limited contribution of mustard oil to the overall quantum of blended oils, around 15%, and its unique identity in the Indian context, the committee felt the need for putting in place specific regulations by FSI to prohibit blending in mustard oil and to facilitate manufacture and sale of pure mustard oil for domestic consumption. So, this is the rationale behind this this particular decision.
Yes.
Now, along with this, kindly take now the next document. I'm sorry, I should have read one. May I take your lordship back to one paragraph? I should have read it in its entirety. I'm so sorry. 8.6.4, page 14. It starts at page 13, page 14. What was the empirical study regarding adulteration would be evident from 8.6.4. 8.6.4 starts with the this phrase, the committee further deliberated on the issue of adulteration in edible oils. Food adulteration is the addition or removal of any substances or from the food that so that the natural consumption quality is affected. Adulterated food is impure, unsafe, and not wholesome. And then comes the definition. Now, my lord, kindly after the definition, kindly take the committee was informed. My lord has got that part?
Yes.
Committee was informed that edible oil survey carried out by FSI in Delhi NCR in 2019-2020 brought out that the fact that 23% of mustard oil samples failed on account of adulteration. So it is not Bevo, my lord, it is mustard oil as such. And what is the percentage? Delhi, where it is 23%. And they take, my lord, they take, what should I say, a microcosm out of the universe. Delhi as the unit.
Yes.
And that forms the basis of arriving at a conclusion that there may be some adulteration.
Correct.
Grateful, my lord. Now, my lord, I take your lordship to page 44 straight away. Well, I've annexed all the, I've given 44. All the annex as 44. Well, the entire annexure is there to the report. Well, for the sake of completeness, my lord. Well, it is from their affidavit only.
Yes.
But I take your lordship to page 44.
Yes.
Well, this is the, my lord, precipitative action. Kindly take page 44. This is dated 23rd September 2020.
Yes.
This is issued by, my lord, this Ministry of Health and Family Welfare, Food Regulation Section, subject to and redirected to FSI. The food safety standards, or your lordship will get it. My lord, it's there. The addressee. Subject. Report of the committee constituted to examine the issue relating to blending of edible vegetable oil. Bevo regarding. I am directed to refer to FSI's OM dated 18/9/2020 on the subject cited above, requesting this ministry to issue further directions in the matter. In this connection, it is hereby informed that recommendations of the report of the committee have been approved by the Honorable HFM. FSI is therefore requested to take further necessary action as per FSS Act to bring out specific regulation to prohibit blending in mustard oil and to facilitate manufacture and sale of pure mustard oil for domestic consumption. These issues with the approval of the Secretary of HW, Health and Family Welfare. Now, Miller, kindly take the next page 46.
Yes.
But this is the direction issued under section 16.5. I read out 16.5 to your lordship.
Yes, yes.
Kindly take the subject. This is issued by FSI. Direction under section 16.5 of the Act, FSS Act, regarding operationalization of draft food safety and standard prohibition regulations 2020. In exercise of the power conferred under section 92 of the FSS Act, FSI had framed draft food regulations, draft food standard and regulation prohibition amendment regulations 2020. The standards of blended oil, edible vegetable oil in the food safety standard regulations 20 standard and food additives regulations permit admixture. Well, kindly mark, permit an admixture of any two edible vegetable oil where the proportion by weight of any edible vegetable oil used in the admixture is not less than 20%. Further, the food safety and standards prohibition and restriction on sales regulation 2011 also permit such admixture. Now the government of India, after due deliberation, has directed Food Safety and Standards Authority of India to prohibit blending in mustard oil and to facilitate manufacture and sale of pure mustard oil for domestic consumption in public interest. The draft regulations in this regard are in the process of being notified, and the process of draft notification, consideration of comments, if any, that may be received thereon, and the finalization of these regulations is likely to take some time. Meanwhile, to implement the said direction of the government of India, it has been decided to operationalize these regulations with effect from 1st of October 2020 no manufacturing of blended edible vegetable oil with mustard oil as an ingredient shall be allowed with effect from this date. This issues with the approval of the competent authority in exercise of the power vested under with the Food Safety Standards Authority under Section 18(2)(f), read be Section 16(5) of the Food Safety and Standards Act 2006. So, pending the finalization of the draft regulations, the FSI decided to act in accordance with the diktat of the central government and decides to and issues an order prohibiting the use of mustard oil in Bevo.
No manufacturing blended vegetable oil with mustard oil.
Mustard oil.
Only with mustard oil.
Only with mustard oil. We can manufacture any Bevo with any ingredient. 7XA we can't use mustard oil.
Correct, that's why.
That's the whole idea. So, this is a direction issued in exercise of the power conferred under Section 16(5), which I read out. I'll come to that later, but just for the completeness of the entire sequence of incidents. Now, my lord, what happened, my lord? This direction I am not included in my paper book, in my compilation, but it's a matter of fact. This direction was challenged by the association, I believe, by the association in Delhi High Court.
This one.
This in Delhi High Court. When during the pendency of this writ petition before Delhi High Court challenging this direction, my lord, the FSI decided to withdraw. Withdrawal order, your lordship will find at page 48. Might has got that? Now, my lord, now I take your lordship to the process as to how the regulations were framed, what were the views of the scientific panel, as would be evident from, my lord, the annexures to an affidavit filed by FSI during the course of hearing of this writ petition. Kindly take, my lord, last one, page 80 of the compilation. Then I'll take your lordship to the 80. But this is now included in the affidavit.
Yes.
Page 81. So, my lord, this is the minutes of 81 is the minutes.
Yes.
Might has got that?
Yes.
Minutes of 21st meeting of scientific panel on oils and fats held virtually through Google Meet from 2 p.m. onwards, so and so. Kindly come directly to, my lord, this serial number Roman 5 at page 82.
(82)?
82, my lord, kindly take Roman 5.
Yes.
Consideration of the agenda.
Yes.
1. Consideration of comments received on draft notification. Well, by that time, draft notification were framed regarding prohibiting mustard oil in blended edible vegetable oil. The panel discussed the comments received on the draft notification from all stakeholders. The recommendation of the panel along with the justification are at Annexure 2. Since the matter relating to prohibition on use of mustard oil in blended edible vegetable oil is being monitored on priority by the government, the process of finalization of the said amendment needs to happen before 5th of February 2021. The recommendations of the panel were approved by all members during the meeting so that it may be circulated electronically to scientific committee for concurrence and suggestion. Decision. The recommendations of the panel with justifications are at Annexure 2. Action points. The Secretariat to place it before the scientific committee for approval. With regard to the matter relating to prohibition on use of mustard oil in blended edible vegetable oil, the recommendations of the panel were circulated via email dated 29 January 2021 among the scientific committee members. SC members would be scientific committee members for consideration, concurrence or suggestion. Then, Miller, consideration of the comments received on draft notification regarding amendments under clause 2.2 of the regulations, the prohibition, food product standards and additive regulations. Now, these are again there. Now, my lord, kindly come to the list of attendees at page 84.
Yes.
Your lordship will find there are all our experts. I mean, kindly take the view of the expert, which starts from page 85. Lordship may have to take that laterally because I take your lordship to this annexure 2.
Yes.
My lord, comments or suggestion. But these are the suggestion given by the registered by the objectors.
Comments of
My
this
lord, there is a table, your lordship has got that.
got it.
These are the organizations which registered, made certain comments. Then, my lord, relevant section in the draft notification on which comments are being provided. This is the inclusion in the draft notification under the prohibition clause. I will take your lordship to that clause later on. But this is the inclusion: any multi-sourced edible vegetable oil containing mustard oil manufactured on or after of 1st October 2020. At that point of time, it was 1st October 2020. Your lordship would relate it back to the 16.5 order. Then Miller comments were like this: my lord, mustard oil should not be prohibited in multi-sourced edible vegetable or blended edible vegetable oil, even if the ban is to be imposed. Rapeseed oil, now erucic acid should not be banned. Then, my lord, the rationale was given. Now, panel recommendation. The panel considered all the comments received and their observations and recommendations are as under. The panel noted that the government of India issued a direction on 23rd September 2020 to bring specific regulation to prohibit blending in mustard oil and to facilitate manufacture and sale of pure mustard oil for domestic consumption. This draft notification was issued as a consequence of this direction. The panel noted 487 comments received in favor of the proposed draft regulation and 24 comments received against it. Those in favor have broadly argued that they prefer pure mustard oil to be available in the market. Permitting blending leads to possibilities of adulteration of MO, and that consumers should have choice whether they wish to blend oils or rotate different single oils. Those against the proposed regulation state that the blending leads to a better fatty acid profile, better omega-3 to omega-6 ratio, and that there is no scientific rationale for prohibiting blending of MO. While there is, this is very important, there is some merit in the arguments given by those opposing the new regulation. It is a fact that overwhelming public opinion is in favor of prohibiting blending of MO. Further, the panel also notes that Bevo category per se is not being prohibited, but only use of MO in Bevo is prohibited. This leaves option for those consumers who prefer Bevo. The panel is also of the opinion that it is still open. Well, kindly to look at the rationale. The panel is also of the opinion that it is still open to the consumers to either blend edible vegetable oil or to rotate consumption of various vegetable oils at their own level. This will encourage adulteration. If it is left to the consumers, or if it is left to the open retail market, that they can blend on their own, well, they do not have any scientific process to their aid.
No,
So
the panel is also of the opinion it is still open to the
consumers to either blend edible vegetable. What they say is that you are buying mustard oil.
Correct.
You are also buying other vegetable oils. You can blend on your own and make a bevo on your own. Or you can, which will be containing mustard oil as one of the constituent ingredient. Or you can have a single oil, single sourced oil on a rotational basis. So, it is not prohibiting blending as such. It is, encouraging or permitting. I will not use the word encouraging. That will be a bias on my part. I would say it will permitting blending at the level of consumer or at the level of retail market. This, my lord, in my most respectful submission, would be antithetic to the letter and spirit of the Act and the regulations. Now, my lord, kindly take 8. But this is the real reason. 8 and 9. The panel is of the opinion that it may be finalized as it is a direction
From the government.
from the government
In the larger interest.
and in the larger interest. So if there is a diktat, there is a mandate from the government, I have to do 7th February 2021 is my finalization date. I have to do it before 7th February 2021. Come what may. You may like it, you may dislike it, but I have to do. Because, my lord, there is some direction from the higher authority. Well, this is, my lord, what should I say, my lord? I'm constrained to make this submission. My lord, this is complete abdication of the rule-making power otherwise vested in FASI.
That happens.
Now, my lord, kindly take larger interest of discouraging adulteration in the name of blending rather than on the basis of specific scientific rationale. Kindly take from the and in view of the above, the panel accordingly recommends the draft notification for finalization that it involves further approvals and also recommends with sufficient before it is made effective as the draft states that the amendment would be effective from 1st October 2020. So, my lord, initially the draft was given they sought to give effect to the draft from 1st October 2020.
Now
But
they are
later on it was made from, my lord, March 2021. Right, March 2021. Now, my lord, may I now take your lordship to, my lord, the two sets of regulations. The first set of regulations I would like to take your lordship through is, my lord, it's also there in my compilation. Kindly take page 56 to 76 to 79. But these regulations, this is food safety and standards, food product standard and food additives regulations 2011. My lord, kindly take this. This is again made under section 92 2E.
Yes.
My lord, what we have done, my lord, we have given an excerpt from the, it's a longish regulation, my lord.
No problem.
So, my lord, kindly take page 78. See there, my lord, the paragraph 24 or regulation 24 or part of 2.2.
Page 77 starts.
Kindly take page 77, which 2.2 under the heads fats, oils, and fat emulsions. My lord has got that?
Yes, yes.
Under this 2.2, 2.2.1 is oils.
Yes.
Now, under 2.2. Regulation 2.2.1 oils, kindly take serial number 24, which is at page 78 of the compilation.
Multi-source edible oil.
Yes, my lord. Multi-sourced edible oil means admixture of any two edible oils where the proportion by weight of any edible vegetable oil used in the admixture is not less than 20%. The individual oils in the blend shall conform to the respective standards prescribed by these regulations. Multi-source edible vegetable oil shall not contain more than 33% of saturated fatty acids. Multi-source edible vegetable oil may have an ideal ratio of omega-3, omega-6 to be in the range of 1.5 to 1.10. Third oil, namely chia oil and flaxseed or linseed oil up to the range of 5% of the total oil, may be added if the multi-source edible vegetable oil is claimed to have been an ideal ratio of omega-3, omega-6. The blend shall be clear, free from rancidity, suspended or insoluble matter, or any foreign matter, separated matter, water, added coloring matter, flavoring substances, mineral oil, or any other animal or non-edible oils, or fats, argemone oils, hydrocyanic acid, castor oil, and triacetyl phosphate. It shall also conform to the following standards and shall conform to the following standards, namely, my lord, the entire standards are laid down. Well, I'm not troubling your lordship with the standard. But so, my lord, as of date, even till now, these regulations do not prohibit admixture of bevo with mustard oil. My lord, kindly view it with the kindly take these regulations and kindly analyze, I beseech your lordship to kindly. You come tomorrow? Yes, my lord, I can.
And he would need to visit the dentist. He's making so many cyanic acid.
My lord, there is an understanding with Mr. Roy and I. Considering the weight proportion ratio, if I am here, he will not be here. If I am not here, he will be. May I take your lordship's kindly?
Thank you. Counsel for the petitioner argued
But may I take back the book, my lord, subject to
Yes, yes. Argued the matter at length, but due to ये वाला book मंगवा लो हाँ? Requisition. Argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter fixed tomorrow at 2 p.m. as especially fixed. Get to it. Original side.
Maybe mention a matter. This matter your lordship has heard at length. It's a part-heard assignment. So part doesn't matter. This is that wax pool matter. 10F appeal.
Next call.
Wax pool.
That company matter.
Yes,
Company.
10F. But whenever your lordship, it will be something new. Your lordship will become such a heavy pen. Something.
Just what? All are something.
Any time, any days, of.
So you persons will made me the expert in all fields.
Your lordship was always.
Just one
It's a
request,
pleasure,
my
my
lord.
lord.
If in case my lord is fixing a date, my lord, then I'm being led by Mr. Ratnanko Banerjee, my lord. He has requested, my lord, if it can be on 4th or 5th or 6th of February, my lord.
That after 20th February. only.
After 20th of
it will be-
March, sometime in March.
दोनों पार्टी है दोनों है You are for the Mughal and he is for the Ratna. मार्च में देख फरवरी कोई डेट है
March is fine. March is fine. ठीक है. What?
18th March. Mukherjee will be available or Mr. Ratnanko Banerjee will be available? Because I think Mr. Mukherjee will complete that.
Yes,
18 March.
3 dates you are already argued.
4 days. He's already 4 days. I think he should finish.
कब? अच्छा company matter है.
Would your lordship be kind enough to fix it at 3 p.m. or?
No, then it's a company matter.
Yes,
So I am fixing tomorrow Tuesday as to be mentioned.
To be mentioned.
Correct.
So
Let
they
the
want the
company people come, then they will take the उसको रख 21st कब रखता है? बुध को, मंगल को. To be mentioned.
Obligatory.
Department Owners Association, my lord, illegally administrator appointed, my lord, And my lord, 10-year over, no election done, my lord. And my lord, no, there is no electricity, no water, my lord. Entire situation is a like a pandemonium, my
So
lord.
what is happening to your apartment?
My
If
lord,
there is no electricity, no water, so there is any public there.
my lord, we are in a grave difficulty, my lord.
Ah.
Illegally arbitrator appointed, my lord.
Ah.
Kindly takes up a hearing. My lord, small. I shall not take 5 to
Which
10.
matter?
My lord,
Which matter?
my lord.
It is not in the list.
Yes, item
Original
number
site.
92, my lord.
Huh?
Item number 92.
I don't know where I can fit.
Time, my lord. 5 to 10 minutes, my lord. Not more than that, my lord. Any date, my lord, as your lordship pleases.
देख लो सो कोई जगह फिट होगा तो देख.
May I have your lordship's kind
Grateful, my lord.
may I have your lordship's kind leave. I'm praying for drawing up and completion of your lordship's decree.
When it was passed?
11th of November 2020. This is the goods of Indra Ajit Kumar Shengu.
Which one?
Ajit Kumar Shengu.
Acha, that is not done.
So there is a mistake on my part. We applied for completion of an order. It should have been a decree.
Okay. No.
If your lordship,
Acha, decree.
it should have been a decree. So your lordship, if lordship grants the leave, will grateful.
My lords, if I may be permitted to mention a matter for inclusion in the list.
Why?
My lords, this matter was last heard on February 7th. There were directions for exchange of affidavits. However, the respondents have not filed their affidavits till date. Last it was heard on February 7, 2025. My lords, my collateral security is being detained by the respondent number 1.
Bank.
No, my lords, it's the West Bengal Industrial Development and Corporation Limited. Grateful, man.
Kindly takes up item number 14 anytime convenient court today. I'm trying to put them on notice. This is regarding renewal of passport. I'm covered by a latest Supreme Court. My passport is valid till 4th.
The criminal case pending.
Yes.
So have you obtained no objection from the criminal
The
court?
issue has been decided. I shall cite the judgment. The Lordship will kindly clarify.
Item number
14.
14 of today's.
Item number 14. आज तो नहीं होगा. देखो कोई एक दिन रखो. मंगल.
Date of service was filed in.
हाँ?
It was upgraded.
नहीं होगा. अच्छा हाँ. Let it wait. Maybe taken tomorrow. Maybe. If not, then I will see.
Lordship, the item number 1 is appearing at my.
Yeah, why it is mentioned?
For the name of the change of name of the special referee, your lordship. Because he is representing the plaintiff in other matters also. And also there is a small correction in your lordship judgment at page number 9, in para number 22, so 4th line, your lordship, instead of plaintiff, it will be defendant.
This code 4th line.
4th line, para
Thus the
22.
plaintiff was in Atracha.
Thus the defendant was in, it has been by mistake as given.
That is only.
That is the thing, and the special referee.
Special officer. A special referee.
Special referee.
We are for the defendant. The matter is mentioned by the learned counsel for the plaintiff for correction in the judgment dated 9th of January 2026. Correction in the judgment as well as for change of special of referee appointed by this court. Special referee is counsel for the plaintiff submit that in paragraph 22, line number 4, the word plaintiff is to be read as defendant. Counsel for the plaintiff further submit that the special officer appointed by the Mr. Suhasi Sen Gupta, learned advocate, is appointed as special referee to determine the main profit. But Mr. Suhasi Sen Gupta is appearing in some of the cases on behalf of the plaintiff, and as such, he prays for change of the special referee in place of Mr. Suhasi Sen Gupta, learned advocate. And counsel for the parties in paragraph 22, 4th line, the word plaintiff shall be replaced as defendant. Full stop. Instead of Mr. Suhasi Sen Gupta, learned advocate. Who can be? कौन है? ये बिजी आदमी है, करेगा? Mr. Chan Gupta, learned advocate.
No, Lordship, Mr. Chavan Gupta is also representing the plaintiff.
Is also representing the plaintiff.
Yes, it's some other matter, your Lordship.
Now you lost. You are in loss.
Matter.
No, I am appearing.
Now you are in loss. Who is और कौन है ग्रुप में? Who can be done? You will do special referee for the main profit.
Well, if it falls me, I will.
Mr. Ray is appointed. ठीक है?
Deeply obliged.
Well, this is my application, writ petition.
Well, I am for the respondent.
Well, it appears that today was fixed for hearing. My learned friends were supposed to give a calculation as to the respect of mean profits. Not mean profits.
But
Drafts of rent unpaid. This is a matter, where they had initiated a proceeding under the PP Act. It ultimately transferred in the appeal, we won. So they had entire whatever procedure took for recovery, has gone. After that, what they do, they again initiate and give a similar letter for demand, giving complete way to the order of the appeal court, which has not been challenged as yet. So therefore, we came before a writ petition. So, because now there is an order for no cause steps and the direction was given, you give the amount of rent you say has been unpaid. But now the affidavits have not been forthcoming. Today was the date fixed for hearing. It appears that I find a...
I am for the port trust. We had to do calculation from 1967. So, now it's ready. 2-3 pages like lease deed of 1967. Now register is saying, department is saying it's not legible. If Lordship grants me 3-4 days time, it will be cured and filed before your Lordship. So, Lordship can extend it and fix the matter for hearing for some other limitation.
But only 4 years saved them.
As per the
63 is the limitation act.
As per the prayer made by the counsel for the opposite party, the case is adjourned. The matter appear on. कब रखेगा?
No, I will have to give a reply to this if they are serving. Let them serve.
Can you extend the time to file a petition by
2 days?
The learned counsel for the opposite parties prays time to file affidavit disclosing the figures and dates of the rent paid and enhance of the current rent in terms of the order dated 28th of November 2025. Let the affidavit be filed by
4-5 days.
Today we are on
19th.
After giving the after serving the copy to the learned counsel for the petitioner, the petitioner's liberty to take exception to the file affidavit reply to the said reply within a week thereafter. Please the matter on 29th. अच्छा 15 9 में है 15 by 16 by उसको कर दो आज हम 15 है ना by 22nd कर दो by 22nd reply by 30th January reply by 30 or 1 week further
or 2
weeks
2 weeks 2 weeks
by 6th of February
considering the size
6th of February 2026 list the matter on 11th February.
The interim order be extended.
Interim order you are enjoying.
No para 13. No cost steps.
Interim order is extended. कब बोला 16 बोला date कब बोला 11 is 16 February 2026 or until further order.
Lordship, I'm grateful. Much obliged.
Next.
না অন্য ম্যাটার
I take up on behalf of the TBO.
My Lordship, item 3-4, I am appearing for the petitioners. Mr. Rajoshi Dotto mentioned this matter in the morning. My Lord kindly keeps it any there.
My lord, one difficulty is that my senior friend is against me in national, against the national insurance in another matter.
Then they have.
May, I don't know, may my client have
then the
some.
controversy
Yes, yes.
not to be keep the
Since I'm on it.
But I was only because it fell from your lordship. I said,
Yes, yes. I have personal, I have no problem, but it's a corporate client and
Okay, then
they have lots of.
I'm very good.
Okay, ठीक है, हम उसका नाम दे देंगे.
Yes and no, he eaten birds which I have to face one. I just.
As per
want
the
to
prayer
mention
made by
the
the council for the plaintiff, the case adjourned. Let the matter appear on कब देगा? 5th March at 3 p.m.
3 and 4, 3 and 4, 3 and 4.
3 and 4 both. Next.
My lordship, can it be any day other than 5th of March?
Why?
Mr. Dotto will not be there on 5th of March.
Then 10th March करें.
10th of grateful, my lord.
Inform the others.
Grateful, my lord.
Yes, call the next. Item 5.
My lord, I'm for the respondent, my lord.
Who is for the petitioner?
My lord, here in this matter, I have a preliminary objection to be raised. my
But
lord.
where is the petitioner?
Yesterday they were there. I cannot see that.
Anybody's on online? No. Withdraw the communication data issued by the respondent alleged capacity.
Why?
Nobody is there. None appears on behalf of the petitioner. Transactions appearing for the respondent. For the interest of justice, case is adjourned. Let the matter appear in the combined monthly list of March 2026. Yes, next. Item 6.
Item number 6, I am appearing on behalf of the petitioner lordship. I'm praying for a short passover. Mr. Ghosh is leading me in this matter.
Yes.
So kindly grant me a short passover.
Short passover, what? Further.
Your Lordship, Mr. Brajesh is appearing for Union of India. He is also doing a matter in courtroom number 29.
Not today.
Kindly pass it over, lordship. There is certain
They
urgency.
are also telling the. Not today. Next.
Lordship, item number 7, I appear on behalf of the petitioner, Your Lordship. I appear on behalf of the private respondent. The writ petition is arising out of an application filed before the Micro Small Facilitation Council, Your Lordship. I had earlier filed an writ petition wherein an order was passed to dispose of the application within a certain time. The order is at page number 119 of my petition.
119.
Yes, Your Lordship. Paragraph number 3, Your Lordship.
Council has already fixed the date for hearing, proceeding according, consider director consider the response of the proceeding. Passing reason or steps shall be taken in the matter to conclude the proceeding at the earliest but possibly within. Yes, then what has happened?
Yes, Your Lordship, I had communicated this order. Thereafter, only one sitting has been conducted. It has been about 5 to 6 months. It was supposed to be concluded, the reference was supposed to be concluded within 90 days, Your Lordship. There has been no compliance. Your Lordship, may I?
This is not the only matter.
Yeah, this is not the only matter. There are several MSME application, Your Lordship, the same
Lordship.
status.
However, more than one sittings have been conducted, Lordship. On the last occasion, my learned friend was there. I prefer an application for adducing evidence, Your Lordship. Now the arbitration has to be conducted under the Arbitration Act. So we have preferred an application that the application has been allowed. So it will take more than 90 days, Your Lordship. And
So you could have been you could have filed an application for extension of time.
no,
There is an order.
Your Lordship, we are for the private respondent.
That's why the authority who is upon whom the direction, if it is that, so they have to file an application for extension. They not file any application for extension, then what can be done?
Your Lordship, I can bring a judgment.
See how the juniors are afraid of you.
Not afraid, laugh. Not like my lord.
Your Lordship, I can bring a judgment next day which says 90 days is directed, Your Lordship, not mandatory.
No. May I start afresh? Forget what my lord has said. My lord, I know my lord has lost the jurisdiction of advising.
That's why.
But
That's what I'm telling.
Today I am asking an advice from my lord by giving court fees that if it is 90 days and not done, what should I go? Is provision become odious?
12 weeks. Who is for the authority?
Coupled with the direction of your lordship's court.
Correct. Who is the authority?
Okay.
It's a private
জামা কাপড় ওয়ালা তার we have served তো দেখেছিস দেখে দিয়েছিস
Original side read to না serve করে তো ফাইলই করতে দেবে to whom is it was directed
মানে the authority
the council itself the council was not the party here
council is the part
council was not a party here so what can be done council is not a party and that earlier also the party
Council is a party.
I can hear it now my lord
Respondent number 3.
West Bengal
Number 3.
yes 3 is there
facilitation yes 3 is there so I am directing
Very well, Your Lordship.
so what you want the evidence
Yes.
you will need evidence
Yes. And that has been allowed on the last occasion.
that whatever procedure is there that should be complied I am not saying that my lord it is a lordship pleasure we have served it my lord kindly grant another chance
For them to
second day let them come
that's why I'm asking who is appearing who is appearing for the council
I have no idea
On the last occasion, Devanshu did
Mr. Dinda appears
Yes.
should I give an info
the respondent council on the last.
the
should I inform Mr. Dinda also he used to appear
the allegation in the
এটা better
present
হবে, তাহলে কিছু
the
লাভ হবে।
allegation made in the present application is that in spite of the direction passed by this court on dated 19th of June 2025 the council has not concluded the proceeding within a period of 12 weeks it is submitted by the land council for the plaintiff after the order was duly communicated to the council and on receipt of the order the council has issued a notice for fixing a date and thereafter no further hearing was conducted. Learned counsel appearing for the respondent number 4 submit that before the council the respondent number 4 has filed an application for allowing the respondent number 4 to adduce evidence and the said application was allowed. Full stop. This court finds that before passing any order a further in spite of service of notice none appears on behalf of the council. Full stop. This court finds that one opportunity should be given to the council before passing any order. Accordingly, case is adjourned. Let the matter appear on 27th January 2026 under the same heading. Full stop. The petition is directed to inform the date to the council. It is further made clear that on the date fixed, in spite of receipt of the notice, if the respondent number 3 failed to appear before this court, appropriate order will be passed.
no I made I request her to clarify the position
I'm not scared, Your Lordship.
now satisfied yes Margaret is leaving
Now, after seeing you see it.
That's on me, Your Lordship. That's on me.
Yes, next.
This is my petition.
Yes.
It's extremely unfortunate, my lord, that the police authorities would do this.
What they have done, sir?
My lord, we were requested by the police authorities that please give your house or whatever this building on rent. We give this to them. So, my lord, they have been enjoying this at a very paltry rent.
When you are given Arjikar?
Long back, 1970s. So now, for 2-3 years, I'll indicate. I'll just give you, Your Lordship, the overall. Then, my lord, we asked them to leave enhanced rent. They gave a proposal that we would want to purchase at the market rate.
Who?
Police.
Police authority.
Would want to purchase at the market rate. We said very well. Thereafter, there has been communication exchange between the parties with regard to market rate. They would want to purchase and they have taken approval from whatever finance and all. That has been done. Still then, they are not doing anything. What we do is we filed a suit.
For eviction.
Yes. Somehow we lost that for some reason. We preferred an appeal.
Agreement entered? No.
I'm sorry.
There is any agreement between you and for
Yes.
specific performance? No.
No. So, my lord, in that letter they had offered. So it's a letter of offer, my lord. Now, my lord, we file an appeal from that dismissal of the suit. Then they give us the golden handshake. So we withdraw that appeal. We said that, okay, now
we are willing to sell, please purchase. They do not do.
They say that
We would purchase.
after you withdraw it.
So they wanted us to withdraw the suit and then thereafter they would purchase.
Communication.
In the appeal, there was no proposal. Simply withdrawal.
No, simple withdrawal.
Simple withdrawal.
Yes. So now we have nothing. We don't have the property. We don't have the money. We don't have the deed. We don't have the appeal.
We are out.
So it's a classic case of promissory estoppel where, my lord, this is being happened.
Where is the letter?
Yes. May I just indicate to your lordship?
Who is appearing?
Mr. Bandyopadhyay is appearing, my lord. I have informed he is coming, my lord.
But they might take a point. It's a specific performance in a writ petition which cannot be granted. But if there is no disputed question of fact involved.
Where is that letter? That's why I want to see. Where is the letter?
109 kindly takes a look at.
108 onwards.
106.
108
onwards.
108 onwards. Kindly. Kindly see who writes this letter. Commissioner of Police. 108.
Land acquisition.
Writes to land acquisition that valuation of land and building at premises number such and such. Then kindly see serial number 2. They say it's from 1970. Then serial number 2. There is an appeal pending before the second additional district judge Alipur for around 10 years filed by the owners for recovery of khas possession. Since the court case is pending for a long time, a possibility has cropped up for formal negotiation with the owners for purchase of the said property by Kolkata police, provided the owner is agreeable to outright sale of the same to Kolkata police at a reasonable price. First, land acquisition collector Kolkata has assessed the value of the existing land and building at such and such. The value of the land and building of the premises was forwarded to the owner such and such and was informed that they are not agreeable to sell the property at the cost assessed. He also informed, as per Directorate of Registration and Stamp, present value of the property is such and such. Then you are requested to kindly assess or reconsider the matter. Kindly turns over. Copy was forwarded to me at the bottom. Kindly turns over. Now the Land and Land Reforms Department issues this letter saying that in forwarding a copy of the letter in such and such, I am directed to state that the base price of the premises stands at rupees 4 crore 10.
Yes.
Then when the police writes to us at page 110, this is to inform, kindly see the heading, offer for sale in respect of premises number. This is to inform that the value of the land and structure situated at premises number such and such has been fixed at rupees such and such. Then it is requested to let this office know if the owners are agreeable to sell the property to the Kolkata police at the assessed cost of 4 crore 10. Wanted formal consent. Then page 112. So I accept the offer. 110, 112.
116 lakhs. They ask for the ownership document.
My lord, so my lord, I accept this at 112. Kindly turns to 116. Now the police wants us to provide necessary documents of ownership.
For purchase of conveyance.
So naturally that would have to be done. Page 116. We do that. 117 under cover of this letter, we provide all these documents.
130. We give to them. And there's an
acknowledgement
in 130.
Yes.
Now kindly comes to 130, where they acknowledge that.
Yes.
Then they ask that cause an inquiry into the legal heirs of the deceased person and to report along with the legal documents at an early date as the matter relates to purchase of the premises by Kolkata police. Last line. So the letter copy has been marked to me, but this is with regard to their Joint Commissioner of Police writing to Deputy Commissioner of Police with a copy marked to me.
Yes.
Number 136, I withdraw the appeal.
Starting at 130. At their behest.
You withdrawn the appeal on when?
Well, this is dated 27th of September 2019.
2019, and this letters of 2019, 4th July 19.
Yes, July
So
9.
that only.
Yes, after that we withdraw this appeal.
So why you not gone
So-
into the compromise, joint compromise in the appeal?
Should have been done, but really we possibly couldn't take on the police and for justifiable reason. Then well at 138 onwards goes my request because after the withdrawal of the appeal, they are sitting tight.
That's why I'm asking.
Yes.
Page 144.
Yes.
Now 144,
The meeting হলো
there's a meeting also. Page 144, minutes of the meeting. We say we indicate this by way of this letter received by them. They had not refuted the contentions. And in the writ petition at page 145, we have annexed the present market value.
minutes of the meeting.
Commissioner of Police assured the owner. Assurance. Then nothing.
Then nothing. My lord, so my writ petition is really that directing
What-
them to purchase.
What is your prayer in the writ petition?
Directing them to purchase
Execution. Page 19.
page 19
70 থেকে শুরু হচ্ছে।
because my lord
17 and 18.
17, I'm sorry.
Registered to sell it.
17, yes.
Yes.
Now, my lord, two things. My lord, they might take an objection that A, there is a contractual dispute. B, that there is a writ petition for specific performance will not lie. So I need to possibly address both these before your lordship calls upon them. And my lord, I am backed by a few judgments. Just two or three, my lord, I shall show that
Perhaps before Mr. Gupta goes to that, let us file the affidavit in opposition. But we also have certain points to bring before the court, my lord. I believe we will not stand in the way, and whatever submissions he wants to make, my lord, he can make it after the exchange of the pleadings, my lord.
but I can, but really this is going on for
Lord, we have to bring some things on record.
What?
Supplementary affidavit. Lord, will allow us to-
What is your instruction?
Lord, my
Yes, what is your
my
instruction?
instruction in this regard is I am not saying that there is any factual impropriety by them, but there are few issues, my lord, which needs to be decided. One of the issues are, my lord, those who are before this honorable court, my lord. There are other co-sharers in the writ petition, that is their admission themselves. They are not before my lords. So whether they are interested, whether there is any
No, that's what I'm telling. Because because the court, if you are still leave aside the other points, if you are still that you're still ready to purchase whatever the formalities, then let the writ will be kept pending. They will give the whatever the
yes, I do not have any quarrel with them. Let them.
let us allow us, my lord, to file an
No,
affidavit,
that
my lord.
see. If
We
you
will also put our points on maintainability of the writ petition.
That's why I'm telling. If you are taking the maintainability, I will not allow you to file affidavit. You argue the matter herein now, so that the time cannot be wasted to the court also, to the party also. If this court finds on satisfied on your point of maintainability, immediately I will dismiss and they will take appropriate steps. Because raising the maintainability point in the affidavit in opposition, no purpose would be served.
Lord, I have
Point of maintainability on the point of record.
I have taken instructions, my lord. There are few records which we
Now tell your authority, if your authority is strictly going with the maintainability, I will not allow you to file affidavit in opposition. First you have to argue the matter on maintainability point. I will decide that.
something, my lord, which the
I will not keep the maintainability open. Mind it.
my lord, in my
Because such
understanding,
type of the matter, this court is the last court. On 17th, you are enjoying the property and they have withdrawn the appeal. You have given the assurance. You settle the amount. So that's why you come with the if
remedies to follow, my lord.
correct. That's why I'm telling. If you are raising the
Then we
point, I am not setting out your mentality.
Keep it on Monday, my lord. We'll argue on the.
Today is the matter. Why you are not arguing?
My lord, today, my lord, I was under the impression, my lord, will grant us an opportunity to file an affidavit. My lord, as my lord is not inclined to, Monday we will argue the matter, my lord, on the point of maintenance.
Point of mentality, there is no requirement of the affidavit.
I agree. I am not disputing. Monday.
The counsel for the respondent submits that intends to argue the matter on the point of mentality and he prays for accommodation. According cases adjourned, let the matter appear on 28th of January 2020. Next. I am for the writ petition, madam.
I am for state led by
So
Mr.
there is a direction to file report with the advance copy to the writ petitioner so that I can take the necessary exception,
Yes.
my lord. Order was passed on 17th November. So no.
Got
copy
the
of
report?
Lordship,
report was
Lordship,
served.
report is ready, Lordship. I am filing it today.
So the copy.
Yes, yes, Lordship. I am sorry.
What is the matter?
My lord, my deed was cancelled, my lord. I am asking for the refund of the
Refund
stamp
of-
duty.
yes,
Yes, ma'am.
Yes, what is your report? What the report says?
Lordship, first of all, Lordship, that is their fault because Lordship, at the time of registration, Lordship, they have not appeared before the registering authority, Lordship. That is point number one. And second is, Lordship, that stamp duty already used, Lordship, and used stamp duty, Lordship.
Who has used?
Lordship, used for registration, Lordship.
Where is the registration has done?
Not
Then?
done, but
If
Lordship,
the registration is not done, what whether there is any, you can say it is registered. If you registered, then it can say you used.
registered, Lordship, not registered document, but in
Sir,
the-
for what purpose you are taking the stamp duty? What purpose you are taking the stamp duty? Tell me.
for registration.
For registration. For registration for what? That is the stamp duty. This is the value of the land. Then is going to be transferred to one person to one
Yes.
person. That's why this is the value. It is to be paid unless
Yes.
it is not been registered.
But
here, whether the land is transferred, conveyance deed is registered. No.
Not registered,
Then
but
have
this is
cancelled the
purpose, only purpose for registration of the deed, Lordship, but the stamp already used in the deed, Lordship. So
that's why for the purpose only he has used the deed, but whether the deed is registered,
not
whether
registered, but
further formalities has been happened.
not
You
registered.
show me any law. I will dismiss the writ petition here in now. If the deed is not registered, the sale deed, the stamp duty paid by the person deemed to be used. Show the law.
Lordship,
Who has given the instruction to you like this?
Lordship, the register of assurance.
Can I tell that
assurance
let
to-
the assurance come in person and satisfy this code?
That Lordship,
If
kindly,
this is the amount of the register, suppose your register is posted in Delhi, he purchased the property, subsequently he transferred, he didn't want to purchase the property, deed is not registered. Whether he not paid for the return of the stamp duty? I am putting your registered itself. For what purpose the deed is been deposited? For the registration. If the registration is not been done, can you say it has been utilized?
registration is not done because Lordship, therefore they have not appeared, Lordship.
You are appearing in the civil suits. You are appearing in the suits. No. If the suit is filed, subsequently on the very first day of coming and telling that now I am withdrawing, the court is allowing you to withdraw along with the court fee. Court is telling no, you have already filed it, it cannot be. This is a public money, sir.
Lordship, also Lordship.
Okay, you use an exception.
Yes, yes, Lordship. I want to.
Exception.
Yes.
How soon?
Within 7 days.
But you take instruction. I am not satisfied with this report.
Also, Lordship, kindly see my report once, Lordship. Kindly see para 9, Lordship. Para 9, Lordship, they mentioned there is no provision on registering authority for refunding the stamp.
They are not asking for the stamp. They are asking the return of stamp duty.
Yes, stamp duty, Lordship. They have no authority, Lordship. Kindly see once para 9 and also Lordship para 9, kindly. And para 12 also, Lordship.
Kolkata made a proper communication to the petitioner, so and so, stating that there is no provision on the registration
They
statute.
stated
But
that-
that's why I'm telling.
They
There's no
stated that-
provision of stamps. If the deed is not registered, where the amount will go?
Lordship, kindly see once, Lordship, para 12, Lordship. They said that this is beyond the ambit, not only the registering authority, but also registration director.
You do one thing.
They have no power
You do
to
one
refund
thing.
the stamp
You
duty.
do one thing. You take instruction from your client. This para 9 and 12.
Yes.
Bring the law. Bring the law under the act. Yes, this is the act. The amount cannot be
refunded.
As well.
Correct.
Section 49,
Just that let he bring.
D subsection 3,
He has taken the
Lordship, it
plea.
says that if the property stamp duty is not executed, it can be refunded.
Correct. I know. That's why I'm asking you. No, I am not asking question from you. The learned counsel for the respondent has filed report after serving the copy to the learned counsel for the petitioner. Counsel for the petitioner prays for time to take exception. Let exception be filed within a week. Release the matter on 3rd February.
Deeply.
Take instruction on this point.
3rd February.
Item number 10, my lord, I am playing for not today, my lord. Learned ASG is engaged in court number 36, my lord.
My lord, I am for the petitioner, my lord. On mentioning your lordship had upgraded it today. This is for issuance of a passport.
Only
What
not-
point involved, my lord, in the matter, my lord? My lord, 2024, the petitioner applies for the passport. Since 2024, the application is pending. The petitioner was called by the regional passport officer for certain clarifications on 2-3 occasions. The petitioner visited. Petitioner was made to sign an undertaking that there is no police cases pending against the petitioner, and petitioner was informed orally that the passport would be issued. All compliances have been done. Even thereafter, my lord, several months passed, no passport issued. Legal notice issued by the petitioner through its advocate asking for reasons for non-issuance of the passport. No reply thereto. My lord, that has compelled the petitioner to approach your honorable lord, my lord, with this matter with regards to issuance of passport. My lord, now, 2 questions. Your lordship, even at the time of mentioning, my lord, for upgrading the matter, your lordship had categorically asked me, any police cases are pending. My lord, there is no police case pending against the petitioner. There is, in fact, a police clearance certificate issued in favor of the petitioner, and the petitioner showed that also. My lord, there is no space for the petitioner to go because, my lord, they are not even refusing the application for issuance of a passport. My lord, since 1994, the petitioner had a valid passport. 2017, the last extension was made. The petitioner then wanted to travel abroad. When the petitioner reached the airport, the immigration department says that the passport has been revoked. So you cannot travel. The petitioner decides to come back because he cannot travel abroad. Thereafter, the petitioner took advice, my lord, made a fresh application for issuance of a passport. That application since 2024.
No, but revoke under why? What wrong?
Yes, my lord, revoked under what ground, my lord? That we are not aware. We were told it is revoked. Now, my lord, the petitioner.
Can it is permissible once it has been revoked, then you can.
Yes, my lord. Fresh application is permissible, my lord. It was revoked because pendency of certain criminal cases against the petitioner. My lord, thereafter, my lord, the petitioner, that is why, my lord, the petitioner obtained the police clearance certificate. Because if any case, my lord, the petitioner was impleaded as a party against which a charge sheet or an FIR has been passed, or anything has been done against the petitioner in his personal capacity, under Section 6 of the Passport Act, the passport officer will have the power not to issue a fresh passport to the petitioner. The police clearance certificate, my lord, which your lordship, if your lordship just takes the certificate at page 29, it's very recent, of 5th February 2024, which categorically, my lord, states that there is nothing that remains pending.
Okay, yeah, when you will come? When ASGI will come?
My lord, only not today.
Not today.
My lord, may I just in that case, my lord, say one thing. My lord, keep it, my lord, wherever your lordship wants, whenever your lordship wants, my lord, but on the next day, kindly consider this. My lord. Because your lordship has so many fixed matters at 3 o'clock, 3:30. Today we were lucky that the 3 o'clock fixed matter.
That is the problem.
My lord, it's not your lordship. My lord, we are to be blamed, my lord. It's not your lordship, but kindly.
Oh, no, I am not. And that's why problem fixed matter gone.
Yes.
So nobody is ready for that. Not today. Let it be tomorrow or day after tomorrow. Tomorrow nahi hoga na. Tomorrow to suit hai na. Then Tuesday, Wednesday. Tuesday.
Lord, may it retain the position.
Yes, same. Next. Yes. Reserve Bank.
Or SBI.
Who is for the petitioner?
I'm appearing, my lord, on behalf of the petitioner.
What is your
My
prayer?
simple prayer before your lordship is
Fraud.
that an order has been passed where, my lord, my accounts have been declared as fraud.
Fraud.
But I have not been given an opportunity of fiscal year.
Where is the order of fraud?
Yes, my lord, kindly have a look at volume 3, page 380.
It is correct. Notice issued.
But sir, my senior is going to appear before this court.
Who is your senior?
at Shukanta Ghosh.
You take instruction whether opportunity is given. Page number.
Lordship,
Lord, kindly have a
Lordship,
look at page 380.
he is appearing before the court number 2. I'm kindly praying for a short passover.
All passover, what the court will do? For the last several matters, I pass on. No, none of the matter has been disposed of.
Lordship, a short passover is prayed, your Lordship. A short passover.
Yes, okay.
Lord, kindly have a look at page 380, Milord.
380.
Yes, this is the covering letter.
Reference to the
Yes,
so-called
we refer
notice.
to the show cause notice as issued by us, VD letter number such and responses received. Milord, we had given a reply to the show cause. Details of the same are provided in the enclosed reasoned order. We have taken cognizance of the responses to our SCN, and after due examination of the same, it is concluded that sufficient reason have not been provided by the respondent to explain the non-adherence to the agreed terms and conditions of the loan documents or the irregularities observed in the conduct of the account of Tantia Construction to the satisfaction of the bank. Accordingly, Fraud Identification Committee of the bank has decided to classify the loan account as fraud for reasons mentioned in the enclosed.
Where is the so-called notice?
Milord, will kindly have a look at the show cause. We have not only
What now what you want? How you are telling that how you are telling that the opportunity is not given?
Show cause notice was given. We gave a reply to the show cause notice, and then directly order was passed.
So what you want?
Milord, we had in our show cause in the reply sought for Milord of hearing, be it virtual or physical, and that was not given.
Not necessary.
No, Milord, it is. It is under the order of the Supreme Court.
Rajesh Agrawal clarified. Personal hearing does not mean the come in person. Personal hearing means the representation.
But here, Milord, personal hearing, Lordship will kindly have a look at page 387, Milord, an order passed in a similar matter. Sorry, Milord, in 385.
Yes, 85.
By coordinate bench, Milord.
Correct.
Where kindly have a look at paragraph 2.
Natural justice to the opportunity of hearing ought to have been granted. For the director to grant a last opportunity hearing on the petitioner to defend the. Okay, in that case, I will say I will not setting aside. What is the stage? Now you have been declared fraud. What can be done?
Milord, I have been declared for fraud by not considering the documents which I had relied upon. Now, my difficulty, Milord, is I have already informed them that I have gone into liquidation. So, I do not have the documents which originally was with me. And that I have mentioned in the show cause notice. That give me some time, or you give me the documents and let me argue. I am not today asking your lordships to declare that I should not be declared as non-fraud or as non-fraudulent. What I am only saying, Milord, that kindly let them give me an opportunity to appear before the authority, the same committee, in person with the documents, and Milord, make submission in a time-bound manner. Milord, in this writ petition, I have also sought for the documents from them because they.
Writ petition you might be, but in the so cause notice, have you sought for any document?
Yes.
Where is that?
Okay.
Where is the so cause? And where is the so cause reply? Where is the so cause reply? 132.
Yes. So that would be in volume 2.
Yes. Reply to the so cause notice. Forensic report not served.
They have relied on the forensic report in their show cause notice, but only excerpt. I asked them for the entirety of the forensic report, which would go on in volumes.
Yes.
And Milord, I have also sought for all these documents in the present writ petition.
Yes.
Lordship, facts remain is that Lordship, personal hearing has not been allowed.
He was at personal hearing,
Lordship,
not.
that
Kindly
Lordship,
come to the page 132, 133. One 132, 132 last line, last two line. Kindly provide me with the fresh and complete copy of the document that you have relied upon. And in the so-called notice dated so and so, so and so. Further, as per the documents annexed, the said so-called notice, I have only been provided with the certain extracts of the forensic report so and so prepared by the Sarath and associates. In the light of some, you are requested to kindly provide. Where is that? And in the impugn order, you have not stated that you have provided all the documents in spite of the petition asked for. And Rajesh Agrawal already clarified all the document is to be supplied.
For your Lordship's kind of convenience, at page 129, same volume, we have given a detailed list of all those documents which we had issued in our first reply, first and only reply given so far. And I have a specific prayer to this effect in this report. This is for your Lordship's convenience and even for them to consider. And I've given the reason also that I have gone into liquidation. The records are not within the control of the director. It goes with the CIR.
Where is the so-called notice?
Yes.
Lordship, page 138.
Huh?
120 is the so-called notice. And your Lordship will find here that they have given yes.
Okay. 138.
Huh?
Page 138, Lordship.
Yes.
Hmm.
Yes, you got page 138, and the Lordship will find.
Yeah, same thing is 130.
Yes, 130, yes, same thing. And page 140, your Lordship will see, Miller, these are excerpts, parts of the annexes, not the full document. And it was this full document which I was asking from them. This is Miller, the forensic audit report. They only given some pages of it.
Yes.
Like page 20, page 32 of that report, page 34, but not the entirety of it. The page numbers of the report is mentioned at the right hand side bottom.
Yes, what can be done?
Fine, of course, prayer. Similar prayer for both the
Lordship, may I, Lordship, that is there. Lordship, we have no reply to that also, Lordship, that reply to the show cause notice. But Lordship, may before deciding, if Lordship may kindly consider the SOP, Lordship, followed by the State Bank of India, Lordship. Lordship, this has been framed. এটা তো available আছে তো এটা তোমাদের কাছে
জানতাম না আপনি এটা reply করবেন
আচ্ছা আমার কাছে আর এক্সট্রা কপি ওকে আমি জাস্ট দিচ্ছি আমি তোমাকে দেখতে জাস্ট So, Lordship, this is framed in pursuance to the Lordship Supreme Court judgment passed by the Honorable Supreme Court, Lordship, and in pursuance to the Lordship guidelines framed by the Reserve Bank of India, Lordship. Lordship, may kindly come to the page 4 of the Lordship, this SOP, Lordship.
Yes.
Lordship, from the bottom, Lordship, identification of loan frauds, Lordship. That fraudulent activity in loan accounts may happen through internal or external sources, and such incidents to be considered as trigger of fraud. Lordship, now may Lordship may kindly
You are having that judgment, Rajesh Agrawal, which year? 22.
Then I asked, it is a 2020.
22. Yes. Where it says that the forensic report is not to be supplied.
Lordship, that is the
It is judgment.
Lordship, that is their Lordship, that has not been followed, Lordship. That
Eh?
is their Lordship, that and their
What I propose to do,
Yes, Lordship.
subject to,
Yes.
I am setting aside your fraud order.
Yes.
But I am not setting aside the so-called
So-called,
notice and
yes.
the reply which is
Grateful,
submitted.
Lordship. Grateful.
Correct.
Grateful.
You supply the documents which you asked for
Lordship.
within a period of 2 weeks.
Lordship.
And on receipt of this, he will give the supplementary reply to you.
Yes.
And you consider that supplementary reply and pass appropriate.
Grateful, Lordship. Grateful.
That is
Grateful.
That
Grateful,
is
Lordship.
only.
Grateful.
So I am, because I am setting aside
Yes,
the
Lordship.
document,
That is their Lordship. That I cannot improve, Lordship.
that I am setting aside that.
Grateful, grateful, Lordship.
The petitioner has filed the present test application challenging, praying for, setting aside the impugn order dated 17th October 2025, issued by the respondent number 2, wherein the account of the petitioner declared as fraud. Full stop. The petitioner says that 140 so-called notice 138 says that on 1st April 2025, the bank has issued so-called notice upon the petitioner directing the petitioner to show cause as to why the account of the petitioner shall not be declared as fraud. In the so-called notice, the bank has disclosed some of the pages of the forensic audit report. On receipt of the so-called notice, though the petitioner has submitted reply, but in the reply, the petitioner has categorically stated that the petitioner has not received several documents, including the forensic audit report, and the description of the documents has also been forwarded along with the said reply. You have forwarded this list?
Yes, sir.
Along with the so-called reply?
Yes. It was a part of the proposed reply.
List of the documents are being forwarded along with the so-called reply. Full list. Even after receipt, after receipt the so-called reply, without considering the request made by the petitioner, for supply of the documents, the respondents have issued the impugn order by declaring the
Only one.
account of the petitioner as fraud. Thus,
1 and 2.
Thus, the petitioner has filed the present detail as fraud. The this court considered the so-called notice issued by the bank, so-called notice dated 1st April 2025 issued by the bank, wherein the bank has only disclosed page number 20, 32, 33, 34, 36, 37, and 38 of the forensic audit report, instead of supplying the entire forensic audit report. From the so-called notice, it is admitted that the respondent authorities have not supplied the entire audit report to the petitioner. In the so-called reply, the petitioner has disclosed the list of documents containing 51 documents, but the same has also not been supplied fully. In the case of Rajesh Agrawal versus so reported in so, I will give. The Honorable Supreme Court has categorically held that in the case of State Bank of India versus Rajesh Agrawal, reported in so, the Honorable Supreme Court has categorically held that that the held that the copy of the forensic report is required to be served upon the party so as to enable the party to give appropriate reply to the so-called notice. In the case, admittedly, the forensic report along with the other documents which the petitioner required to the forensic report along with the documents has not been supplied to the petitioner. Considering the above, this court find that the respondent authorities before passing have passed the impugn order dated 17th October 2025 by violating the provisions of audi alteram pertum by not providing the copy of the audit report and the other documents which the petitioner has requested the bank to supply in the so-called reply. Accordingly, the order dated 17th October 2025, wherein the bank has declared the account of the petitioner has fraud, is set aside and quashed. Full stop. The bank is directed to supply the forensic report along with the other documents as mentioned in the list of documents in the so-called reply of the petitioner.
That is annexure P8. I have specified for their convenience.
Documents as mentioned in P8. Now, the authority will say which is the P8. Along with the list of documents, along with the documents which is appearing in the list of documents in the so-called reply
And
of the petitioner.
Because here it is clear. Here I have made this table, which is clear.
Okay, take care.
And I have specifically
To supply the forensic report along with the documents as mentioned in annexure P8 of the present date application within a period of
So can be 4 weeks, Lordship.
4 weeks from the date of receipt of this order. Full stop. On receipt of the all documents include on receipt of the forensic report and the documents, comma, the petitioner shall file a supplementary reply to the so-called notice within a period of 2 weeks, within a period of 3 weeks. Full stop. On receipt of the reply, if any, on receipt of the supplementary reply, if any, filed by the petitioner, comma, the bank shall pass necessary order within a period of 2 weeks thereafter. WP is disposed of.
But in the next matter,
WPO is disposed of. Yes, next.
but in the next matter, I have given the date of the show-cause notice. Similar facts, over here, we had requested them to.
My lord, my senior is under.
Whether so-called the forensic report served.
My lord, I don't have any instructions, my lord.
Absolutely same facts.
My lord, I'm praying for kindly not today.
Not to keep it with.
We had sought for virtual hearing, they had promised, but they didn't send.
Keep it.
My lord, we can come back tomorrow.
Not today.
No.
Tuesday.
Yes.
Next.
Of today's order. And people apply.
No, item number 13.
Yes. Yes.
Please, Your Lordship, I appear on behalf of the private respondents in this matter.
Made a submission on the last occasion.
Lordship, only thing, Lordship. Lordship, being led by Mr. Shuddha Sattva Banerjee in this matter, he has requested for a time. Lordship.
This has been pending for quite some time, my lord. I generally. And in fact, my lord, last occasion, my lord, we made our submission. So, my lord, the order doesn't record because, my lord, they came up, my lord, with the excuse that they were not served with a copy of one of the state's affidavit.
Lordship,
for the matter, my lord, if you recall.
Affidavit filed?
Yes, my lord, affidavit
ready.
filed.
Lordship.
My lord, it's a cancellation of, my lord, registration under, my lord, the apartment ownership act. The completion.
So argued the matter.
Yes, I argued the matter on the last occasion. 1998, my lord, was the completion. There's a 2 points are there, my lord. One, my lord,
there is a limitation period, my lord, in terms of the act and the rules, my lord, for 3 years from the date of publication. There's an absolute bar, you can't have it registered. Second, my lord, it also requires, my lord, under section 10, a complete detailed procedure where, my lord, notice has to be given to, my lord, all the, my lord, apartment owners with regard to, my lord, before it is registered, because, my lord, the form, the section 10 form, my lord, which has to be registered, that actually defines the common area. So all rights, my lord, are determined by, my lord, the registration itself. That is why, my lord, it is such an important, my lord, aspect. Now, my lord, there are disputes between, last occasion, my lord, recall, they said there are disputes between us because we are part land, my lord, owners of some of the flats, and them, my lord, with regard to, my lord, payment of maintenance charges, and civil suits are pending. But that is a separate chapter. This is, my lord, a separate issue altogether. But I wanted to finish.
Yes, Lordship, Mr. Banerjee wishes to address your Lordship. Just makes it not today, Lordship. Could come any day. Keeps it any day, Lordship. Next week, Lordship.
My lord, any day, my lord, then whatever's convenient, because I don't want, my lord, that
Day is the day is the problem. Then it will go to March. If you specific date, then it will go to March. If you take the chance, then it will remain in the list like today. Monday is holiday. No, no, Monday is working. Monday will come. No, Monday will the suit. Tuesday. Not today. Only let the matter remain in the list. Not today.
my lord, take that. Because, my lord, recall when the matter now comes up, my lord, my fear is, my lord, I won't be there, my lord, again. They will be quite happy, my lord, because it will get
Lord,
adjourned.
only one thing, of course, my lord, my learned friends will also note that they themselves have accepted, my lord, that they want to become a member. They've written to the competent authority. Lordship recalls, my lord, in the affidavit which was, my lord, disclosed by the,
ready, my lord,
lord,
let
the
us know
authority.
what you
Lord, I need to point this out.
No, no,
my lord.
let us start.
Okay, come next session.
Grateful.
I'm
Grateful, Lordship.
happy to start, my lord, my argument.
Not today. Not today.
Grateful, Lordship.
And you're asking for,
Mr. Banerjee.
so now you're asking for adjournment, now you wanted to argue.
Yes.
Grateful.
Grateful, Lordship. Grateful.
Item 14. 14 कोई था? Yes.
I am for state lordship. The state what means?
State of West Bengal. Yes.
Open do not ban. Paper number
Have served.
Yes.
Where is that? Only postal receipt. Where is that track? Where is the track?
Well, I'll serve the regional passport officer.
312.
Serve him. But today, the position is this is the latest on the subject.
Yes.
Whatever just now fell from your lordship, it's covered by the subject. This is the latest on the subject. Perhaps your lordship will find it refer to this. Please see paragraph 10. It is 2025 SCC online. 2025 SCC online.
Yes.
Okay, the actual position is not. This was a development agreement resulted in eviction of certain tenants with respect to a building in Jotindra Mohan Avenue, North Calcutta. Because of interstate disputes, the original trustees and everyone, the tenant, unfortunately, she lost the complaint, criminal complaint against me. Now, I have carried the proceedings. Here, the charge sheet is there. At the charge sheet stage, as I have understood, the law laid down by your lordship, that charge sheet means, it comments. The criminal case is pending. It can be declared to be so. Therefore, today the factual position is, the charge sheet has been stated by your lordship court in CRR, official jurisdiction. That interim order is subsistent. Today, two things I can do, subject to what your lordship says. One aspect is, I approach the concern, because passport authorities, have rejected my prayer.
On what ground?
Page 16,
Page
page 17. I'm sorry, I'll just give you a lordship the exact page.
That is the order.
Criminal case is pending.
Yes.
As per the police verification, Bortola, this is the only.
This is the only communication, dated November 19, 2025.
Correct.
This communication, in the light of this document, ultimately your lordship sees. Please see your paragraph 25.
So that's why, see, I will dispose of this, giving liberty to file an application before the London trial court. And trial court is directed to consider your application in terms of this GFR. Correct. And to pass appropriate order once, and if the trial court will grant objection, the passport authority will take appropriate steps in accordance. That.
The RTO fresh notice is required or notice is stopping.
When you come on Tuesday, then I am fixing it. Serve the copy. Because SGI will appear. Serve the copy. Advance copy also served to the SGI. It's appearing. Additional solicitor. The petitioner has filed the present application praying for a direction for renewal of passport. Full stop. Learned counsel for the state is present, but none appears on behalf of the respondent number 1 and none appears on behalf of the respondent number 1. Full stop. According, the petition is directed to serve the note, serve a fresh notice upon the respondent number 1, as well as to the SGI, who is normally appearing on behalf of the regional passport office by tomorrow. Let the matter appear on Tuesday. ASGI, additional solicitor. Tuesday. Yes, sir. Yes. Not today.
16, I am for the state respondents, madam.
Yes.
This is a repetition of 2021, challenging an order passed by the West Bengal Clinical Establishment Act.
What order passed?
Correct.
Regulatory committee disposing of the complaint.
There was a direction on the respondents to file their affidavit. We are for the state, but the respondents, principal respondents, the Clinical Establishment Act, I don't know.
That's why the matter is pending. 2021, when the matter has come up for hearing, you are taking the time. You are wasting the time of the. So, henceforth, I will not list the matter of the original side in the writ matters only once in a month. See, since 3 o'clock, none of the matters is coming up for hearing.
We wait some time. Kindly makes an order to that date.
What?
Fixes a date and.
But affidavit, who is appearing for the clinic authority?
I saw from the order sheet.
Clinical establishment, you are appearing?
Yes, my lord, I did.
So, have you filed the affidavit?
My lord, subject to correction, my lord.
5 years down.
My lord, whatever documents were relied upon us, you have adjudicated that and passed the order for that effect. You do not have any other thing.
So you will not use the affidavit. So I will record and I will fix your hearing. Learned counsel for the respondent number 2. Who is 3? Private respondent, who is 3? consul for the respondent number 2 submit that they will not use any affidavit. You will also not use any affidavit.
No.
Consul for number 1 and 2 submit that they will not use any affidavit. And they will argue the matter on the basis of the documents available on record. In view of the submission made by the consul for the respondents, chance to file affidavit is closed. Full stop. Please the matter on 5th of February 2025 for hearing. Next.
Item number 70.
Item 17, Lordship.
Yes.
Kindly make it not today, Lordship.
You are appearing for?
Respondent.
Huh?
Respondent.
Respondent. On last occasion also you have taken time. As for the prayer of the consul for the respondent case at John. Who is for the petitioner? I don't know, sir. Yes, 17. You are for the petitioner? Yes, start. You are competent before this court. Yes. Not today. Which scheme? Incentive scheme? Yes. Amendment. You filed it. So who is for the other side? Have you served? But nobody is here. The petitioner has filed GA1 of 2025 praying for amendment in the writ application. Full stop. None appears on behalf of the respondent. For the interest of this case is adjourned. Let the matter appear on 6th of February 2026. It is made clear that on the date fixed, if the respondents fail to appear and file affidavit in opposition to GA1 of 2025, the matter will be taken up for hearing without the affidavit. Next. Not today. Next. जो not today बोला ना उसको next month में रख. Next.
21.
Not filed. So I am closing the chance to file affidavit in opposition. You argue the matter. No problem. I will allow you to argue the matter.
Item number 21, I am for the petitioner.
Have you filed the affidavit?
I'm for the petition.
Petitioner. Yes. No affidavit. Petitioner has filed the affidavit in reply after serving the copy, but no affidavit in opposition in record.
The petition that was dated filed, that was
Not filed on the respondent director placed the affidavit in opposition on record, but nobody is there. So what can be done? What is the matter?
whereby a deal was made. I'm being led by Mr. Kurdipa. I'm starting.
No, but other side is not there. Not today. Next. None appears. March list. List in the combined monthly list of March.
February.
Which you are this matter? 21 not today. 22 March. Next.
My lord, I am appearing in person in 23.
Yes.
I am petitioner. Bank is supposed to file the affidavit by the order dated 27 June 23. In last 30 months, they have not filed their opposition. and in last two occasions they did not appear. So please fix the time for hearing sometime in late February or first week of March.
You are appearing for?
In person, in petition for
Petitioner.
Srimati Fashion Private Limited as a director.
As the petition is appearing in person and prays for fixing the matter in the month of February 2026. In view of the submission made by the council for in view of the submission made by the petitioner in person, let the matter appear on 26th of February.
Okay, thanks, my lord.
Next.
24 I appear for the petition. The owner of the site in question was acquired by the Department, Land Acquisition Department under the West Bengal Premises Distribution and Control Temporary Provisions Act, in the year 1973. And thereafter, it has lost its force. We moved before it lost its force after in the year 1993. Two flags initially was taken up by the authority, and in terms of the direction passed by your lordship court, one flag has been given. So far, the other flag concerned position was not given, and that is why, we have again by filing a press come before your lordship, so that you can the direction may be given, to hand over the.
Who is for the respondent?
State authority, they appeared. Last operation for us, they did not appear.
None appears on behalf of the respondent. 21st November. Yes. Where is the earlier order?
Yes. Page 76, your lordship.
70, 69, 70.
Your lordship, page 67. Of the affidavit in opposition, my lord, filed by the state.
No, your writ petition, page 71, that's what is the order.
Before that, your lordship, they have annexed, my lord.
Affidavit in opposition?
That is why I am referring.
Affidavit in opposition?
Opposition.
I don't think affidavit in opposition is there. Hey. No, affidavit is opposition.
Sure. They have not filed it. But your lordship, they kindly peruse my lord the page 38 of it. And they have filed it.
Yes, your reply is here.
Yes.
But affidavit in opposition is not.
And the order of requisition, your lordship will get it, my lord, writ petition page 38, and it's a P2 first. Your lordship kindly peruse. May I hand up the oppositions used by the state?
Yes. Yes, page 38.
Page 38. And
Requisition of premises 67, Benteg Estate.
And notice under section 5A of the West Bengal Premises Distribution and Control Temporary Provisions Act as amended by the West Bengal Act of 1963. And whereas the premises in Schedule 3 manner was taken up, now your lordship kindly pay no manner. And what is the provisions of law? Your lordship kindly pay. Your lordship kindly peruse section 3.
Yes.
Whenever it appears to the state government that any premises in any locality are needed or are likely to be needed for any public purpose, it may by order in writing requisition such premises either with or without any or all of the furniture, if any, in such premises, provided that no premises exclusively used for the purpose of religious worship shall be requisitioned under this section. An order under subsection 1 shall be served in such a manner as may be prescribed in the landlord and prescribed on the landlord, and where it relates to the premises let out to a tenant also on such tenant. Now your lordship kindly peruse section 10A, duration of the requisition.
Yes.
For the removal of doubts, it is hereby declared that an order under subsection 1 of section 3 shall be remain valid and operative, and the state government or any person in occupation of any premises requisitioned under the order shall continue to remain portion thereof so long as the public purpose exists. Now, my lord, 10B, compulsorily released from acquisition. Notwithstanding anything contained in section 10 or section 10A, the state government shall release the requisition any property requisition or deemed to be requisitioned under this act on or before expiry period of 25 years from the date of such requisition. That time has
Government shall release from requisition of any property or deemed to be requisition under the on or before expiry of period of 25 years.
73.
70.
Now, my lord, provided on proviso
Yes.
also there
Benefit of this shall not be available.
Shall not be available until after the expiry of period 5 years, date of coming into force of the West Bengal Control Temporary Provisions Act 1986. Has your lordship got it, my lord? Now your lordship kindly peruse the order of once, my lord, the order of requisition. Page 38, Annexure P2.
Yes.
73.
It was requisition 73.
Yes.
Now your lordship kindly peruse page, my lord, 39. Now your lordship, my lord, we have handed over, I have handed over your lordship, my lord, the affidavit in opposition. There your lordship will get the full orders. That is at page 67 of the affidavit in opposition. Yes. And we moved before your lordship's court, and this was the order passed, my lord, February 6, 1993.
Yes.
This is an application under Article 226 of the Constitution of India, India praying for the order that read or in the nature of mandamus commanding the respondent to court the requisitions number 5 in premises number 67 Benting Street, Calcutta, however vacant and peaceful version of the said premises to petitioner. A read in the nature of such order. My lord, this is not required for the purpose. Now, my lord, your lordship kindly skip over page 68. The ordering portion starts, my lord. The case of the petitioner, has your lordship got it, my lord? The case of the petitioner is that on or about 26th of August 55, the petitioner purchased a tenanted house situated at 67 Benting Street and sale deed of the said premises is annexed to the petition and marked with the letter A. The vendors of the premises addressed a letter dated 26th August 1955 directing all the occupants of the said premises to pay their rent to the petitioners. The respondent number 3 is occupying 2 flats. One in respect of flat number 4 on the first floor, paying a sum of 94 per month. Respondent, my lord, the state here.
Yes.
And the other flat in flat number 5. And now we are concerned with the flat number 5. On the second floor, paying a monthly rent of 84. The monthly rates and taxes were paid by the petitioners, the owners, the landlord. The further case of the petition is that by an order dated Land Acquisition Collector, Calcutta, the respondent number 3, suit number 5, situated on the second floor of the premises, Benting Street, Kolkata, measuring about 900 square feet, first floor consisting of 3 rooms, 1 bath, privy, 1 kitchen, 1 and 2 balconies were requisitioned, and possession thereof was taken. Pursuant to the said requisition, the said requisition was made under subsection 1 of section 3 of the said West Bengal Premises Requisition Control Temporary Act 47, which I have placed before you just now. The petitioner further states that since 48, the said property has been kept under acquisition on the ground of public premises, public purpose. It is submitted by the learned advocate for the petitioner that the said provisions was made for a temporary purpose. It is further submitted that the continuance of the requisition is an unreasonable restriction on the petitioner's right under Article 300A and 21 of the Constitution of India. It is further submitted that the respondents have kept the said flat under requisition for such a long period, though the purpose for which the premises of requisition has ceased to exist, and no public purpose now exists for continuance of the requisition. It is further submitted that the respondent cannot keep the said suit number 5 under requisition for the indefinite for an indefinite period of time. And on the this portion is not legible.
Not legible. Yes,
And
next.
keep over
Yes.
3-4 lines. Thereafter, the relevant file was produced before the court on 30th June 1992, being file number such and such, with suit number 5 of premises number 67 Benting Street, Calcutta, and said that file contained paper from 79, but the respondent are in occupation of said that before 55. It is submitted by the learned advocate appearing for the petitioners that the petitioners are the purchasers. Oh, my legible copy was also in the next page.
Are the landlords.
Landlords, and as a result, are unable to produce note for of requisition, which was received by the previous landlord. Several dates are taken on behalf of the respondent, but the respondent is unable to trace out the file in respect of the suit number 5. The learned advocate for the respondents could not produce a single scrap of paper to show that government took any tenancy in respect of the suit number 5, nor could produce a tenancy agreement, nor could give any suitable explanation to where the file was lying. On Madhavendra Vishwas, land acquisition collector, has affirmed an affidavit, and the said affidavit, it has been stated that there was no requisition on the said suit number 5 on the second floor of the premises number 67 Benting Street, Calcutta. It has also not been stated in the said affidavit that the said suit number 5 was the subject matter of a tenancy. However, at the time of argument, it was admitted by the learned advocate for the respondents that the respondent is now in occupation of said suit number 5. It is submitted by the learned advocate for the petitioner that the suit number 4 and 5 are being occupied by the respondent from 1948, and the occupation charges are paid at the rate of rupees 83 so far as the flat number 5 is concerned, and at the rate of rupees 94 so far as the flat number 4 is concerned, which amount were assessed by the land acquisition collector. Both the said flats have similar accommodation, and the said amount payable as monthly charges were never enhanced since 1948. From the facts and circumstances stated in the affidavit, and also from the facts stated herein, it is clear that the respondents are in occupation of the suit number 4.
What was the conclusion?
Conclusion, yes.
Considering the facts and circumstances.
Hand over the ordering portion, considering page 75.
Yes.
Considering
respondent, there will be an order of
submission made by the learned advocate for the respondent. There will be an order in terms of pair A and B of the petition. The respondent further direct vacate and render peaceful possession of the suit number 5, situated on the second floor of the premises number 67 Benting Street by 30th April 93 positively, and we pay area charges which are legally payable by the respondent to the petitioner. This was the order. Then they did not comply. Then my lord, contempt application filed. Contempt order was passed. They did not comply the order passed in contempt application. My lord, they preferred appeal. My lord, the contempt was pending. Appeal was pending 2014 till 2014, and ultimately it was dismissed. But thereafter, my lord, there was dispute between the partners of this my lord, petitioner's firm and the person who was dealing. He died. For few years, my lord, they could not take any steps. Subsequently, my lord, the petitioners have filed this application before your lordship, my lord, to implement the order passed by this honorable court, my lord, so that we can get the petitioner can get back the flat return
After 30 years.
well, because my lord, initially admitted position is that they had handed, it was not handed over. We are out of possession. But what happened, my lord, your lordship kindly peruse one document I am showing. Thereafter, my lord, the writ petition, page, my lord, page 80 P12.
80.
Page 80 P12. And this order was passed. We are pursuing, my lord, to get the flat possession of the flat back. But in the meantime, an order was passed by the Joint Commissioner of Police, Kolkata, and on 4th January 23. My lord, the writ petitioner was filed internally are praying, my lord, the mandamus cancellation.
No, what is the 80? Page 80, what is the page 80?
80, has your lordship got it, man?
Yes.
80, my lord, license under section 4 of the West Bengal Government Premises Regulation Occupancy Act 84 is hereby granted to one Mr. Rahul Amin,
SI of
SB, deputed to CD, Kolkata Police, for occupancy of the government premises number such and such. And disposal of Kolkata Police until order a change of cancellation of his occupancy. The present allotted quarter
until order
shall not be eligible to draw any HRA during the period of occupancy of the quarter. Sri and Srimati Rahul Amin Ali Shah is also not entitled to occupy any government accommodation any other place during the period.
Correct.
And after filing this contempt, after filing this petition before the lordship, they have withdrawn this notice. That is
where is the withdrawn?
That your lordship will get it from the order sheet. Your lordship kindly produce, my lord, the order dated 12th July 23.
Yes, I got it.
The learned counsel for the petitioner contends that
in support of condition and appearing for the services, cancelling the license such so far as the challenge of the order dated 4th of consent become infectious for further hearing a petition on the other conditions issued. So
thereafter, my lord, the matter was taken up for hearing by your lordship's court, my lord. The last order was effective order was 14th July 23. And may I place this order? This is very important. The learned counsel for the has your lordship got it?
Yes.
The learned counsel for the petitioner submit that originally there was an order directing the respondent authorities to hand over the vacant and peaceful possession of the premises in dispute to the petitioner. The respondent did not comply with the same. Subsequently, another writ petition was filed, which was also culminated in an order by the learned single judge reiterating the previous order directing the respondent to vacate the premises, possession, to vacate the possession. The subsequent order was challenged in the appeal preferred against the same. The appellate court allowed the appeal to the extent that writ petition was held not maintainable in view of the pendency of the contempt application, the context of violation of the earlier order of eviction passed in the learned single judge. Well, I have submitted before lordship and the contempt was pending. Now, subsequently, the petitioner alleges the petitioner ran from pillar to post, and ultimately the petitioner wrote representation to the respondent authorities to vacate the premises, which was not implemented by the respondents. Learned counsel for the respondent number 4 submits that the respondent number 4 has been occupation of the property independent of acquisition on requisition of the property in the capacity of tenants is 48. Now, after the second writ petition, they have come content before your lordship that they have independent right. Now, your lordship, peruse. It is submitted that nothing in the previous order takes note of such tenancy of the respondent to substantiate, which there are several documents in custody of the respondent. Number 4. Learned counsel for the petitioner submits that it is a well settled position that a phase which lies even for executing the previous order passed by a writ court, and that is why I have come before the lordship's court. There cannot be any doubt that even the Civil Procedure Code under section 36 of the same provides that provisions of Code of Civil Procedure relating to the execution of the decree shall, so far as applicable, be deemed to apply to the execution of orders. Borrowing such principle to the writ jurisdiction in the absence of any specific corresponding rule akin to section 36 of the Code of Civil Procedure, the writ court also has power to execute an order passed by a previous writ court. Hence, the proposition mooted by the learned counsel for the petitioner cannot be denied. However, if that be so, the provisions of Order 21 of the Code of Civil Procedure, which pertains to execution of decree, shall also apply to in case of execution of an order. In this respect, we can also take a cue from section 141 of the Code of Civil Procedure. Keeping such aspect of the matter in view, the provisions of Order 21 Rule 97-101 of the Code of Civil Procedure, to the extent that its principles are applicable to the writ court, also apply to the present case. Hence, since the respondent number 4 has raises claim regarding its alleged independent right, my lord has many cases, if independent right is claimed, my lord, that will be independent right, title, interest with regard to the disputed property, which is not enough, which is not through the judgment debtor. A right has to be given to the respondent number 4 to canvass such grievances within the contemplation of Order 20 Rule 97-101 of the Code of Civil Procedure. In order to obviate unnecessary delay, the respondent number 4 shall incorporate all such pleadings in its affidavit in opposition to the present petition. Accordingly, the respondents are directed to file their respective affidavit. And they have filed opposition. May I?
Who has filed the affidavit? 4 has filed the affidavit.
They have filed the opposition. In the opposition, they have reply file.
Yes.
Your Lordship, in this event, Your Lordship, the opposition has been filed. But since it is a changed brief and I have been newly assigned, the reply is not with me. Your Lordship,
You are having the original affidavit in opposition, you are
opposition. But the reply.
original.
Yes, no, Your Lordship, that has perhaps been submitted before the court.
That is not here.
That is not here. Your Lordship, since this is a changed brief, I only have a copy of the opposition. Your Lordship, may I be permitted to reaffirm this affidavit in opposition?
No, already they have filed the reply. How you can reaffirm? Okay.
The same
Give the
opposition, I
copy.
shall give a copy.
No problem. Give the copy. It will be taken on record. No problem.
Grateful, Your Lordship.
You already filed the reply.
Your Lordship,
So, what is your stand?
I request my learned.
What is your stand?
Your Lordship, it has been specifically stated in the affidavit, Your Lordship, that it is an absolutely independent right.
How the independent right will accrue?
I shall indicate through the documents annexed in the opposition, Your Lordship.
How the independent right will accrue?
Your Lordship, I need to refer to certain documents and pages in the opposition, Your Lordship. May I provide a copy to the court, and a copy of the reply also may be served upon me, so that I may be able to assist the court properly.
Affidavit in reply.
To their independent right. Affidavit in reply pasted. This is admission on the part of the authority. With reference to your letter date such and such of the above, I would inform you that suit in question, which is rent has been claimed, is neither requisition nor hired by the Kolkata police, and the rent for the same is not payable by the Kolkata police. They, my lord,
Your Lordship, the difficulty is the
one land acquisition, Kolkata police, land was acquired by the land acquisition department. Now the Kolkata police is independently, they have submitted your lordship that independent right of tenancy. And this is the.
So what is there in the flat?
No right, my lord.
Who is in the flat now?
They have put padlock. We are not able to use the padlock. And that since this matter we are unable to use the padlock, we are unable to enjoy the use of it. But we cannot forcibly open it unless court, since we have approached the court, my lord, what court will decide will go direct, my lord.
Yes, what is your right?
Your Lordship, I shall, Your Lordship,
What
kindly
right?
gives an opportunity. I shall provide a copy of the opposition. I was not aware that the original opposition has not been provided with the court, Your Lordship. I shall, and Your Lordship will kindly request my
Counsel for the
learned senior
petitioner
to
has
provide a
completed
copy
his
of the
argument.
reply. একটা reply এর copy
Counsel
টা
for
নাও
the
তো।
respondent is directed, it is found that that original affidavit in opposition is not on record, comma, the petition is directed, the respondent is directed to supply the copy of the affidavit in opposition on the next date fix. Full stop. Counsel for the respondent prays for time. According cases adjourned, let the matter appear on 28th January.
Well, any my lord, especially fixed or item number or any time my lord may fix, my lord.
Within 5 minutes.
Yes.
Your Lordship will kindly direct the
I
my
know,
land.
there is no court lie land.
Gratefully, Your
Rises item number 145. They're mentioning upon
Expired.
2 days expired.
My lord, I have one prayer. My lord, it's being extended for some time now. My lord, I was praying, my lord, if it can be fixed any date or time one day so that my lord, this application can be disposed of, or if my lord
For the other side.
But they are there.
They filed the affidavit.
Yes, everything is complete. Everything is
Affidavit
complete.
it is suit.
Suit, my lord.
So hearing of GA1.
Yes, GA1. GA1.
What about the suit?
My lord, suit, my lord, GA, my lord, my lord,
Suit is not here. It is on the
my lord, not on the my lord, the application
suit
is
तो नहीं है ना, special
both.
भी है.
Yes, yes. My lord, unfortunately, both are here, my lord, suit and application.
Though the matter is listed as item number 142.
145. My lord, only one prayer, my lord.
Police of counsel for the petition has mentioned the matter after notice to the respondents and submit that and prays for extension of the interim order. He further submits that the respondents already filed the affidavit in opposition and you already filed the reply.
Complete.
And the petitioner also filed the reply. Police of in view of the above, give the February cover date March.
At any date and time may fix.
Let the matter appear on 6th of March at 3 p.m. Interim order is extended till 10th of March 2026 or until further.
Milad, to this Milad, if Milad the interim order can be confirmed, if Milad thinks that it's to be vacated.
Come on that.
Very well. Milad.
10th March.
Milad, one more thing, Milad, one more matter has been assigned before your lordship, Milad. Milad, this is the list of assignment, Milad, just published.
How this has been assigned? This is not a commercial court.
No, it's being released by two courts, Milad. There is a Milad, Milad had the sale matter, clause 4950, arbitration. Milad, শুক্রবার দিন this is also mentioning upon notice.
So what do you want?
Milad, the interim order is expiring on 30th January, but may it be listed, Milad, so that it remains in list. Or Milad keeps it any day for
29 correct to be mentioned.
Very 29. Order লাগবে